Lordship on 4/4/2025. Thereafter, they filed one by one, my lord. There is an order by your lordship. All the matters shall be, all the matters shall be clubbed together. Kindly have it on Monday, my lord. Or, I moved a memo.
Tomorrow.
Please, my lord, tomorrow.
You want it at 2:30?
2:30
It is
also.
anyway there.
I have served copy on vacating stay.
ಅದೇನ್ ತೀರ್ಮಾನ ಮಾಡೋಣ ಬಂದ್ಬಿಡಿ.
Please.
ಅದೇ ಮಸ್ಜಿದ್ ತಾನೆ.
Out ಸಮಯ ಅದೇ. 2:30 today, my lord.
ಅದೇ which I interpreted 185, 187.
Yes, yes. Same man.
Your lordship may take it tomorrow.
2:30 you can come.
I have to go through the file.
Hey, what is this? Balan sir and they are telling go through the file. All right. You want it tomorrow? We'll take it tomorrow.
Please take it.
Tomorrow, I think ಬೆಳಗ್ಗೆ bench ಇರುತ್ತೆ ಮಧ್ಯಾಹ್ನ.
Please, tomorrow by 2.
Yes.
Your lordship would be here in Bangalore bench?
Yes, here only.
One matter, parted. Tomorrow, it does not come. Tomorrow kind.
ಅಲ್ಲ successive writ ಅಥವಾ
It is first time.
first time.
Stayed, my lords. My lords has covered by judgment of my lords.
My lord, this is a successive petition. My lord.
Successive ಎಲ್ಲ ನಾಳೆ ಕೊಟ್ಬಿಡಿ.
Lords.
ಬೇಡವಾ ನಾಳೆ 2:30 ಗೆ ಬೇಕಾ?
ನಾಳೆ ಇಲ್ಲ.
2:30 ಗೆ ಬೇಕಾ?
ಇಲ್ಲ ನಾಳೆ. Much obliged.
My lordship, regarding to serial number 15, I am filing a memo for withdrawal, my lordship.
Thank you, madam. Yes.
My lords, it is GMCPC.
Which one? 1.15 or what?
15, lordship, 15.
My lords, it is GMCPC order.
One moment. Giri Kumar. 15, yes. Disposed as withdrawn. Tell
My
me.
lords, it is a GMCPC matter.
All right.
It has been, the petition has been filed misinterpreting your lordship's order.
Oh.
It is for the appointment of a court commissioner, my lords. The dispute was whether a Tahsildar had to be appointed.
ಅಯ್ಯೋ ಅದ ಕೊಡಿ. ಇಬ್ರು ಸೇರಿ ಯಾರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ಬಿಡಿ. We'll close that.
My lords, there's one more matter, RFA, my lord.
In the first week once I come here.
Great.
Come here only for 2 days, today and tomorrow.
Parted matter, exoneration in departmental inquiry, in DA case.
We'll see, ಕೊಡಿ. Stay ಇಲ್ವಾ?
No, stay.
With my lord's kind permission, may I make a mention? My lords, ನಿನ್ನೆ ಅದು
Tell me, yes.
the Jaggery unit Brahmanand Sagar.
ಬಂದಿಲ್ವಾ?
Illa, it is not listed before my lords today here, but it is listed in Dharwad. Because the inspection is ordered for tomorrow, my lords.
ಇಲ್ಲಲ್ಲ ಅಲ್ಲೇ ಬಂದಿರ್ಬೇಕು ಅನಂತ್ ಹೆಗಡೆ ಅವರು. Justice Anant Hegde. Just check the list of Justice Anant Hegde.
No, it has come up before Justice Anant Hegde in serial number 39.
Yes.
But I had requested that my lords keep the direction for inspection in abeyance.
That see, if I have sitting here, if that had to be done, the Honorable Chief Justice's order would be required. Because the order is already to be posted there. You make a mention before His Lordship Justice Anant Hegde.
Agilla andre, I will again make a mention.
Madam.
My lords, I'm waiting for the CCR matter, my lords.
I know, because unless it gets listed, I can't adjourn it. So
Please, my lords. Therefore, please, my lords.
What are the dates? That's why I asked.
My lords, may I request for any date between January 15th and 17th, my lords? 15th.
We'll take it 15th to 17th.
My lords,
Please.
my lords, I think the 15th is a holiday, my lords. I think the court calendar for next year has come and the 15th is a holiday.
Then if 15th is a holiday, then
16th, my lords.
is it, madam? 15th. So if 15th, then 16th, 17th.
Please, ma'am.
We'll keep it on 16th, madam.
Please, my lords. 16th is a Friday. Please, my lords.
16th is also holiday.
Oh, okay. Oh, then 16th.
Then, my lords, may I request
19th.
for my lords, may I request for January 29th to 31st then?
Yes, Petitions Council.
My lords, we are fine, my lords.
Yes. The learned council, CGC, senior CGC. What's the madam?
My lords, here I'm appearing as a counsel for CCI, my lords.
The learned counsel, Nayantara BG, representing the Competition Commission of India, submits that the Attorney General is indisposed today to appear and make his submissions either online or physically. In that light, list this matter on, in that light, as a date of consensus, list this matter on 29th January 2026. Yes. Interim orders of whatever nature subsisting as on today shall continue till the next date of hearing.
I'm
Much
grateful.
obliged, my lords.
Yes.
Order still number 2.
One matter, my lord, tomorrow,
Could he
41, my lord.
give it, sir? ನಾಳೆಗೆ ಬೇಕಾ?
ನಾಳೆ.
ಇವತ್ತಿಂದ
ಹೌದು.
ಕರೆದು ಬಿಡ್ತೀನಿ 5 ನಿಮಿಷ.
Still number 2.
The petition. There is a office objection, lordship. In the order sheet, there is a mistake. The order sheet, there is a mistake in the date, lordship. Office has raised objection to that.
Forget about it. Come on, merits, man.
Lordship, settlement talks are going on, lordship. We will report.
Settlement talks, sir.
Yes, lordship.
354.
Yes, lordship. Case and counter case, lordship.
Which is the counter case?
At page number 110, lordship.
Other stay idea.
Yes, lordship.
Dates are different. Dates are different.
You are accused number 1 and 2.
Yes, lordship.
Correct. Come to page 18. The only problem is last 4 lines. In civil suit pending idea?
ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Allah, between the same parties.
ಇದೆ ಸ್ವಾಮಿ, they have filed.
Yes, Jagdish. It appears to be the petition. What's your name?
Tamilarasi.
Huh?
Tamilarasi.
Heard the learned counsel Tamilarasi appearing for the petitioner. The petitioners are accused 1 and 2. Are charged of the offences punishable under section 341, 323, 354 and 504 of the IPC. A perusal at the summary of the charge sheet as obtaining in column number 18 would not indicate the ingredients of those offences being driven as the offences or the complaint or the summary of the charge sheet appears to be a ploy of wreaking vengeance for the civil proceedings pending before the competent civil court between the parties. The learned counsel further submits that the issue is of a case and counter case where the petitioners had registered a crime against the complainants, in which this court has granted an interim order of stay of further proceedings and the said interim order is subsisting.
No, lordship. They are not challenged that.
Then you said stay ಕೊಟ್ಟಿದ್ದಾರೆ. All right, ಅದು ಬೇಡ ಬಿಡಿ. So and so. In the light of the ingredients of the offense not being made out till the appearance of the complainant. Appear ಆಗಿದ್ರಾ ಮೇಡಮ್?
Appear ಆಗಿದೆ.
ಆಗಿದ್ದಾರಾ? ಸರ್ವ್ ಆಗಿದೆ ನೋಡಿ.
Serve ಆಗಿದೆ.
ಯಾರು ಪದ್ಮಾವತಿ ಅಂತ?
Counsel ಇದೆ.
So therefore, there shall be an interim order of stay of further proceedings in CC so and so till the next date of hearing. List the matter on 2023. List the matter on 5th January. ಇಲ್ಲ ಇದೆಯಾ? List the matter on 5th January for admission. Naveed, stay idea. Madam, 1 ನಿಮಿಷ. Where is the stay application ಇದೆಯಾ? Stay application ಇದೆಯಾ?
Number 3.
ಇದೆ.
Lords, this petition was disposed of, Lords, as if the charges are framed. Lords, I have gone through the ordership, no charges framed, Lords.
Charges are not framed.
Not framed, Lords.
Offense same.
Lords, it is under pollution control board, Lords. Masjid matter, Lords. Masjid matter, Lords, just because the decibel is more, Lords, more.
Reduce the decibel.
I have reduced, Lords. Long back I have reduced. Lords.
The crime is registered because of the decibels?
Yes, Lords.
Where is the report?
Lords, kindly see, Lords, the report. Lords, page number 43.
40?
43, Lords.
Yeah, Azan.
Lords, yes, my lord, Azan, lords.
Daytime 75. What is the minimum decibel?
Plus minimum decibel, my lords, kindly see my lords, page 44. Plus for, my lords, they have not mentioned residential zone, my lords, decibel 55, my lords. Night time it is 45, daytime it is 55.
But it's quite high.
Lord, this was the prescribed, my lords. No, so ours is little more, my lords.
ಅದನ್ನೇ more ಅಂತ ಹೇಳಿರೋದು ಇಲ್ಲಿ. Reduce it a little. So
reduce ಮಾಡಿದ್ದೀನಿ. I have reduced. Immediately I have reduced.
The petitioners are before this court. Calling, ಇದು dispose ಮಾಡಿದ್ನ ಮುಂಚೆ?
Disposed as if it is framed charges are.
The matter stood disposed on 19th November 2024 on this score that charges had already been framed in the case at hand. The learned counsel for the petitioner submits that charges are not yet framed and has produced the order sheet to that effect, a perusal of which indicates that the charges are indeed. The petitioners generating noise pollution at the time of Azan in the morning in the masjid nearby to the in the nearby place in the vicinity of JC Nagar residence. The Pollution Control Board is said to have inspected the property and found that the decibel level was a little higher than what was permissible in law. The learned counsel for the petitioner submits that moment the inspection report came about, the noise, the decibel levels have been brought down by the petitioners. In the light of the said statement, as also the offence relating only to the aforesaid decibel level, further proceedings in CC 13917 of 2021 shall remain stayed. Learned HCG, learned additional SPP, being Jagdish is directed to accept notice for the respondent, petitioner to serve set of papers upon the aforesaid counsel forthwith.
Fresh copy. I will give 8 numbers, oblate notes.
Yes.
Number 4.
Oblate notes.
That serial number 4 and 8 are connected matters.
Yes, sir.
This matter is pertain to the 2006 PGT entrance exam scam, my lords.
Yes, Prasanna Kumar, what happened?
Some allergy may not react.
Oh, all right.
And in the fourth matter,
I'm placing on list of events.
Madam.
Yes, I'm placing the list of events, my lords. In all, my lords, the 20.
I'll first on the order ಬರ್ಕೊಂಡು ಒಂದೇ ನಿಮಿಷ.
Yes, ma'am.
Previous matter ಅಲ್ಲಿ the petitioner has filed an application or the order on I-1 of 2024 ಅಂತ ಮಾಡಿ the petitioner has filed an application I-1 of 2024 seeking recall of the order dated so and so. The order, the subject petition had been disposed on the score that the charges had been framed before the concerned court, and in the light of the charges being framed, the petition under section 482 of the CRPC would not be entertainable. The learned counsel has appended the order sheet to the application, which demonstrates that the charges had not been framed and the matter was a matter at the stage of framing of charges. In that light, due to the error that had crept in while disposing the petition, the application stands allowed. The order stands recalled. ಆಮೇಲೆ ಅದು order ಮಾಡಿ. Yes.
prepared a chart note for both the cases note as I had submitted earlier. And your lordship's earlier order note in the case of Mr. Girish, which one senior friend note has given as serial number 3 in the second page. That note has been affirmed by the apex court.
ಏನು ಸುನಿಲ್ ನಿಮಗೆ ಗೊತ್ತಿಲ್ವಾ?
I'm giving another. No, I'm go to no.
ಸುನಿಲ್ ನೋಡಿಲ್ಲ ಅಂದ್ರೆ
ಇದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಸುನಿಲ್. I'm giving other orders, my lords.
ಎಲ್ಲ ಕನ್ಫರ್ಮ್ ಆಗಿದೆಯಾ?
No, my lords. Some other 3 petitions SLPs are still pending before the honorable
apex court.
25 124 ಗೆ ಒಂದು ಕನ್ಫರ್ಮ್ ಆಗಿದೆ.
Kindly see my list of events, my lords.
Girish B. ನಿಮಿಷ ಗಿರೀಶ್ ಬಿ ಇದು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ನ
ನಾವು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರಿ.
ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ ಕನ್ಫರ್ಮ್ ಆಗಿದೆ. ಅಲೋ ಆಗಿದ್ದು ಏನಾಗಿದೆ?
ಅಲೋ ಆಗಿದ್ದು ಮೋಸ್ಟ್ಲಿ ಕನ್ಫರ್ಮ್ ಆದಂಗೆ ಕಾಣುತ್ತೆ. ಯಾವ್ದು ಏನು
ಅಲೋ ಆಗಿರೋದು ಸ್ಟಿಲ್ ಪೆಂಡಿಂಗ್. ದಟ್ಸ್ ವೈ my lords have given list of events.
ಈಗ
we are not on the point which is allo.
Correct. You are the allegation against him is akin to Girish or what?
It is akin to Girish. That's why I have given the chart.
No, my lords.
ಆ ಚಾರ್ಟ್ ಕೊಟ್ಬಿಟ್ಟಿದೆ ಅದಕ್ಕೆ. ಸೇಮ್ ವೇ
ನಿಮ್ ಚಾರ್ಟ್ ಅಲ್ಲ ಸರ್,
ನಿಮ್ ಚಾರ್ಟ್ ಹೇಳಿ.
ಅಲ್ಲ, ಅದು ಎವಿಡೆನ್ಸ್ ಚಾರ್ಟ್, ಅದು ನಂದಲ್ಲ ಅದು.
Come on.
Kindly see the list of events, my lords. In some of the, in all my lords, there are 20 accused persons. Out of 20, my lords, 5 accused persons have been discharged from the dishonorable court as well as the honorable trial court. Some of the my lords, the accused number 2, which he is facing this more serious allegation than this petitioners, my lords.
He's been discharged.
His petition came to be dismissed before this honorable court, my lords. Now, my lords, his petition is pending before the honorable apex court. Now it is pending for consideration, my lords.
For what? ನಾನು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದೀನಿ.
How dismiss ಮಾಡಿದ my lords? He approached the honorable apex court.
Correct.
Then it is pending for consideration.
All right.
Which, my lords, this coordinate bench of this honorable court had discharged one of the accused. His petition came to be challenged by the CBI, my lords. It is pending before the honorable apex court for consideration. So, my lords, my humble submission, my lords, when the matters with respect to the similar allegations are pending before the apex court, it's not proper on my part to make my submissions.
It's proper on my part, sir. Don't worry at all. You don't worry about your part. It's proper on my part to pass orders.
I am facing the.
Your part is only to make submissions. Kudi.
I am facing the orders of the honorable apex court. It's
pending. ತಗೋಬಾರದು ಅಂತ ಹೇಳಿದಾರೆ.
ಇಲ್ಲ, no, my lord.
They have voluntarily appeared and taken notice.
Knowledge of this honorable court. That's it, my lord.
They voluntarily appeared and taken notice. I think in Shantanu Saukurala.
ಶಾಂತನ ಸಾವು. ಇದು ಡಿಸ್ಮಿಸ್
ಮಾಡಲ್ಲ ಸರ್.
ಅಲ್ಲ, ಇದು ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಆರ್ಡರ್ ಬೇಕಿದೆ.
Yes, my lord. That's even I have not placed the entire charge sheet before this honorable court.
VI Hukeri have dismissed.
Yes, the 2 connected petitions your lordship has dismissed.
Come on, merit, sir.
My lords, I have not placed the entire charge. Even the last date of hearing, lordship has directed me to place the polygraph test and all, my lords.
Don't worry, sir.
Because of
ಈಗ ಏನಿದೆ ನಿಮ್ಮ ಮೇಲೆ ಹೇಳಿ. ಎವಿಡೆನ್ಸ್ ಪ್ರಕಾರ ಏನಿದೆ ಹೇಳಿ. You are what accused? Accused number 10.
Serial number 4 is, my lords, accused number 10.
10.
In serial number 8, I am accused number 15, my lords.
All right. 10 and 15 are before the court. Tell me, sir.
Let's I will place entire my materials.
ಹೇಳಿ ಸರ್, ಪರವಾಗಿಲ್ಲ.
ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ ಅವರು ಆಗ್ಲೇ.
ಎಲ್ಲ ಇದೆ. ನಮಗೆ ತೀರ್ಮಾನ ಮಾಡಕ್ಕೆ ಏನ್ ಬೇಕು ಅದೆಲ್ಲ ಇದೆ ಹೇಳಿ. ನಾರ್ಕೋ ಟೆಸ್ಟ್ ಆಗಿತ್ತೆ ಇವ್ರದ್ದು?
ಆಗಿದೆ ಆಗಿದೆ. I have noted.
With respect to Miller's A15, A10 Miller's, there is no narcolepsy test.
ಇದೆ ಅಲ್ಲ, ಬರ್ದೀನಿ, ಇದೆ.
A15.
Last item.
You picked up from the hotel and took them to the examination center.
I am a student, Miller's. I'm student.
Student ಆದ್ರೆ
student Miller's, we am placing with the similar allegations of accused number 15, this Shantanu Saukar and the maker A6.
But you straight away dismiss A6 allow ಮಾಡಿದ್ದೀನಿ ನಾನು, if I remember.
Yes, my lord.
A6 is a doctor. Now
ಅಲ್ಲ, ಅವ್ರ ಮೇಲೆ ಏನು ಮೆಟೀರಿಯಲ್
ಇರಲಿಲ್ಲ. Nothing was there. Nothing. See, allow ಮಾಡಿರೋದು ಯಾವುದು ಅಂದ್ರೆ ಯಾವ ಮೆಟೀರಿಯಲ್ ಇಲ್ಲದೆ ಇರೋದು allow ಮಾಡಿ.
In fact, I have considered in respect of so many accused. In my note, I have clearly stated what is the material available.
Really?
That's because of
I'm waiting for your submissions.
Because of this appeals, my lords, I have not.
ಅಲ್ಲ, ಅಪೀಲ್ ನನ್ನ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇರೋದು, ಅವ್ರೇನ್ ರೆಡಿ ಆಗೋದು?
ಯಾವ ಅಪೀಲ್? ಓ, ಅದು
ಇಲ್ಲಾಂದ್ರೆ my lords, I have not taken single adjournments, my lords.
Correct.
Tomorrow, my lords.
ಆಯ್ತು, ನಾಳೆ
my lords.
We'll finish it tomorrow.
I condone my absence tomorrow, man. Some family function.
No problem. The
note that I have given is our argument. Watch what we have done earlier also. Same.
Reddy is there. Heard the learned counsel Sunil Kumar appearing for the petitioner and the learned counsel P. Prasanna Kumar representing the CBI. The learned counsel representing the learned counsel P. Prasanna Kumar submits that the issue in the list is akin to what is already decided by this court, the accused whose cases have been dismissed. The learned counsel submits that dismissal of the case against few of the accused has been affirmed by the apex court or not interfered by the apex court. In that light, the learned counsel submits these petitions also should meet the fate that met the fate of accused number 1 and 2. The learned counsel of the petitioner seeks a day's accommodation. List tomorrow at 2:30 p.m.
Yes, much.
ನಾಳೆ ಮುಗಿಸ್ಬಿಡಿ ಸುಮ್ಮನೆ.
Yes,
ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ, ಇದೆ ಅಂದ್ರೆ ಇದೆ.
I'll do it because of this matter only, my lords.
Yes.
5.
Lords, this matter may kindly be taken along with criminal petition 3473.
ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ?
No, tomorrow, Lords.
ಆಯ್ತು, ಏನ್ ಹೇಳಿ?
ASG is appearing in this matter, Lords. This is that NDPS case wherein 50A was not complied and it was quashed.
My lord, they have sought for recalling of the order.
Who has? Oh,
That dummy.
oh, ಇದು. All right.
Co-accused
Controlled,
petition.
Controlled.
ASG.
Uncontrolled delivery.
Controlled delivery. Uncontrolled delivery.
Uncontrolled. My lord, this is hit by 362. Absolutely. They are seeking as a appeal.
ಅಲ್ಲ ಅದು ನಾವು ಯಾರೋ ಒಂದ್ರಲ್ಲಿ ಬರ್ದ್ಬಿಟ್ಟಿದೀವಿ. We should not fight shy of recall. That's the reason for recalling that or not.
Ado bere iತ್ತು, I recollect that. But there are so many. In 25 alone, there are 3 judgments of the Supreme
Matter,
Court.
Lords, learned the ASG had appeared
ಆಯ್ತು.
earlier.
ನಾಳೆ.
My lord, 6 years. 6 years, 22K.
Huh?
Your lordships, 22,000 plus.
ಆಯ್ತು. ನಾಳೆ. We'll take it tomorrow.
ಇದು ಅದು ಆಡ್ ಆಗೋಗುತ್ತೆ.
Serial number ಯಾವ್ದದು? ಇನ್ನೊಂದು?
Lords, it is not listed today, my
That's
Lords.
reserved, right?
It is not reserved.
ಯಾವ್ದು ಕೀರ್ತಿ ಅಪಿಯರ್ ಆಗಿ? ಮೇಡಮ್ ಅದು ರಿಸರ್ವ್ ಆಗಿಲ್ವಾ?
It is not reserved, my Lords. In fact,
I've reserved it.
my Lords,
I'm not reserved it?
after hearing this recall, my Lords, that will be decided. Please.
That's
On the same ground.
same. Other accused number. This is accused number 2, I guess.
Yes.
That's accused number 1.
Accused number 3, my Lords.
3.
That is
All right,
accused
3.
Please.
We'll see. But that as far as I know, I've reserved it. We'll see. Yes. ನಾಳೆ.
Number 6.
Ah, 406 for.
Yes, my lord.
Yes, sir.
Only. There is already connected matters, my lord.
Stay ಇದೆಯಾ?
Stay is some connected matter.
ಏನ್ connection?
Criminal petition number 9618 of 2023, my lord.
Yes, Jagdish.
Be taken up together.
Tag this petition. Learned counsel for the petitioner submits que the other accused. Same CC? Same CC, na?
Yeah, same CC.
Where the other accused in CC 6903 of 2023, this court has granted an interim order of stay and the same is in subsistence even today. Adu todi, number. Tag this petition along with so and so in the light of the interim order subsisting in the said case, there shall be an interim order in the case at hand as well. Yes.
7.
For the petitioners, my lords, I'm filing the memo of withdrawal.
Thank you, sir. Yes.
With liberty, my lords. After
What liberties?
charge sheet file ಮಾಡಿಲ್ಲ, my lord.
All right, good. Same charge sheet format ಇದೆ. ತೊಗೊಳ್ಳಿ madam.
8.
8 goes with, 8 goes tomorrow.
9.
For as 4 and 5 is concerned, Lordship has quashed the proceedings and compounding application also filed. Affidavit is also annexed. The co-accused order at page number 78, annexure E.
Page
78, annexure E is the, so far as accused number 4 and 5, Lordship has quashed. And now I have filed application for compounding, so far as accused number 1 and 2.
Complainant yaru? The petitioners are different accused in CC 56 of 2013. This court in criminal has disposed criminal petition 8696 of 2025 in terms of its order dated 10th July 2025, recording a settlement arrived at between the other accused The offences were the ones punishable under section 406, 419, 409, 420, and which were not against the state. Therefore, the matters, the compounding application was accepted and the crime stood obliterated qua those accused. The petitioners are, as observed here and above, different accused. Illu hakidira?
Hakide.
And have arrived at a similar settlement. Arrived at a settlement and a similar application seeking compounding has been preferred. Ellide Latif?
Please.
Ellide. It's here. The affidavit is as follows. In the light of the aforesaid circumstance of quashment of proceedings qua the other accused on the settlement and a similar settlement and a compounding application springing in the subject petition as well, the petition, same order.
Okay.
KV location. ಇದು ಯಾಕೆ ಏನಕ್ಕೆ ಮೇಡಮ್ ಇಲ್ಲಿ ಬಂದು extension. This court had disposed the petition, recording the undertaking, the affidavit of undertaking on 15th February 2023. The affidavit of undertaking, the reason on the affidavit of undertaking, this court had passed the following order, page para 2 of the order. An application is now filed by the petitioner seeking extension of time. In the light of the undertaking affidavit that was filed, there is no warrant to grant any extension of time to the petitioner. The application lacking in merit stands rejected, leaving open the petitioner to avail of all remedies as is available in law. Ordered accordingly.
Number 11.
Yes, Tahir.
Much sincere apology, Lordship. I'm not able to come there physically.
Don't worry.
20-minute pass over, Lordship. I'll come physically and assist this honorable court, Lordship.
ಏನ್ ಮ್ಯಾಟರ್ ಏನ್ ಹೇಳಿ ಪರ ಡಿಜೆ ಹೇಳಿದ
multiple FIR matter which Lordship has disposed earlier petition, a similar petition with respect to other accused persons, and some other accused person has filed, and Lordship give me 20-minute pass over, Lordship. I'll come there and assist this honorable court, Lordship.
No problem, come sir, you can come at 2:30 20 minutes sir.
Please may I submit, my lord? I'll file my objection, my lord.
ಬಂದ್ ಬರ್ಲಿ ಬಿಡಿ. Yes.
Number 12, preliminary hearing.
BWSSB.
Yes, sir.
Heard.
My lord.
BWSSB order disposed.
Okay. Admission 13.
KP activation. 70 and 80. KP activation. 150 and 152 is not complied.
The permission ತಗೊಂಡೆ ರೈಡ್ ಮಾಡಿದ್ದಾರೆ.
ಪರ್ಮಿಷನ್ ತಗೊಂಡಿದ್ದಾರೆ.
ತಗೊಂಡು ರೈಡ್ ಮಾಡಿದ್ದಾರೆ.
ಮತ್ತೆ ಇನ್ನೇನ್ ಬೇಕು?
ರಿಕವರಿ ಆಗಿದೆ.
The permission ತಗೊಂಡಿರೋ Lordship 151 is not complied, your Lordship.
ಅದು ಪರ್ಮಿಷನ್ ಇಲ್ಲಿ ಇಲ್ವಾ?
ಇಲ್ಲ.
ಇದೆ.
Magistrate permission.
Raid ಮಾಡಕ್ಕೇನೆ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಪರ್ಮಿಷನ್ ತಗೊಂಡೆ, even including before registration of FIR, raid was conducted. Even for that itself they obtained a permission.
Where is ಇದೆಯಾ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ?
ವಾರೆಂಟ್ಸ್ ಎಲ್ಲ ತಗೊಂಡು ಮಾಡಿದ್ದಾರೆ.
To register a crime raid ಗೆ ತಗೊಂಡಿದ್ದಾರೆ ಅಂದ್ರೆ ರಿಜಿಸ್ಟರ್ ಕ್ರೈಮ್ ತಗೊಂಡಿರ್ತಾರೆ. ಅದಕ್ಕೆ ಅಷ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ ಇದನ್ನ.
ಇಲ್ಲ ತಗೊಂಡಿಲ್ಲ ಸರ್.
ಏನಿದು? ಕ್ಲಬ್
ಇಸ್ಪೇಟ್ ಆಡ್ತಾ ಇದ್ರು ಅಂತ.
ಇಸ್ಪೇಟ್ ಆಡ್ತಾ ಇದ್ರು. ಇದು ಸಂದರ್ಭ
ಅಲ್ಲಿ ದುಡ್ಡೆಲ್ಲ ರಿಕವರಿ ಆಗಿದೆ. Even under bar, my lord, when there is a recovery of amount, they are playing by putting money.
155(2) ಅಷ್ಟೇ ಬಿಲ್ಡರ್ ವಿಲ್ ಡಿಸ್ಮಿಸ್ ಇಟ್.
That's correct.
ಏನದು 155(2) ಗ?
ಹೌದು.
ಅದೇನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಬೇಕಾಗಿದೆ.
151
ಪರ್ಮಿಷನ್ ತಗೊಂಡಿದ್ದಾರೆ. I'll secure that exact order, my lord.
Tagoli. Well, the solitary ground projected by the petitioner, counsel for the petitioner is non-compliance with subsection 2 of section 155 of the CRPC. In as much as no permission of the learned magistrate is secured prior to registration of a crime of a non-cognizable offence. Section 7980 of the Karnataka Police Act is what is alleged, which is admittedly a non-cognizable offence. The records would not indicate that permission is taken. Learned additional SPP submits permission is indeed taken even to conduct a search, and the offence is one of gambling. The learned vacation then we'll stay till then. List the matter on same day. List the matter on so and so. Further proceedings in the light of the aforesaid circumstance shall remain stayed, subject to the learned additional SPP securing and placing the records of taking of permission of the learned magistrate on the next date of hearing. Yes. Next.
14. For petitioner in 14.1, my lordship.
Petitioner in this. This is a case, Miller. Immoral Trafficking Act was invoked.
ITP.
ITP. And the first is a sleeping partner with that spam Millers. He's a sleeping partner Millers. Admittedly, there is an agreement between
that's the problem.
1 and 2.
ITP
1 and 2 Millers. He's only a sleeping partner Millers. He's no way concerned with the day-to-day. No way concerned with the day-to-day activities of the spam Millers. That is the first. That is the specific contention of the petitioner Millers. Here, Millers, the legal issue is that Millers, the investigating officer who receives the credible information on 8/7/2022. On 5:30 Millers, 5:30 PM, he received the credible information. Between 7 to 8:30, he conducted this raid Millers.
What was your sleeping partner doing then?
I was not present Millers. Even admitted fact, even as per the complainant, as per the prosecution Millers, I was not present at the spot Millers. You are
not present with your partner.
Even with your partner Millers, even in this spa, I was not present Millers. Millers, I am working in a different area, different company. I am not aware of the day-to-day basis of this particular spam. That is my specific contention.
Why you are not the manager there?
I am not the manager Millers. I have appointed Millers. Even at last date of hearing, I have placed the memo with the agreement. The customer. I am not the owner of the premises. Only.
What were you doing there?
I was not present Millers as per the partnership deed.
Why are you accused here?
Merely because I am a partner of the particular spa, I have worried as an accused person Millers. Accused number 1. I am facing the partnership deed Millers.
Last
time quoted in. That's the legal issue is Millers, whether the raid conducted prior to registration of FR is permissible or not Millers. The Honorable Apex Court in the Pradeep Nirankaranath judgments Millers, they were interpreting the.
That is not applicable to ITP, sir. FIR register ಮಾಡಿ logo
coordinate benches of this Honorable Court also come up with the similar issue.
Just Suraj Govindaraja brother nodi barala.
But Millers, in criminal petition number 7582, and even Millers, Justice Honorable Kunnas, we've also Millers, before conducting raid, the registration of because Millers, there is a cognizable offence. The information is cognizable.
Correct. Why is 156 there? Go to 156 CRPC. ನೋಡಿಲ್ವಾ?
And now
156 ಇರೋದು ಅದಕ್ಕೇನೆ.
Yes, my lord.
They will.
That is my specific contention.
No, I'll tell you one thing. Now 154 crime register ಮಾಡಿ ಅಲ್ಲಿ ಹೋದ್ರೆ ಏನು ಇಲ್ಲ ಅಂದ್ರೆ it has to be closed in a manner known to law. Police cannot close it. ಅದಕ್ಕೆ 156 ಅಲ್ಲಿ when they conduct a search, if they find the cognizable offence being conducted or being alleged to have been done there, aವಾಗ they will register a crime.
No, my lord, it is not their case, my lord. ಇವ್ರು ನಾವು ಫಸ್ಟ್ FIR ರಿಜಿಸ್ಟರ್ ಮಾಡಿ ಅಲ್ಲಿ ಹೋದ್ರೆ ಅವ್ರ ಸೀನ್ ಆಫ್ ಕ್ರೈಮ್ ಇಂದ ಪ್ಲೇಸ್ ಆಫ್ ಅಫೆನ್ಸ್ ಇಂದ ಎಸ್ಕೇಪ್ ಆಗೋ ಚಾನ್ಸಸ್ ಇದೆ ಅನ್ನೋ ದಟ್ ಇಸ್ ನಾಟ್ ದೇರ್ ಕೇಸ್.
That is not that is not located. I told you Lalita Kumar is not a panacea to all these problems.
That is to, my lords, when the information receives regarding the cognizable act itself, my lords, before registering, my lords, they received the information at 5:30.
All information will not be correct. Raid ಮಾಡಿದ್ರೆ ತಾನೇ ಗೊತ್ತಾಗುತ್ತೆ.
Raid ಮಾಡಿದ, no my lords, they says that my lord, it's a credible information.
The raid in these cases, raid ಮಾಡಕ್ಕೆ entry in the police diary and the search party being taken note of is enough. That's what I feel. Unless Jagdish says yes.
In fact, 2022, my lord, Supreme Court said, while doing it, Supreme Court went one step ahead and said, even if you do.
ಅಲ್ಲ ಸರ್ 2017 RH ಸಿಗುರನ್ ಕೊಡಿ ಅದು.
2017, 11.
ಅದು ITP.
And even my lords, the similar issue was come up before the Honorable Madras High Court, my lords. Whether the massage parlors.
Justice Anand Venkatesh ಅವರು
Yes, my lord.
ಕೊಡಿ. Yes.
And in detailed discussion, my lords, from the ancient period.
Correct. What is massage ಅಂತ ಬರೆದಿದ್ದಾರೆ.
ಎಲ್ಲ ಪೂರ್ತಿ massage is giving.
ಅಲ್ಲ ಇಲ್ಲಿ ಬರೀ ಮಸಾಜ್ ಅಲ್ಲ, ಬೇರೆ ಬೇರೆ.
ಅದು ಪ್ರಾಬ್ಲಮ್ ಅದು.
ಅದು ಪ್ರಾಬ್ಲಮ್.
No, my lords, in specific allegation against these petitioners are, my lords, they have established
Okay, see, I told you.
and they are giving the
brief history. This is state by Supreme Court.
I'm not aware of that.
It's a matter of investigation. If it comes to know that he's only sleeping, not sleeping in the massage parlor, we will do.
And no, my lords, it is not a matter of investigation, my lords. In the end, my lords, my humble submission that, my lords, the matters, the allegations like this, my lords, in the FIRs like this, my lords, it's rampant in the Bangalore city, where the police officers, as the police station is far away from the spot, my lords, 1 kilometer. 1 kilometer, Indranagara police station. ಅವ್ರು ಮಾಡಲ್ಲ ಸುಮ್ಮನೆ CCB ನವರಿಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಬರುತ್ತೆ.
ಅವ್ರು ಮಾಡೋಂಗಿಲ್ಲ, CCB ನೇ ಮಾಡಬೇಕಾಗಿರೋದು.
my lords, they says that my lords, we have received credible information, my lords. ಅವ್ರು ಹೇಳೋದು ಸುಮ್ಮನೆ credible information ಬಂತು, ಅದಕ್ಕೆ ಓದಿ ಅಲ್ಲಿ ನಡೀತಾ ಇತ್ತು ಅಂತ. Anyway, my lords, I was not present at this spot.
List the matter on same day third. Entry order subsisting will continue.
We have a stay, my lordship, in 14.1.
In my petition, my lords, there is
You're okay now?
No, my lordship, I'm under bed rest for 2 more weeks, my lordship.
All right, yes.
My petition, there is no interim order.
I am heard the learned counsel appearing for the petitioner. The learned counsel Sunil Kumar submits that the stay application ilva ಇದೆಲ್ಲ ಮಾಡ್ತಾರೆ. ಬೇಡ. Yes. He was elsewhere ಅಲ್ಲ ಅದಕ್ಕೆ. Yes. ಅವರು ಬರೀ ಅಪೀಲ್ ಮಾತ್ರ ಇವತ್ತಾಗಿರೋದು. List the matter on same day. Interim order in the companion petition shall stand extended till the next date of hearing. Yes.
Where is my lordship?
16.
ಇದ್ರಲ್ಲೇನು ಸುನಿಲ್ ಕುಮಾರ್ 16 ಆಯ್ತಲ್ಲ ಈಗ, ಅದೇನೆ ಅಲ್ಲ 14 ಆಗಿದೆ. 16 ನಿಮ್ದೆ ವೆಂಕಟೇಶ್ ಅಲ್ಲ ಅಲ್ಬರ್ಟಿ ಅವರೇ 15 ವಿಡ್ರಾ ಮಾಡಿದ್ದಾರೆ. ಯು ನೀಡ್ ನಾಟ್ ವೈಟ್. ಬೇರೆ ಇರ್ಬೇಕಲ್ಲ ನಿಮ್ಗೆ.
It's a detailed interim order passed by this honorable court.
Correct. 409, 420.
420 and 409. Initially, my lords, I have already accused the entire allegation against me, my lord, during the crime in the FIR, my lords. Subsequently, my lord, the investigating officer has collected the FSL sample signatures, sample handwriting signatures of the other accused persons. Then, my lords, after obtaining the FSL report, the investigating officer has filed a detailed charge sheet, my lord, wherein, my lords, they have exonerated, they have recorded, the investigating officer has recorded the voluntary statement of accused number 2. In his voluntary statement, my lord, he has exonerated me. The entire allegation has shifted to the other accused persons, my lords.
That's why interim order have granted.
Yes, my lord.
It's a detailed. Yaru respondent yaru? Yaru complainant yaru idare?
One counsel has filed wakalat, my lord.
This court on 20th August 2024 has passed the following order. Heard the learned counsel appearing for the petitioner, awaiting the appearance of the counsel for the complainant. List this matter same day. In the event the counsel for the complainant would not be present, appropriate orders would be passed on hearing the state and the counsel for the petitioner. Interim order subsisting would continue to the next date of hearing. Yes.
17.
The petitioner, please.
My lord, I appear for respondent number 2.
Yes, ಏನ್ ಮಾಡ್ತೀರಾ?
This was posted for limited effect, wherein my lords had expressed that offense not made out for section 420, 468 and 471, except 447. With respect to 447, civil suit is pending To that effect, please, my lord.
Hmm.
Only then this complaint came to be filed, my lord.
Yes, madam, you have complied with your undertaking?
My lord,
Yes, yes.
my lord,
All right.
the last occasion I had submitted a compliance affidavit with reference to the
Yes.
encroachment allegation.
Yes, yes, yes.
My lord, my sincerest apology for, my lord,
Coordinate bench.
Please, my lord.
ಯಾವ್ದಕ್ಕೆ?
MFL.
MFL.
Please. After this petitioner, petition number 1, accused number 1, approached the civil court seeking injunction. Only then this.
We'll pass this tomorrow.
Please.
This tomorrow at 2:30.
much obliged.
PR
Balan.
Balaraj.
Balraj. Complainant served under present.
307.
Interim model and case. Tomorrow. Huh? Served 9/10/25. The complainant is served on 9/10/2025. Therefore, to afford one more opportunity for representation, list this matter on for same day. Yes, next.
19.
Petition. My lordship, the crime ಆಗಿದ ತಕ್ಷಣ I have filed quash petition. ಕ್ರೈಮ್ಗೆ ನಾನು ಸ್ಟೇ ತಗೊಂಡು ನಾನೇ ವೆಕೇಟ್ ಮಾಡಿದ್ದೀನಿ.
ನೀವು ಸ್ಟೇ ತಗೊಂಡ?
ನಾನೇ ವೆಕೇಟ್ ಮಾಡಿದ್ದೀನಿ.
ಏನ್ನ?
ಸ್ಟೇನ.
ನೀವೇ ವೆಕೇಟ್ ಮಾಡಿಸಿದ್ರ?
ಹೌದು.
ಯಾಕೆ?
ನಾನು ಪ್ರೊಸೀಡಿಂಗ್ ಸ್ಟಾಪ್ ಮಾಡಬಾರ್ದು ಅಂತ. ಏನಂದ್ರೆ ನನಗೆ ಏನು ಅಫೆನ್ಸ್ ಇಲ್ಲ. ಆಕ್ಚುಲಿ A3 ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಡಿಫ್ಯಾಕ್ಟರ್ ಕಂಪ್ಲೇಂಟ್ ನ A3 ಮಾಡಿದ್ದಾರೆ. ಅಂದ್ರೆ ಪೇಜ್ ನಂಬರ್
BNS
21 ಮೇಲೆ ಪೇಜ್ ನಂಬರ್. ಪೇಜ್ ನಂಬರ್ 21. ಇಲ್ಲಿ ಒಂದು ಕೌನ್ಸಿಲ್ ಅಪೀರ್ ಆಯ್ತಾರೆ ಫಾರ್ ವಿಕ್ಟಿಮ್ ಅಂತ. ಐ ವಿಟ್ನೆಸ್ 1. Yes, filed wakalat on behalf of the victim. Same on page number 22. He has withdrawn the same application to defreeze. Page number 38, my lordship. A3 के same counsel has appeared. Victim को और एक accused को और एक. Now he has claimed the application for victim. For both the person, the same counsel.
Charge sheet allide.
Charge sheet page number.
Stay itta ಮುಂಚೆ
ಇತ್ತು.
ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ, ನಾನೇ ವೆಕೆಟ್ ಮಾಡಿದ್ರಿಂದ ನಾನು ಮಾಡಿಲ್ಲ.
ಮತ್ತೆ ಅಲ್ಲೇ ಕಂಟಿನ್ಯೂ ಆಗ್ಲಿ ಬಿಡಿ.
ಇಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ. ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡು ಮಾಡಿದ್ದೀನಿ.
ಚಾರ್ಜ್ ಶೀಟ್ FIR ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಸ್ಟೇ ಇದ್ದಿದ್ದನ್ನ ಚಾರ್ಜ್ ಶೀಟ್ ವಿಡ್ರಾ ಮಾಡಿದ್ದೀರಾ ಅಷ್ಟೇ.
ನಾನೇ ವಿತ್ಡ್ರಾ ಮಾಡಿದ್ದೀನಿ. ಚಾರ್ಜ್ ಶೀಟ್
ನೀವೇ ವಿಡ್ರಾ ಮಾಡ್ಬೇಕು. ಯಾರು ವಿಡ್ರಾ ಮಾಡ್ತಾರೆ ಮತ್ತೆ?
ಅದೇ
cheating is the offense, sir.
ಇಲ್ಲ, ಸ್ಟೇ ವೆಕೆಟ್ ಮಾಡಿದ್ದೀನಿ.
ಅಲ್ಲ, 318 is the offense. 318 BNS.
ಬಟ್ FIR ಅಲ್ಲಿ 66C and D ಮಾಡಿದ್ದಾರೆ. ಅದರಿಂದ
FIR ಅಲ್ಲಿ
ಹೌದು,
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ
ಡ್ರಾಪ್ ಮಾಡಿದ್ದಾರೆ.
318 66D ಇಲ್ಲ.
ಇಲ್ಲ, 66C and D ಡ್ರಾಪ್ ಮಾಡಿದ್ದಾರೆ.
ಜಗದೀಶ್
318 ಇದೆ.
ಅಲ್ಲ, 318 is cheating.
Yes, sir. ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ A3 ಮೇಲೆ ಮಿಜೋರಂ ಅಲ್ಲಿ CBCID CID ಮತ್ತೆ ಎಕನಾಮಿಕ್ ಅಫೆನ್ಸ್ 368 ಕೇಸ್ ನಂಬರ್ ಅಲ್ಲಿ FIR ಆಗಿದೆ. A3 ಮೇಲೆ ಮಾತ್ರ.
So A3 also the complainant is also shown.
Complainant is also an accused.
accused ಮಾಡಿದ್ದಾರೆ.
Now the victim shown in the charge sheet is somebody else.
ಏನಪ್ಪ
ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅಮೌಂಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿರೋದು ಪೇಜ್ ನಂಬರ್ 1.
It is cheating and conspiracy.
The victim shown in charge sheet
93 ಮೇಲಾಚ್ ಪೇಜ್ ನಂಬರ್.
You may have to make that victim as a complainant in the.
Who is the complainant here?
ಕಂಪ್ಲೇಂಟ್ ಯಾರಿಲ್ಲ, ಪೊಲೀಸ್ ಅವರೇ ಮಾಡಿದ್ದಾರೆ.
The charge sheet, the victim is one.
ಐ ವಿಟ್ನೆಸ್ 1 year. ಚಾರ್ಜ್ ಶೀಟ್ ಯಾರು ಹಾಕಿಲ್ಲ, ಕಂಪ್ಲೇಂಟ್.
1 minute, sir.
Page number 93 ಮೇಲಾಚ್.
One crore 94 lakhs.
Yes, ma'am.
Bank transaction.
Oh. Page number 93 ಮೇಲಾಚ್.
Wait. Just look into it.
But then the victim, he has to make this one Linda as a respondent in this case. Seems to be she is the one.
ನಾವು ಪಾರ್ಟಿ ಮಾಡಿ
ಮಾಡಕ್ ಬರಲ್ಲ. ಯಾಕೆಂದ್ರೆ ನನಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ ಥರ್ಡ್ ಪಾರ್ಟಿ. Is not the complainant, not the.
Who is the complainant, sir? Complainant is some Muhammad Badshah.
Has made us accused number 3, but he is as a commission broker.
Whoever it is, complainant ಯಾರು ಅವರು
ಅವ್ರು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿಲ್ಲ.
ನಿಮಗೆ ಯಾರು ಮಾಡಿದಾರೆ ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ ಅದು ನೋಡೋಣ, ಯಾರು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದಾರೆ ಯಾರು ಮಾಡಿಲ್ಲ ಅಂತ.
ಇಲ್ಲಿ 93 ಇದೆ ಪೇಜ್ ನಂಬರ್.
According to charge sheet, one Linda is
92 ಮೇಲಾಚ್.
1 minute.
92.
ಯಾರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದು?
ಭಾಷಾ ಅಂತ ಎಫ್ಐಆರ್ ಅಲ್ಲಿ.
ಭಾಷಾ ಆಯ್ತು. ಈಗ ಹೂ ಇಸ್ ದಟ್ ಲಿಂಡಾ?
ಐ ವಿಟ್ನೆಸ್. ಅವ್ರು ಬಂದು 92 ಪೇಜ್ ನಂಬರ್ ತಗೊಂಡ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. 92. ಇವ್ರು ನಮ್ಗೆ ಚೆಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ನನ್ಗೆ ಕೊಡ್ಬೇಕಾದ್ರೆ ಅಮೌಂಟ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಮೇಲೆ ಕೊಟ್ಟಾದ್ಮೇಲೆ she has told, actual lady, she has told that don't deposit check, she has transferred. ಇವ್ರು ಬಂದು
ಕಂಪ್ಲೇಂಟ್. Who has registered the complaint?
ಡಿಫೆಕ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಇವ್ರ ಹಸ್ಬೆಂಡ್.
ಯಾರು ಹಸ್ಬೆಂಡ್ ಯಾರು?
ಭಾಷಾ.
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿ.
ಅವ್ರ A3 ಆಗಿದ್ದಾರೆ.
ಹಸ್ಬೆಂಡ್ ಇಸ್ A3. Then ಇವ್ರನ್ನ ವೆರಿಫೈ ಮಾಡಿ. What is telling is not clear. ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬೇಕು. ಅದಕ್ಕೆ tomorrow at 2:30.
Petitioner, my lord. My lords, in this, the petitioner has been accused of default payment and forgery. As of now, the matter is settled as the petitioner has proposed for a one-time settlement to the respondent number 2, which is at annexure.
Bank is the complainant, is it?
R2 is the complainant, my lords. Which is at annexure E, second volume, page number 550.
Learned Counsel KV Lokesh is directed to accept notice for the second respondent. Learned additional SPP for the first respondent. The Learned Counsel appearing for the petitioner submits that talks of settlement between the settlement has been arrived at between the second respondent bank and this petitioner with regard to the deposit of the amount. In that light, further proceedings shall remain stayed till the next date. List the matter on so and so. In the event there is no settlement or arrived at between the parties as is submitted, the interim order granted would get automatically vacated. Yes.
21 B group.
Disposed on.
21.
Petitioner's counsel, my lord, what happened was, this is that matter, my lord, with regard to the PPE kits. They filed an appeal against your lordship's order. Then produced, my lord, new documents. So the court said, look, how can I look into it? Shall I remand it? So, my lord, the matter is come back to your lordship. They have not produced the new document before your lordships. They are simply.
Your government, PPE kits, I quashed it.
How do? Your lordship allowed, my lord. Your lordship recollects.
Correct.
The AG came, he said, my lord, everything is in order.
Yes.
Now, my lord, they produce some new documents. Writ appeal order. Nodi.
claim for interest.
This is the writ appeal order where they produce my lord new documents. Please come to my lord paragraph 4 onwards. Appellants added my lord new documents, new pleadings. So court said, now I can't. Illeno hakilla. Nothing is placed before your lordships.
I think grouping Jacob will appear, my lord. I think statement of objections is ready.
Pass over matter.
Objection will be filed today.
We heard the learned senior counsel Uday Holla appearing for the petitioner. This court had disposed the petition on 10th April 2024 on recording the submissions of the state and the petitioner and the counsel and senior counsel for the petitioner. It transpires that the state has tossed the matter before the division bench, the contempt hakidre anta hakiru. Division bench and writ appeal 1576 of 2020. Ruben, what is all this?
My lords had allowed it. There was an arbitration clause in the agreement. At the point of time when it was allowed before my lords, we had said that the matter is pending before an inquiry before the Kunna committee. But the report was yet awaited. Then my lords had allowed the petition regard to payment. But after the disposal of my lord's petition, petition by my lords, the Kunna committee report came out, wherein my lords there were disputed questions of fact arose with regard to whether he had actually committed.
Where have you produced all that here?
No, that was produced, my lords, in the writ appeal.
No, here where have you produced?
No, we are filing the statement of objections, my lords. Today we are filing it, my lords. My lords, in fact, we kindly grant us. By end of the day today, my lords, we will serve it and file.
The 4th March 2025, what were you doing till now?
No, my lords, I'm told, my lords, objections were ready. There is some problem. Today, no government advocate got allotted. Their matter came up, my lords. We are slight. I get it, my lords. Give us 2 days accommodation.
Ultimately, it has to be heard by me only now.
Lords, but with pleadings, my lords, with pleadings.
Without pleadings order matter.
Lords, subsequent event ಬಗ್ಗೆ pleadings ಬೇಕು. What had happened is now there is a disputed question of fact. There is an arbitration clause. The question only thing is whether it can be gone into a writ jurisdiction. Now that disputed question of fact, we will bring it to the notice of my lords based on the report that we have. Kindly grant us, my lords. My lords can say, but within a day's time, we'll file objections. My lords may fix a date, my lords.
Kunna committee report does not say anything. I'll point out.
No, we will point out that. We will produce it. My lords, that we will produce it. And they had the benefit of the copies, my lords, before the division bench. So maybe they are making some comments.
I don't have the benefit of the copy. Senior counsel says Kunna report
No, my lords, maybe
it was Kunna committee report was in the sealed cover. They did not even give us.
No, it was handed over. Ultimately, it was handed over.
Ultimately.
Finally,
I think ultimately ಯಾವಾಗ objection ಆಗ್ತೀರಾ?
My lords, 2 days time for objections. My lords, the difficulty was it's a disposed matter restored. Then ನಮ್ಮ office ಅಲ್ಲಿ ಸ್ವಲ್ಪ file missing ಇರುತ್ತೆ. ಇವತ್ತು ಇಲ್ಲಿ ಯಾರು
ಫೈಲ್ ರೆಸ್ಟೋರ್ ಆಗಬೇಕು.
We have our difficulties.
ರೆಡಿ ಹಾಕ್ತೀವಿ ಇತ್ತು. ಈಗ ಹೇಳ್ತಾರೆ 2 ದಿವಸ ಫೈಲ್ ಮಿಸ್ಸಿಂಗ್.
My lords, we will get it filed, my lords, within 2 days time. Accommodate me for 2 days for filing objections. Maybe if they want to retain the right of rejoinder, subject to that, my lords may fix it.
So should we fix it on the 5th January?
Please,
I'll be here. Better.
Please.
So the pleadings complete.
Please.
The subject petition heard the learned senior counsel Uday Holla appearing for the petitioner, learned additional advocate general Ruben Jacob for the state. The subject petition stood disposed by an order dated 10th April 2024. It transpires that the state had tossed the order passed by this court before the division bench in writ appeal 1576 of 2024. The writ appeal is disposed on 4th March 2025, setting aside the order passed by this court supra, as noted supra, directing the state to produce all the documents that were secured by the state in the aftermath of the disposal of the petition by this court. In that light, the petition is again before this court to be heard. The learned additional advocate general submits that if a week's time is granted, he would file the entire material that was placed before the division bench before this court by way of statement of objections. The submission is placed on record. The state shall file its objections within a fortnight from today, and any rejoinder, if any, within a fortnight thereafter. Less the matter on 5th January.
Oh, 5th January, not 5th to
December. Urgency, yeah?
ಅಂದ್ರೆ ಈಗ ಒಂದು ಹೊಲ criminal complaint ಹಾಕಿಟ್ಟಿದ್ದಾರೆ.
Criminal complaint, why?
This is what, my lord, they are
No, in the
contempt
Kuna
ಹಾಕಿದ ತಕ್ಷಣ,
committee-
my lord, when I filed the contempt petition, they went and filed a criminal complaint.
My lords, that is on the basis of the recommendation of the Kuna committee, wherever, my lords,
All
there has
this-
been some.
Ah,
My lords,
anyway,
may have it.
don't precipitate that.
My lords, that I don't know, my lords, I am not aware of
Yes, my
that.
lord,
I am
make
not
that
aware
clear.
of that, my lords. They
Your
should-
lords may make that clear, that they'll.
No, how can, I don't know, my lords.
No,
Let him.
anyway, all right. The learned senior counsel now submits that on the basis of the report of the committee which is yet to be placed before this court, criminal complaint is already registered against the petitioners. Therefore, the matter would require to be heard. There's extreme urgency in the matter. If in the light of the matter being heard after the remand from the hands of the division bench, the criminal complaint, if has been filed, shall not be pursued by the state. List the matter on 5th January.
Please, great put.
ಜಗದೀಶ್ ಅವ್ರು ಇಲ್ಲೇ ಇದ್ದಾರೆ ನಮ್ಮ ಕ್ರಿಮಿನಲ್.
ಅಂದ್ರೆ ಅಲ್ಲ, ಈಗ ಕಮಿಟಿಲಿ ಏನೂ ಇಲ್ಲ ಅಂತ ಬರೆದು ನೀವೇನ್ ಪರ್ಸೂ ಮಾಡೋದು ಆಮೇಲೆ?
Committee has said, my lords, there is.
ಅದು I have to see it still.
ನಾವು 5ನೇ ತಾರೀಕು
My lords, maybe it would have been proper for them to file an.
In fact,
Quashing
if you
petition
I
and get
didn't
an
want to
order.
say that.
Literally, we don't know the FIR number.
Earlier
I don't
AG
know.
comes and
Now,
says,
now he will file everything.
Yes.
Whatever is there, ಅದರದೆಲ್ಲ ಫೈಲ್ ಮಾಡಿ.
No, no, they're talking about earlier age and other things, but I had appeared before the division bench.
ಅದು 482 ಹಾಕಿದ್ದೀರಾ?
482
ಅಲ್ಲೂ stay ಆಗಿದೆ, but it precipitate ಇರಲಿ, because my lord, what will happen is
Stay
they
ಆಗಿದ್ರೆ then ಏನ್ ಪರವಾಗಿಲ್ಲ.
That is already stated, it should not have, they should not even have made that submission.
one minute.
Wait.
They are filing, my lord, applications for vacating. They are doing, my lord, coming here and then taking time. Please look at it. They can't, my lord, play ducks and drakes. After all, my lord, state also has to be fair. If your lords recollects, in this very matter, please look at the order sheet.
Yes.
First AG comes and says, my lord, everything is in order. We produce, my lord, bulk of documents. The director of, my lord, medical education specifically says, my lord, it is in order. Everything is in order.
That's why it is.
Now, my lord, he goes back.
We never say it was in order, my lords. We said it was under investigation.
15/9/2023 order of your lordships. I
Lords,
don't want to say
that
all
was
that.
our objection before the division bench.
Moment
Division
I
bench
file a contempt.
just accepted our objections and remanded the matter.
ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಹೊಸ ಮೆಟೀರಿಯಲ್ ಕೊಟ್ಬಿಟ್ಟು ಇಲ್ಲಿ ವಾಪಸ್.
That material was not available on that day. We had said, let the matter be deferred. The payment cannot be ordered, my lords, in the writ jurisdiction. My lord, they are.
Oh, seriously?
Please,
If
lords,
if
in
it's
a disputed
if the
question.
contracting party is a state and state
Lords,
has
if it is
behaved
admitted
arbitrarily,
amount,
it can be,
admitted
sir.
amount, my lords,
You
why
want
said?
you want speed of
We
judgment
have
on that?
my lords have already quoted the judgments, my lords, in the
Yes.
earlier. Lords, it's not that in matters of this nature where there is a disputed question of fact, whether it is disputed or not, and whether it requires remand to the arbitration or reserve the right to arbitration, my lords, is.
Page 137.
ರಿಟ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಬರಲ್ಲ ಅಂತೆಲ್ಲ ಹೇಳ್ಬೇಡಿ.
ಅಲ್ಲ, ರಿಟ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಬರುತ್ತೆ, but not in the fact situation of this case.
ಅದು ಓಕೆ.
Please.
137 page ಅಲ್ಲಿ.
Lords, that
right?
observation may not be necessary. If it is already stayed.
Stay ಆಗಿದ್ರೆ ಏನ್ ಬೇಡ.
Stay ಆಗಿದೆ. It may
We'll
not
tag that along with this.
ಬೇಡ, tag ಏನ್ ಬೇಕಾಗಿಲ್ಲ.
Yes.
No, my lord, what I am submitting is, my lord, they want to, my lord, investigate. In spite of the stay order, they say we will investigate. That, all that, my lord, therefore, my lord,
That is
precipitate
in
action,
that
my lord,
case, I
they
am
must
not
have.
ಅಲ್ಲಿ ಕೇಳಿ.
That is in that case, my lords.
ಇಲ್ಲ ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ.
Please, my lords.
Your lords may treat this as part-heard, my lord, because your lords is.
I have to hear this
Very
choice.
great.
Fight.
List the matter on 5th January
Please.
for further
My lord,
hearing.
can it be on 8th, my lord?
8th January for further
8th,
hearing.
because
Yes.
I am not in town.
No problem, sir. 5th, I don't think it's.
ಅಂದ್ರೆ court reopen ಆಗದೆ 5th.
8th January. Yes.
Great.
Grateful.
Further hearing 22.
ಇಲ್ಲ ಇದು ಸೈನ್ ಕಾರ್ನರ್ ಅದರ್ ಸೈಡ್.
Could I appear for appellant in my lord criminal appeal number 2270?
ಅವ್ರು ಮುಗಿಸ್ಲಿ ತಾಳಿ. ನಿಮ್ದಾಗಿಲ್ವಾ?
ಇಲ್ಲ, my lord has reserved my right, my lord, to make submission because I was opposing, my lord, to some extent remand and to fullest extent joint trial. So that was the requisition made.
ಅದಕ್ಕೆ ನಾನು ಅಂತ ಹೇಳ್ಬಿಡ್ತೀನಿ, ಅವರು ಒಂದು ಅಕ್ಯೂಸ್ಡ್ ಅಪಿಯರ್ ಆಗ್ತಾರೆ.
No, that is the difficulty.
One minute, he is an accused in only one case and accused is not alive.
Company represented by
This is very worst part is.
ಜಾಯಿಂಟ್ ಟ್ರಯಲ್ ಯಾರ್ದು ಮಾಡ್ಬೇಕು?
ಯಾರಿಗೆ ಬಿಡ?
ಅಲ್ಲ, ಒಂದು ನಿಮಿಷ.
ಇನ್ನು 3 ಕೇಸ್ ಅವರು ಜಾಯಿಂಟ್
ಅಲ್ಲ ನೀವು ಕೇಳ್ತಿರೋದೇನು? ಒಂದು ಜಾಯಿಂಟ್ ಟ್ರಯಲ್. ಅಲ್ಲ, ಆಯ್ತು. ನೀವು ರಿಮಾಂಡ್, ಯು ಆರ್ ಅಪೋಸಿಂಗ್ ರಿಮಾಂಡ್.
Remanding to some extent.
To some extent, all right.
Because it cannot be required because straight away.
Your client is not alive.
Allah, nange joint.
Hello, your client is alive?
No, he is not alive.
So why are you worried?
Huge penalty is imposed, but ultimately,
That
the
will
order may have to go, it has to be set aside. My submission is not, I am entitled for acquittal based on the.
Then you reserve your submissions in case I send it back to you.
Joint trial difficulties, my lord, they are asking.
Joint trial ಆಗಲ್ಲ ನಿಮಗೆ ಬಿಡಿ. Joint trial ಎಲ್ಲಾಗುತ್ತೆ? Accused is not alive.
ಮತ್ತೂರು ಕೇಸನ್ನ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. There I am representing different accused persons.
ಅದು ಬೇರೆ. That will.
Therefore, my lord, I am opposing.
We'll see.
Please.
Now let the CBI finish.
Probably in that regard, I would be supporting that.
You give me objection. That is the application.
You are ready, or should I run through the list and take it later?
Anyway, ready, your lordship, instead of the
that's
waiting, we'll wait.
I'll take it at 2:30 and finish it today. By then I'll finish the list.
Please.
Better.
Please.
26.
Ramesh. Special court matter. Correct. Jagdish sir. 2016. This should not remain. Yaar idu? Ramesh, huh?
Disproportionate asset.
Oh, it's special order agogbiಟ್ಟಿದೆ. No representation on behalf of the petitioner. List the matter as a last chance on 9th January. In the event the petitioner would not be present, appropriate orders would be passed. Next.
Please, Your Lordships. Your Lordships, it's that quashing matter.
Yes.
Your Lordships had heard the parties extensively.
Yes.
Already. Just 2 points, my lords, to what my learned friend had argued, because one of the arguments by the bank was that my interaction with them had started only in 2018 to show, because my argument to your lordships was that I've been doing this banking since 2008 onwards, and there was no change. I mean, I had totally always serviced all the loans, etc. It was only because of the raid and freezing of accounts in 2019 that the default started, and that can't be then a criminality attributable just because of that. So, my lords, just 2 documents to show that my relationship goes well before this incident of 2018-19. If I could trouble your lordships with just that, just the page numbers of that.
Yes.
If relevant. Yeah, if your lordships would just have, my lords, the sanction letter your lordships would get in the CBI additional documents, page 1 itself, which is of 2013, Bank of India. So the 2008 letter is not before your lordships, but at least the 2013 letter, where...
2 minutes.
Yes.
Yes, where, my lords, the banking relationship with Bank of India started, page 1, 28-10-13. And in fact, my lords, in 2008 was with the Oriental Bank. In 2013, it was taken over by Bank of India. And in 2015, State Bank of Mysore took it over. Finally, it came, my lords, to the respondent over here, and the issue started. Just one other short point, my lords. In fact, if your lordships would just have page 153 of the main petition, there is a due diligence report, my lords, of undertaken by the India Bank, which, my lords, also shows, and this is of 8/9/2017. I just trouble your lordship with 3-4 points of that, because one had shown the forensic, but even their own due diligence clearly showed that I was always very compliant. If your lordships would just have, for instance, at page 154 for a moment, my lords.
Yes.
My lords would have page 5, point 5. Company has advanced loans, guarantees, provided securities amount nil to its directors. Then your lordship would see point 7. Amount borrowed by the company from its directors, institutions, banks were within the borrowing limits of the company. Such borrowings were made by the company in compliance with applicable laws. Breakup of the domestic borrowings were as detailed. The company has not defaulted in the repayment of public deposits, unsecured loans, debentures, facilities granted by banks, financial institutions, and non-banking financial companies. Investments in wholly owned subsidiaries abroad made by the company are detailed as nil. Principal value so and so, my lords. Everything was insured. Point 20 at page 155. Funds borrowed from banks, financial institutions have been used by the company for the purposes for which they were borrowed. My lords, all the pointers which any financial due diligence report is going to have. So my conduct has always, my lords, been absolutely as per the book, never a default from 2008 till 2019, never a default. And your lordships would, of course, recall it is only because my accounts got frozen that at the end of the day, the default started happening, my lords. And in fact, I'd even made an OTS offer, my lords, back in 2019 itself, if that's of any relevance.
Yes.
So I'm only humbly submitting, my lords, on first principles over here. I would not be troubling your lordships any further with this, unless there's any new point raised by the other side.
Yes. Madam. Right.
Additional documents we have filed on 18/12/2024.
You're appearing for?
Second respondent,
Petitioner.
Three. Suman Mahendra.
Third petition.
I adopt all that Mr. Gaggar has said. So we sail together. Only one thing is that this additional documents has been filed on 18/12/2024. This is post filing of this petition before your lordship. That's where, my lords. I will draw your lordship's attention to annexure N.
Additional objections.
Additional
documents.
ಹೌದು interlocutory application under section 482 ಅಂತ ಹಾಕಿ 18/12/2024 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾರು ಹಾಕಿರೋದು?
ನಾವು ಹಾಕಿರೋದು ಸರ್.
ನೀವು?
ಹೌದು.
ನೋಡಿ ಬನ್ನಿ. ಇದೊಂದಿದೆ ಅದಲ್ಲ
18/12/24 ಮೇಡಮ್ ಈ ತರ ಚಿಕ್ಕದಾಗಿ that has not yet been allowed. Nevertheless, it's a admitted document. Page 40 may kindly be seen, my lords. There's a resolution passed by the COC. In that your lordship may kindly come to section 47 anta ide. Adra ಕೆಳಗಡೆ ಇರೋದು. Mrs. Indian Bank appointed Mrs. Satya Prakash Mangal and Co. Could your lordship lay hand? Next paragraph, my lords. This paragraph alone I would like to
mark ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ already.
ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ. So other next page ಅಲ್ಲಿ ಇರೋದು
ಅದು ಮಾಡಿದೀವಿ.
ಅದು ಅಷ್ಟೇ. This is one thing. And ನಮ್ಮ short synopsis ಒಂದು ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವು ನಿಮಗೆ. That short synopsis by the petitioner ಕೊಟ್ಟಿದ್ದೀವಿ. Next, further to that, I would like to add two aspects. One is with regard to GST. There was GST ಬಗ್ಗೆ they have made so many statements. As far as GST from Chennai is concerned, it is dropped. Hosur is concerned, it is dropped. They have said there is no default or anything on our hand.
But that does not whitewash the other crimes that are there.
That is the starting point, my lords, where everything, my lords, in between there was COVID-19 in the ella start agididdu. They took away everything, and then there was they seized my documents, and their own forensic report says that some of the documents were not available. It was not with me also, and now, my lords, there was COVID period also in between. Till then, nothing, everything loan was regularly repaid, and there was no default on my part. It all started with GST rates. And GST with regard to one aspect, they have cleared, given a clean chit. Whereas the other one is concerned, there is a stay order passed by this honorable court. These two documents may not be
Alright,
in
we'll
the
hear
compilation, I will give it.
We'll hear the
My
CBI.
absence may kindly be excused for 10 minutes, I'll just.
Please. ಮುಗ್ದಿದೆಯಲ್ಲ ಕೆಲಸ.
ನಮ್ದು ಮುಗ್ದಿದೆ ಅಷ್ಟೇ.
Please. During pendency of this petition, no, not that the investigation is complete, final report is filed. Not for all the offences, not for which FIR was registered, your lordship will find.
Where do I get that?
That's not, I think, filed.
ಹಾಕಿದ್ದೀರಾ?
Filed ಆಗಿದೆ ಈಗ ಲಾಸ್ಟ್ ವೀಕ್ ಆಗಿದೆ, ಇನ್ನು CC ನಂಬರ್ ಆಗಿಲ್ಲ.
ಆಯ್ತು, ಅಲ್ಲ ಅದು ಯಾವ offense ಹೇಳಿ?
Not your lordship page 68 not is the first information. 420, 468, 471 ಇತ್ತು. 460, 420.
420.
No, charge sheet is only for 420. All the other offences are dropped.
468, 471 ಯಾವುದು ಇಲ್ಲ. Only cheating.
Only cheating.
Cheating ಹೆಂಗ್ ಬರುತ್ತೆ?
The final report, no, I may have to. Can I seek some time? I'll paste the final report on record. Let them also, if they want to challenge it, let them also file an application. But now, once for all, I'm not a quite a.
So all this while, the deliberation was about how will the ingredient of 415 become applicable in a case where there is a contract between the parties, loan is being processed or whatever.
I do not know what is the content of the final report. Can I request?
So all other offences are dropped.
They're all dropped.
Will you get the report? Then it now boils down to 420.
ಅದ್ರಲ್ಲಿ ಏನು ಇರುತ್ತೆ ಅಲ್ವಾ ಅಂತ ಹೇಳ್ಬೇಕು.
ಆಯ್ತು.
I need only 2 minutes.
After 420.
After 420 would be better.
ಆಯ್ತು. ಹೇಳ್ಬಿಡಿ. ಅಲ್ಲ, you are aware that it is only 420 now? Even then you will make your submission or later? No, you can do it now, no issues. Tell me, madam.
My lords, the reference was made by the petitioner.
No, you just take note of it that it is only 420 and you make your submissions, no problem at all. That was also an offense earlier, so you make your submissions, no problem.
After going through that, I'll file a synopsis, but for now, at least let me permit it to clarify.
Please,
what
madam,
was brought.
do it, yes.
My lord, I have also filed one additional objections. It was filed on 10th November. I hope it is before your lordships.
Additional objections are here, yes.
I will only point out, though it is a little bit bulky, I'll point out 22 issues, my lords. That is page number 30 and 31.
30 and 31.
31, yes, my lords. It is the minutes of the second COC meeting, my lords.
Correct.
It was pointed out.
That's
Yes.
what was pointed out now.
Yes, my lords, in which, my lords, it has been stated that Indian Bank appointed, let me read out.
Yes, yes.
Indian Bank appointed Mr. Satya Prakash Mangal and Co.
Yes.
Chartered Accountants, Koramangala, Bengaluru, to carry out forensic audit of corporate data as
Yes.
per the bank norms. On conducting the audit, the firm has submitted its report to the bank, copy of which is also made to the RP. Said forensic audit report covered period from 26/9/2017 to 31/5/2019, where it is commented by auditors that the report is prepared with some limitations, that the borrower may have diverted the funds without quantifying the amount. Forensic auditors did not come across any transaction which in their opinion may be categorically and conclusively termed to be fraud.
Yes.
My lord, in this connection, my lord, there is no such recording in the forensic audit report that the forensic auditor did not find anything towards
Then
fraud.
why did the COC?
COC, my lord, COC, which is headed by this RP, my lord, they have played
So
something.
RP has played mischief?
Yes, my lord. For that purpose, my lord, I request your lordships to come to page 22 and 23 of the same. My lord, in page 22, this RP, who was the previous RP, my lord, page 22, last line, para 5. RP conducted a meeting with former suspended directors on 7/4/22 and discussed about the status of the CD and also stages of ongoing litigations. Further, RP has authorized the suspended director, Mr. So-and-so, to lead evidence on behalf of Steel Hypermart India in all cases filed by the company at his cost. As CIRP is commenced, the RP is in charge of the company. He has to take care of the company's cases. He authorizes Mr. So-and-so to take care. My lord, then he continues, my lord, in para 6. In order to recover the dues from debtors of CD, suspended directors has initiated litigation long before against the debtors in different courts. RP directed the suspended director to continue the process of ongoing litigations. Steps have been taken to continue appointment of Mr. So-and-so as legal counsel. This comes to the next part. My lord, as it is well known in IBC, once the CIRP is initiated and an RP is appointed, he takes over the assets. He is actually run the company. He has to run the company.
Correct.
Here, he has appointed an erstwhile promoter to take care of the cases at his cost. A similar matter has happened in a similar case, my lord, wherein the same promoter has initiated disciplinary proceeding against RP for doing this, allowing to conduct the cases at his cost.
What happened to that?
That he got suspended for 3 years and now it will be commenced. That is a different issue. And for this also complaint has been raised. My lord, this shows there is collusion between the RP and the managing director, which has caused him to make such a remark which was not there in the forensic report for the first, my lord. And then, my lord, this is further recorded in page number 31, my lord, which your lordships had already seen. Page number 31, the paragraph, said forensic audit report. Said forensic audit report covered period from 26/9/2017 to 31/5/2019, wherein it is commented that the auditors, by the said auditors, that the report is prepared, that limitations paragraph I had already read. My lord, coming to the next paragraph, on going through the ABS at 31/3/2020 and PBS at 24/11/21, there is a wide variation in stocks and debtors. This is recorded by this RP. Large number of related party transaction. Corporate data has routed sales through current account outside the lending banks. In view of the above, the chairperson opined, chairperson means the RP, opined that the transaction audit need to be conducted for the period covering 5 years. RP called for EOI from qualified CA firms. Accordingly, following firms have expressed interest in conducting transaction audit. My lord, what it means is that the forensic audit done by the bank, which I am representing, it was by the bankers themselves. It was not part of the CIRP. There was no necessity to bring that inside the COC. Still, they brought it, they commented upon it, and now they are making a representation that whatever conducted first was not right. We are going for second. No. Whatever was conducted by this RP for the period 2020, which is a subsequent period, that is the first forensic audit conducted by this RP. So, in no way, the forensic audit conducted by Indian Bank is wrong. Number one, and whatever they have commented upon is not found in the audit report, which I have already produced before your lordships along with my objections, my lord. This is further clarified, my lord, in page number, my lord, 53, my lord. Page number 53, my lord. It is actually the latest minutes of 9th COC meeting, my lords. In that C, para C.
Status of the forensic audit, yes.
RP, the present RP shared the forensic auditor was appointed in May 22 only by erstwhile RP for conducting audit for a period of 2 years from 18 to till CIRP commencement date. The forensic auditor has submitted only an interim report, and it also observed that many details have not been given as the erstwhile RP did not take custody of such records. My lord, so the first RP which was conducted, that was the first audit report. So the submission that they have gone for the second audit because the first audit was not right, it is absolutely wrong. As far as the bank is concerned, my lord, without going into what has happened before in the CIRP process under IBC, they have independently conducted an audit. They have found certain forensic transactions which shows cheating, wherein amounts have been transferred from the company's account outside to related parties to their own cells and their own companies in other names. So whereby, my lord, based on that, the criminal complaint had been filed, my lord. In view of which, my lord, I request your lordship that this FIR should be upheld. At this juncture, my lord, your lordship.
The charge sheet is already filed.
Yes, my lord. Yes. In the previous, one of the previous hearing, your lordship had asked me as to the entries regarding repayment, my lord. I would like to clarify, my lord, this is a current account, my lord, working capital current account. So specifically, there'll be no entry regarding repayment. It is the money comes in, goes out. And at the time when the interest is debited, if there is an amount, it gets debited. Otherwise, it becomes red. So there is no specific entry for repayment, my lords.
Yes.
My lords, if I may only point out one aspect, my lords, insofar as the argument that was canvassed by my learned friend is concerned, in the application that we have filed under section 482, page number 28, if I may invite my lords' attention.
Which the senior counsel now relied on.
Please, the same document as well, my lord. Page number 28, proceedings in the Shuru Agate Swami. In that, my lords can directly come to voting share of financial creditors. 28, page number 28, my lord.
Yes.
Voting share of financial creditors, Indian Bank, voting share is 78.87%. In no manner can this particular resolution could have been passed without the assent of Indian Bank. If I may invite my Lord's attention to that particular resolution which the learned senior counsel pointed out, page number 41 nalide Swami. ಅದರಲ್ಲಿ vote anyone, assent, dissent, abstained ಇದೆ. Please. 41 ನಲ್ಲಿ particulars, assent, dissent ಅಲ್ಲಿ ನೋಡ್ಬೋದು ಸ್ವಾಮಿ 100%. Indian Bank has consented to it. At this point of time, coming and making allegations as against the RP is unsustainable, my lords. That's all, my lords.
And my lords, after 5 years, I'm grateful to my learned friend for pointing this out. After 5 years where they are the chairing it, it's not the RP who runs the COC, my lords. The COC is an independent body, your lords are more than aware of it. And they have taken this decision. I'm grateful.
Heard the learned senior counsel or
Mr. Vaibhav.
Then learned senior counsel Sushila, and the learned counsel Chitra Nirmala representing the complainant Indian Bank. The learned counsel P. Prasanna Kumar representing the CBI submits the pursuant to the investigation conducted by the CBI QA, the FIR so registered. The CBI has now filed its charge sheet. All other offences that were alleged in the FIR have been dropped, and the only offence sustained while filing the charge sheet is the offence punishable under section 420 of the IPC. In that light, the learned counsel seeks a week's time.
2 weeks time.
2 weeks time to place the charge sheet so filed or numbered before this court on the next date. List the matter on 6th January. Interim order idega? Protection. The interim protection that is subsisting as on today shall continue till the next date of hearing.
Great.
Now that we have filed report, we will not even call them or arrest them. They may have to
whatever protection is there.
Await orders of this.
Because Apex Court itself had granted protection. Yes.
Very grateful.
Sixth, yes. So further here.
My lord, am I permitted to file the synopsis after sir's filing of charge?
No problem. Yes. Now it boils down to 420. We'll concentrate on that. Yes.
28.
ಕೊಡಿ ಇವತ್ತು ಮುಗಿಸ್ಬೋಣ ಇದ್ದ
kindly pass over, my lord, senior in court hall 1.
ಕುಮಾರ್ ಇದ್ರ ಈಗ
He's in court hall 1, my lord.
let him come. You start ಮಾಡ್ರಿ ಬರ್ಲಿ ಇವತ್ತು ತೊಂದರೆ ಇಲ್ಲ. Yes sir.
First of the petitions, my lord,
First is 12441.
Yes. That seeks quashing of the proceedings initiated by the ROC, my lord, before the trial.
Yes, sir.
Lord, without troubling your lordships too much, my lord, I have filed a synopsis with a list of dates on 7th August 24.
It's here, yes.
And at the bottom of the first page, Lord, on 10/10/2011, this company came to be incorporated. Petitioner, my lord, was a director for about 4 months, less than 4 months. Lord, he is an auditor, my lord, by profession. He was requested, my lord, by one of the promoters to be a director because they didn't have the DIN number for some time. They got it, my lord, and he resigns on 29/2/2012. The form 32 is at annexure B we have produced. Then, my lord, the company admittedly, even in as stated, my lord, by the respondent in their complaint, company's operations started only in the financial year 2013-14, much after I resigned. Then, my lord, there are various proceedings later initiated based on complaints received from the public. My lord, Economic Offences Wing Mumbai initiates proceedings, issues notice to the petitioner. He replies, and then, my lord, a charge sheet is filed without the petition.
Correct. You are not the accused.
Yes. Similarly, my lord, CID Bangalore also initiates proceedings. On my reply, I am again not an accused in the charge sheet.
Yes.
Then, my lord, this LOC comes to be issued. That is on page 4.
That's challenged in the companion petition.
Companion petition.
Yes.
My lord, at serial number 8, the show cause notice, which is presently the subject matter of this case, my lord, is issued to me. I issue a reply on 8/11/2021. The complaint is filed on 30/7/22. In the complaint, my lord, there is no averment as against the petitioner. It simply says so and so are former directors. In the reply to the show cause notice, the petitioner himself says, I resigned within 4 months and then I was auditor for a limited period. The complaint does not array me as accused on the basis that I was an auditor of this company. Then, my lord, one other charge sheet is also filed by the Economic Offences Wing of Hyderabad, which I have filed along with my memo on 7/6/24. Alli kuda after my reply, I am not an accused. My lord, the submissions are that the petitioner ceased to be a director much before the operations commenced. And my lord, the prosecution under section 447 and 448 of the New Companies Act is not relatable to the petitioner because they came into force subsequent to his resignation.
That's 2012, this is 2013.
13, yes. Lord, then your lordship's judgment we have cited. Article 20, your lordship goes into ex post facto and quashes the proceedings.
Ashana?
Covered, my lord, your lordship.
Lord, I have informed he's on his way, my lords.
One other judgment, my lord, which we have cited, which we have filed along with this at page 64, my lord. Similar, my lord, proceedings were initiated in respect of this QNet company that is also quashed.
This is Anand Barare.
Yes, page 64. They have served as one copy of statement of objections now, my lord, yesterday. After all these years.
Today we filed statement of objection.
3 years admele. I want to go through it or?
No, I have gone through it, my lord. There's really nothing to say.
Pass over. Ask him to come.
Great.
We'll finish this today. LOC is an offshoot of this.
Yes, my lord.
Yes.
29.
Just one submission, my lord, on LOC.
29. ನೀವಿದ್ದೀರ ಅದರಲ್ಲಿ ಎಸ್ ಎಸ್ ಅವ್ರು ಮುಗಿದ್ಮೇಲೆ ಮಾಡಿ ಕುಮಾರ್ ಮುಗಿಸ್ಬಿಡ್ಲಿ ಮುಗಿದ್ಮೇಲೆ ಮಾಡಿ LOC. But today we'll finish it. Yes. Next.
That's
Unnikrishnan.
The respondent, my lord, 29.1. Last time it got adjourned for the reason that 29.1 is the predicate offense, which is based on a complaint given by certain home buyers, my lords, against a set of 44 people. If that gets decided, that's 29 would automatically fall.
Correct. This is ED proceedings.
Please, my lords. That there are.
Now, who appears in that?
That's that petitioner advocate is not there today. I'm sorry.
That's really counsel on records. Mother is not feeling well. He's gone to his native.
Anyway, there are 4 other matters also which needs to be connected pertaining to similar transaction, same transaction.
Give it.
That only one is pertaining to the same FIR. The others are all different.
Tag this, heard the learned counsel Mahesh Chowdhury appearing for the petitioner in criminal petition 3113 of 2023. The learned counsel representing the petitioner in WP 9468 of 2022 has some inconvenience today. The said petition challenges the offences alleged under the IPC, which forms the predicate offence for drawing up an offence in criminal petition 3113 of 2023 by the Enforcement Directorate. Therefore, the said petition challenging the predicate offence will have to be heard. The learned counsel for the respondent complainant submits that there are 4 more matters to be tagged along with this. They arise out of the same transaction. Tag this petition along with so and so. List them all on 8th January. Interim order subsisting will continue till the next date of hearing.
In my note, there's no offense. Show cause notice is being challenged under the ED. That is
ED da? Sir. ಅದರಲ್ಲಿ ಈಚೆಗೆ ED ಇದರಲ್ಲಿ 3113 of 2023 ಅಲ್ಲಿ what is challenged is a show cause notice. Show cause notice issued by the Enforcement Directorate based on the predicate offence in ಅದು ಕೊಡಿ ನಾನು ಮಾಡ್ಕೊಡ್ತೀನಿ.
30.
This matter, my lords. This pertain to the secondary evidence, my lords. Your own lordship's
ಅವ್ರು
judgment.
ಬರಲೇ ಇಲ್ಲ.
Or ಬರ್ತಾನೆ ಇಲ್ಲ.
ಕೊಡಿ ಮುಗಿಸ್ಬೋಣ.
Please, my lords.
Order sheet is growing more than the petition.
I'm sorry. This is your own lordship's judgment, my lord, to rectify the error, my lords. Because your lordship has observed that.
I've already recalled it.
Order is not recalled, my lords.
Order
Order is recalled, but it's still not.
Idén
disposed.
ಬೇಕಾಗಿಲ್ಲ
Please,
ಈಗ.
my lords.
Order
I
is
just got to the
recalled
notice,
now.
my lords. The only thing is that, my lords, your lordship has observed that the document is under the custody of the complainant who is the petitioner herein. It is specific denial before the trial court is that the document itself is not executed. And even if lordship sees for a moment, my lords, he has got notarized the document.
ಈಗ ರಿವ್ಯೂ ಹಾಕಿದ್ರೆ ಏನಿದು?
ಇಲ್ಲ,
ರಿವ್ಯೂ
ಅದ್ರಲ್ಲಿ-
ಹಾಕಿದ್ರ ಫಸ್ಟ್?
ಏನು ಹಾಕಿಲ್ಲ. ಇದನ್ನೇ ಮೆಮೊ ಫಾರ್ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು ಹಾಕೊಂಡು
ಸ್ಪೋಕನ್ ಟು ರೀಕಾಲ್ ಮಾಡ್ಬೋದು.
Please, my lords.
This I am aware.
Please, please.
Child pornography.
Please. My own main condition was that, my lords, he has produced the notarized.
What's happening before the trial court?
It's getting urgent, my lords. It's posted for first week of January.
Will pass orders, will take it as heard.
Please, my lords.
The heard the learned counsel appearing for the petitioner. The respondent is not present and has not been present throughout these proceedings. In that light, the will say not disposed, reserved.
Please,
yes.
Oblige, my lords. The only contention is that document is not under the custody
That's
of
the
the
only
company.
contention.
Please.
We'll see the last.
But your lordship observed that it is the contention that it is under his custody. On that, isn't it? Please. Grateful, my lords.
31.
This one number 2, mate.
7A.
Yes, my lord.
Huh.
Lord, I would like to pass on the synopsis and one judgment, my lord, of your lordships has been.
ಎಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ರಿವರ್ಸ್ ಆಗಿ ವಾಪಸ್ ಬಂದಿದೆ.
ಇಲ್ಲ, ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ.
ಕನ್ಫರ್ಮ್.
Page 57.
ಯಾವ್ದು ಕನ್ಫರ್ಮ್ ಆಗಿರೋದು?
57, page 57, my lord. Similar matter.
Because I followed Justice Hemant's order. ಇದು ಕನ್ಫರ್ಮ್ ಆಗಿದೆಯಾ 57?
Next page is the your lordship's order.
ಧಾರವಾಡದ್ದು.
Dharwad. Other two matters, my lord, that also have been confirmed by the Supreme Court, by the Lordship Chairman Chandran Gowda, my lord, and Lordship Trajan.
ಮತ್ತೆ ರಿವರ್ಸ್ ಆಗಿರೋದಲ್ಲ ಯಾವುದು?
ಬೇರೆ matters. This was not before the same judge.
13
my lord,
one day
lordship.
irbekeno.
This is a case where, my lord, no trap, no demand, no acceptance, and no conversation. Well, the conversation.
Your accused number?
2, my lord. Conversation was with the accused number 1, constable. I being the police sub-inspector, my lord.
Yes, sir. Ready. You ready?
Yes.
I am ready.
Yes. Lord, FIR came to be registered, my lord, on produce the complaint copy.
FIR?
412, my lord, 4/12/2019. FIR came to be registered with an allegation that the incident has happened on 13 November 2019, my lord, that the FIR was registered against the complainant and another, my lord, where there was a dispute with regard to the property dispute, my lord. Then, my lord, accused number 1 has complainant has approached accused number 1, and then accused number 1 has demanded 1 lakh to file B report. Lord, in that relation, my lord, he has complained to the present petitioner that accused number 1 is demanding so and so. That is the allegation. Apart from that, my lord, there was no trap and there was no demand by this petitioner, and there was no, my lord, phone conversation between the petitioner and the complainant. Later, my lord, the FIR came to register after 26 days against the accused number 1 to 3, saying that they have demanded the rupees 1 lakh from the complainant. And charge sheet was filed, my lord, against the complainant, lord.
Against the complainant?
Yes, my lord. There was a FIR was registered against the complainant, my lord. For in that connection, my lord, that there was a demand by the accused number 1 and the petitioner. But as per the complaint government itself, is very clear that accused number 1 himself has demanded 1 lakh from the complainant, not by this petitioner.
You are accused number 2?
Yes, my lord. In that light connection, my lord, I have challenged the FIR whether protection was granted. given synopsis, my lord, where there are totally 9 cases were registered against the complainant.
In page number 16, my lord. Column number 9 ಅಲ್ಲಿ ಫಿರ್ಯಾದಿಯವರು ನೀಡಿದ ಅಸಲು ದೂರಿನ ಪ್ರತಿ ಹಾಗೂ ದೂರಿನೊಂದಿಗೆ ಫಿರ್ಯಾದಿಯಾಗಿ ಆರೋಪಿತನ ಸಂಭಾಷಣೆಯ ಸಿಡಿಯನ್ನು ಲಗತ್ತಿಸಿರುತ್ತೇನೆ ಅಲಾಂಗ್ ವಿತ್ ಕಂಪ್ಲೇಂಟ್. ನಮ್ಮ ಜೊತೆ ಏನ್ ಕಾನ್ವರ್ಸೇಷನ್ ಆಗಿದೆ ಆ ಸಿಡಿ ಆಲ್ಸೋ ಪ್ರೊಡ್ಯೂಸ್ ಬಿಫೋರ್.
ಇವ್ರ ಜೊತೆ ಕಾನ್ವರ್ಸೇಷನ್ ಆಗಿದೆ.
ಇವ್ರ ಜೊತೆ ಪ್ಲಸ್ ಕಾನ್ಸ್ಟೇಬಲ್ ಇವ್ರ ಜೊತೆ ಕಾನ್ವರ್ಸೇಷನ್.
ಅಲ್ಲ ಇವರೇ ಕಾನ್ಸ್ಟೇಬಲ್.
ಪ್ರೊಡ್ಯೂಸ್
ಅಲ್ಲ ಇವರು ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್.
ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ along with produced along with complaint jothe produce ಮಾಡಿದ್ದೀವಿ conversation voice conversation ಎಲ್ಲಾನು ಇದೆ. everything has been produced and produced.
ಟ್ರ್ಯಾಪ್ ಆಯ್ತಾ?
ಅನ್ಸುತ್ತೆ
ಟ್ರ್ಯಾಪ್ ಮಾಡಿದ್ರ?
ನೋ ಟ್ರ್ಯಾಪ್. ಟ್ರ್ಯಾಪ್ ಆಗಲಿ ಇದರಲ್ಲಿ ಇಲ್ಲಿ say I am file objections along with some documents my lord.
sir. yes ಹೇಳಿ sir.
Ink page number 8 my lord. Ink page number 8.
ಮಾಹಿತಿ.
The petitioner has filed a charge sheet against the respondent number 2 and 21/10/2019 ಅಲ್ಲಿ ನಮ್ಮ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗ್ತದೆ. As per the evidence, we have filed one RT application before the SG police station. Kindly see the last column number 2 ನಲ್ಲಿ ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಶ್ರೀ ಪ್ರಭುಗೌಡ PSI ಅವರು ದಿನಾಂಕ 20/10/2019 ರಂದು ಅನುಮತಿ ರಜೆ ಹಾಗೂ ದಿನಾಂಕ 21/10/2019 ರಿಂದ 24/10/2019 ವರೆಗೆ 4 ದಿವಸ ಆಕಸ್ಮಿಕ ರಜೆಯಲ್ಲಿ ಇರ್ತಾರೆ. ಆಕಸ್ಮಿಕ ರಜೆ. ಈ ಡ್ಯೂರಿಂಗ್ ದಿಸ್ ಟೈಮ್ ಅಲ್ಲಿ ಕೈಲಿ ಸಿ ದಿ ವೆರಿ ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಮ್ದು ಕೈಲಿ ಸಿ ದಿ
ಆಕಸ್ಮಿಕ ರಜೆ ಟೈಮಲ್ಲಿ ನಿಮ್ಮ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗ್ತದೆ.
ಆಕಸ್ಮಿಕ ರಜೆಯಲ್ಲಿ ನಮ್ಮ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ತಾರೆ. ರೆಕಾರ್ಡೆಡ್ ಸಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್.
ಅಲ್ಲ ಅದು ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿಲ್ವಾ?
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ.
ಅದು ಯಾವ ಪಿಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಈ ಪಿಟಿಷನ್ ಅಲ್ಲ, ನಾವು ಆರ್ ನಾಟ್ ಚಾಲೆಂಜಿಂಗ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ಸ್. ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಡೀತಾ ಇದೆ. ಹೇಳಿ ಸಿ ದಿ ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 16 ಮೈ ಲಾರ್ಡ್. ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 16 ಅಲ್ಲಿ ಹೇಳಿ ಡೇಟ್ ಆಫ್ ದಿ PF ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕಳಿಸಿದ ಸ್ವತ್ತಿನ ಪಟ್ಟಿ 21/10/2019. ಪ್ರಭು this petition was signed and very next documents Mazar was conducted 21/10 during the ಯಾವಾಗ ರಜಾ ಆಕಸ್ಮಿಕ ರಜೆ ಯಾವಾಗ ತಗೊಂಡು ಆ ಟೈಮಲ್ಲೇ ಕೃತ್ಯ ನಡೆದ ಸ್ಥಳದ ಪಂಚನಾಮೆ 21/10/2019 and very next page ಮಾಜರ್ ಅನ್ನು ದಿನಾಂಕ 21/10/2019 ರಂದು ದಿನ ಬೆಳಿಗ್ಗೆ 11:30 ಗಂಟೆಯಿಂದ 12:30 ಗಂಟೆವರೆಗೆ ಮಾಜರ್ ಮತ್ತು ಲ್ಯಾಪ್ಟಾಪ್ ನಲ್ಲಿ ಟೈಪ್ ಮಾಡಿ ಪ್ರಿಂಟರ್ ತೆಗೆದು so and so ಯಾರು in front of the petition this petitioners. Very next documents is recording one statement on 21/10/2019 ಅಲ್ಲೂ ಒಂದು ವಿಟ್ನೆಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅನ್ನು ರೆಕಾರ್ಡ್ ಮಾಡ್ತಾರೆ. ಆಲ್ ದ ಎಂಟೈರ್ ಚಾರ್ಜ್ ಶೀಟ್ ಆನ್ 24/10 ಒಳಗಡೆ ಮುಗಿಸ್ಬಿಟ್ಟು ಫೈಲ್ ಮಾಡ್ಬಿಟ್ಟು ಹೋಗ್ಬಿಟ್ಟು
ಹೇಳಿ. ಅದೆಲ್ಲ ನಿಮ್ಮ ಮೇಲೆ ಮಾಡಿರೋದು
ಅಲ್ಲ ಸರ್, ದಟ್ ಇಸ್ ಜನರಲ್ ವೈ ಐ ಆಮ್ ಅವರು ಹೇಳ್ತಾ ಇರೋದೇನಂದ್ರೆ ನಮ್ಮ ಮೇಲೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಫೀಸರ್ ದಟ್ ಇಸ್ ದ ರೀಸನ್ ಫಾರ್ ಫಾಲ್ಸ್ ಅಲಿಗೇಷನ್ ಅಂತ ನಮ್ಮ ಮೇಲೆ ಹೇಳ್ತಾರೆ.
ಆಯ್ತು, ನಿಮ್ಮ ಮೇಲೆ ಮಾಡಿರೋ ಕೋಪಕ್ಕೆ ನೀವು ಮಾಡಿದೀರಾ ಅಂತ
ಅವರು ಹೇಳ್ತಾರೆ. ದಟ್ ಇಸ್ ದ ರೀಸನ್
ನೋಡಿದ್ರೆ ಸ್ವಲ್ಪ ಅಲ್ಲಿಗೆ ಹೆಚ್ಚು ಕಮ್ಮಿ ಬರುತ್ತೆ.
That is the reasons very direct evidence against these petitioners. Kindly dismiss the petition below.
All right, direct evidence. Yes sir.
My lordship, in complaint, my lordship, page number 21, my lordship. There is a demand here.
Demand ಎಲ್ಲಿದೆ ತೋರಿಸಿ.
22, my lordship, 22, page number 22.
22,
my lordship.
ಟ್ರ್ಯಾಪ್ ಮಾಡಿದ್ರ?
ಪಾಟೀಲ್ ಅವರು ವಕೀಲರು ಇದನ್ನು ವರದಿ ಮಾಡುವುದೇ
ಡಿಮಾಂಡ್ ಆಯ್ತು. ಆಕ್ಸೆಪ್ಟೆನ್ಸ್
ನೋ ಟ್ರ್ಯಾಪ್.
ಟ್ರ್ಯಾಪ್ ಇಲ್ಲ ಅಂದ್ರೆ ಆಕ್ಸೆಪ್ಟೆನ್ಸ್ ಎಲ್ಲಿಂದ ಬಂತು?
there is a demand.
ಓನ್ಲಿ ಡಿಮಾಂಡ್, ನೋ ಆಕ್ಸೆಪ್ಟೆನ್ಸ್, ಓನ್ಲಿ ಆಕ್ಸೆಪ್ಟೆನ್ಸ್, ನೋ ಡಿಮಾಂಡ್ ಎರಡು ಹೋಯ್ತು. ಡಿಮಾಂಡ್ ಅಂಡ್ ಆಕ್ಸೆಪ್ಟೆನ್ಸ್ ಇರ್ಬೇಕು. ಎನಿವೆ ಅವ್ರೇನೋ ಹೇಳಿದ್ದಾರೆ. ಸಿ ಹಾರ್ಡ್ ರಿಸಲ್ಟ್ ಮಾಡಿದ್ಯಾ? Subsisting will continue till the disposal of the petition.
Grateful.
Yes. Next. 30.
Yes, for the petitioner. Senior is not well, madam. Is that? This case, madam. Senior is not well, madam. I have next
Not
week,
well.
Hospitalized.
Hospital. The learned counsel appearing for the petitioner submits that the petitioner is unwell. The counsel, arguing counsel is unwell, lists the matter on 8 Jan. Interim auditor continues. Next.
33.
I represent the state.
Represent the state.
Special counsel, my lord.
Prosecutor ಮಾಡಿದ್ದಾರೆ.
Individual capacity, my friend appears and opposes bail. Now, my lord, a special counsel has been engaged. Anyway, my lord, I will go on with the merit.
Yes, one.
Yes. My lord.
Lord, may I just seek one indulgence, my lord? May I just seek one indulgence, my lord?
Allow ಮಾಡ್ಬೇಕಷ್ಟೇನಾ?
ಇಲ್ಲ interim order ಅವರಿಗೆ already ಕೊಟ್ಟಿದ್ದೀರಿ. ಇದ್ರಲ್ಲಿ I am bit under the weather today. I am not well. If your lordships could kindly have it on some other day, my lord, I'll sum up.
You are under the weather.
ಸ್ವಲ್ಪ ಆರೋಗ್ಯ ಸರಿ ಇಲ್ಲ. ಇಲ್ಲ ಅಂದ್ರೆ my lord, I wouldn't have lost an opportunity to personally appear before your lordship.
All right. ಇದು interim 498A.
ಅಲ್ಲ 304B. My lord, suicide note ಇದೆ. Page 57 suicide note. The lordship kindly to see the suicide note, my lord.
ಅದಕ್ಕೆ stay ಕೊಟ್ಟಿರೋದು. That's page 25.
My lord, in the second matter, my lord, I appear. There are two matters, my lord.
You ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ appear ಆಗ್ತಿರೋದು? ಪ್ರವೀಣ್ MT.
In the second matter, my lord, 33.1.
Vacating stay ಯಾರು ಹಾಕಿರೋದು?
ನಾವೇ.
My friend.
ಹೌದಾ?
Second respondent ಅವರಿಗೆ ಕಂಪ್ಲೇಂಟ್
ಎರಡು ಒಟ್ಟಿಗೆ ಕೇಳ್ಬೋಣ. The learned senior counsel MS Shyam Sundar ಈ ಕಂಪ್ಲೇಂಟ್ಗೂ ನೀವೇನಾ?
ಇಲ್ಲ ಕಂಪ್ಲೇಂಟ್
Totally, my lord, in violation of the law.
ಇಲ್ಲ ವಂದನಾ PL is your colleague.
Yes.
Generally, my lord. Generally.
ಅದೇನು ಸ್ಪೆಸಿಫಿಕಲಿ ಜನರಲಿ ಬೇರೆ ಇದೆಯಾ ಕೊಲೀಗ್ಸ್ ಅಲ್ಲಿ?
In fact, my friend appeared in the bail application.
ಅಲ್ಲ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ನ ಸ್ಪೆಸಿಫಿಕ್ ಕೇಸ್ ಎಂಗೇಜ್ ಮಾಡೋದು ನೋಡಿದೀನಿ. ಕೊಲೀಗ್ ಸ್ಪೆಸಿಫಿಕ್ ಕೇಸ್
The matter Supreme Court came. Yes. One of the matters Supreme Court came heavily on the same set of facts.
ಹೌದು, ಇಟ್ಸ್ ನಾಟ್ ಕರೆಕ್ಟ್. ಇಲ್ಲ ಯು ಹ್ಯಾವ್ ಟು ಚೇಂಜ್ ವಂದನಾ ಆರ್ ಯು ಹ್ಯಾವ್ ಟು ಚೇಂಜ್ ಯುವರ್ ಸೆಲ್ಫ್.
I prefer the second thing.
Change yourself so that you can appear for the complainant.
ಅಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರ ಹತ್ರನು ಹೇಳ್ತಿದ್ರು ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಸ್ಪೆಷಲ್ ಪಬ್ಲಿಕ್ ಪ್ರಾಸಿಕ್ಯೂಟರ್ಸ್ ಆಗೋ ಹಾಗಿಲ್ಲ ಅಂತ. I want to be, my lord, fair to the honorable court. ನಾನು ಹೇಳ್ದೆ
We have no problem. Let him appear, my lord. We have no problem. The entire case is on the suicide note.
Vipin cannot say if Vipin don't want me in the matter, my lord, let him take that call. I don't mind.
ಇಲ್ಲ who is court wants you, sir.
At the end of the day, my lord, for whatever Jagdish, my learned friend Jagdish said, we are all, my lord, serving the cause of justice. There is nothing beyond.
All right, sir. When you are on this side, serving the cause of the accused.
Serving the cause of justice.
Yes. At the learned counsel Bipin Hegde appearing for the petitioner. Learned special public prosecutor. Special public prosecutor MS Shyam Sundar seeks a week's time on the score that he is indisposed today. Lists the matter on 8th January.
9th or 10th.
9th, okay. 9th Sunday.
8th time. Some difficulty.
9th Friday. Yes, 9th January. Interim order subsisting would continue till the next date of hearing. It's made clear no further adjournment would be granted in the matter.
Greatly obliged.
Yes, sir. Take care.
I'm honored, my lord. I'm honored.
Yes, sir.
34.
I appear for the petitioner in 34.1 and 34.6. Petitioner in 34.1 is accused number 21, your lordship, and the next petition at 34.6 is accused number 11. Both have been implicated based on the voluntary statement of accused number 2.
Offense,
your lordship, as per the charge sheet is 471, 120B, 406, 408, 409, 420, 465.
except the voluntary statement, no other corroborative material.
No, your lordship. May I take your lordships to the complaint at page 21 of my petition, your lordship? The allegation as per the complaint is, the complainant is a Tahsildar.
What are you?
I am a common man.
Common man. All right.
The allegation as per the complaint, your lordship. May I read the complaint, page 21. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ GH ಸತೀಶ್ ಕುಮಾರ್, he is accused number 1. ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕರು ಆಗಿ ಗುಬ್ಬಿ ತಾಲೂಕ್ ಕಚೇರಿಯಲ್ಲಿ ಈಗ 2007ನೇ ಸಾಲಿನಿಂದ ಜೂನ್ 22ರ ಅಂತ್ಯದವರೆಗೆ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ್ದು, ಅವರ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದ ವೇಳೆಯಲ್ಲಿ ಗುಬ್ಬಿ ತಾಲೂಕ್ ಕಚೇರಿಯಲ್ಲಿ ಮುಜರಾಯಿ ಆರಾಧನಾ NCR RKL ರೆಕಾರ್ಡ್ ರೂಮ್ ಶಾಖೆಗಳಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ್ದು, ಹಾಲಿ ಇವರು ಗುಬ್ಬಿ ತಾಲೂಕ್ ಚೇಳೂರು ಹೋಬಳಿ ನಾಡ ಕಚೇರಿಯಲ್ಲಿ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕರಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುತ್ತಾರೆ. GH ಸತೀಶ್ ಕುಮಾರ್ ಅವರು ಈ ಹಿಂದೆ ಗುಬ್ಬಿ ತಾಲೂಕ್ ಕಚೇರಿಯ ರೆಕಾರ್ಡ್ ರೂಮ್ ನಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ್ದು, ಹೀಗೆ ಒಂದು ವಾರದ ಹಿಂದೆ ಗುಬ್ಬಿ ತಾಲೂಕ್ ರೆಕಾರ್ಡ್ ರೂಮ್ ನಲ್ಲಿನ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ 1995ರಿಂದ 2000 ಕೈ ಬರಹದ ಪಾಣಿಗಳಲ್ಲಿ, ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್ ಯೋರ್ ಲಾರ್ಡ್ಶಿಪ್, ಕೈ ಬರಹದ ಪಾಣಿಗಳಲ್ಲಿ ಗುಬ್ಬಿ ತಾಲೂಕಿನ ಕೆಲವು ಸರ್ಕಾರಿ ಜಮೀನಿನ ಸರ್ವೆ ನಂಬರ್ಗಳ ಪಾಣಿಗಳಲ್ಲಿ ಅನಧಿಕೃತವಾಗಿ ಸರ್ಕಾರದ ಯಾವುದೇ ಆದೇಶವಿಲ್ಲದೆ, ಯಾವುದೇ ಮಂಜೂರಾತಿ ಇಲ್ಲದೆ ಖಾಸಗಿ ವ್ಯಕ್ತಿಗಳ ಹೆಸರುಗಳನ್ನು ನಮೂದು ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತೆ. 1972ರಿಂದ 73ನೇ ಸಾಲಿನ ದರಖಾಸ್ತು ವಿತರಣಾ ವಹಿಯಲ್ಲಿ ಹಾಗೂ ಮ್ಯೂಟೇಷನ್ ರಿಜಿಸ್ಟರ್ ನಲ್ಲಿಯೂ ಸಹ ಖಾಸಗಿ ವ್ಯಕ್ತಿಗಳ ಹೆಸರುಗಳನ್ನು ನಮೂದು ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಸದರಿ ಸರ್ಕಾರಿ ಜಮೀನನ್ನು ಕಬಳಿಕೆ ಮಾಡಿ ಮೋಸ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಮೇಲ್ಕಂಡ ಕೆಲವು ದಾಖಲಾತಿಗಳಲ್ಲಿ ಅಧಿಕಾರಿಗಳ ಸಹಿಗಳನ್ನು ನಕಲು ಮಾಡಿರುವುದು ರೆಕಾರ್ಡ್ ರೂಮ್ ನಲ್ಲಿನ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಸದರಿ ಕೃತ್ಯದಲ್ಲಿ ಈ ಹಿಂದೆ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ GH ಸತೀಶ್ ಕುಮಾರ್ ಹಾಗೂ ಇತರೆಯವರು ಭಾಗಿಯಾಗಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ತಾವುಗಳು ಮೇಲ್ಕಂಡ ಸತೀಶ್ ಹಾಗೂ ಪ್ರಕರಣದಲ್ಲಿ ಭಾಗಿಯಾಗಿರುವ ಇತರೆ ವ್ಯಕ್ತಿಗಳ ವಿರುದ್ಧ ಕಾನೂನು ರೀತಿಯ ಕ್ರಮ ಜರುಗಿಸಬೇಕೆಂದು ತಮ್ಮಲ್ಲಿ ಕೇಳಿಕೊಳ್ಳುತ್ತೇನೆ. This is the complaint. According to the complaint, this Satish Kumar, who is accused number 1, along with other government officials, he has inserted few names of publics in the old registers pertaining to the year 1995 to 2000. Allegation on accused number 21 is he has got his mother and sister's name entered in one of those registered. There is a document of the very DC which gives a list of the names whose names have been inserted, your lordship, and there is an observation against the names of the sister and mother of the petitioner that their names are not found in that. Apart from this, your lordship, may I take your lordship to the column number 17.
Come to page 185.
185.
Yes. 185, you are 821.
Yes, your lordship.
Last paragraph.
This is what. ಈ ದೋಷಾರೋಪಣಾ ಅಂಕಣ 12ರಲ್ಲಿ ನಮೂದಿಸಿರುವ ಆರೋಪಿ 21 ಅಣ್ಣಪ್ಪ ಸ್ವಾಮಿರವರು ಗುಬ್ಬಿ ತಾಲೂಕು ಹಾಗಲವಾಡಿ ಗ್ರಾಮದ ಯಕಲ್ಕಟ್ಟೆ ಸರ್ವೆ ನಂಬರ್ 31ರ ಸರ್ಕಾರಿ ಜಮೀನಲ್ಲಿ ತಾನಾಗಲಿ ಅಥವಾ ತನ್ನ ಕುಟುಂಬದ ಸದಸ್ಯರಾಗಲಿ ಯಾರೂ ಸಹ ಅಧಿಕೃತ ಸಾಗುವಳಿದಾರ ಅಲ್ಲದೆ ಇದ್ದರೂ ಸಹ ಆರೋಪಿ 21 ರವರು ಈ ಪ್ರಕರಣದ ಆರೋಪಿ ಕರಿಯಣ್ಣರವರ ಜೊತೆ ಶಾಮೀಲಾಗಿ ಯಕಲಕಟ್ಟೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 31ರಲ್ಲಿ ಇರುವ ಸರ್ಕಾರಿ ಜಮೀನನ್ನು ಕಬಳಿಸುವ ಉದ್ದೇಶದಿಂದ A2 ಕರಿಯಣ್ಣರವರಿಗೆ ಆನ್ಲೈನ್ ಬ್ಯಾಂಕಿಂಗ್ ಮೂಲಕ 3.5 ಲಕ್ಷ ರೂಗಳನ್ನು ಸಂದಾಯ ಮಾಡಿ ತನ್ನ ತಾಯಿ ಗೌರಮ್ಮ ಕೋಂ ನಾರಾಯಣಪ್ಪ ಹಾಗೂ ಅವರ ಹೆಸರಿಗೆ ಯಕಲಕಟ್ಟೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 31ರಲ್ಲಿ 4 ಎಕರೆ 2 ಗುಂಟೆ ಸರ್ಕಾರಿ ಜಮೀನು ಹಾಗೂ ತನ್ನ ಅಕ್ಕ ಶಾಂತ ಬಿನ್ ನಾರಾಯಣಪ್ಪರವರಿಗೆ ಹೆಸರಿಗೆ ಇದೇ ಯಕಲಕಟ್ಟೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 31ರಲ್ಲಿ 4 ಎಕರೆ ಜಮೀನು ಸರ್ಕಾರಿ ಜಮೀನು ಇರುವಂತೆ ದರ್ಖಾಸ್ತ್ ರಿಜಿಸ್ಟರ್, MR ರಿಜಿಸ್ಟರ್ ಮತ್ತು ಕೈಬರದ ಪಾಣಿ ರಿಜಿಸ್ಟರ್ಗಳಲ್ಲಿ ಹೆಸರುಗಳನ್ನು ಸೇರಿಸಿ ಸರ್ಕಾರಕ್ಕೆ ಮೋಸ ಮಾಡಿ ಸರ್ಕಾರಿ ಜಮೀನನ್ನು ಕಬಳಿಸಿರುತ್ತಾರಂತ ಆರೋಪಿ ವಿರುದ್ಧ ಈ ದೋಷಾರೋಪಣಾ ಪಟ್ಟಿ. Lordship, A2, who is Karyanna, who is an ex.
Correct. You are the beneficiary.
I'm not the beneficiary. Then? Allegation is my mother and sister's name has been inserted. And there are witnesses CW 25 to 45 who say that these people, Karyanna and other accused, have collected money from them saying, ನಿಮ್ಮ ಹೆಸರಿಗೆ ಜಮೀನ್ ಮಾಡಿಸಿ ಕೊಡ್ತೀವಿ ಅಂತ ಒಬ್ಬೊಬ್ಬರ ಹತ್ರನು 10,000 20,000 ಹತ್ರ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. If this has to be believed, your lordship, if for the sake of argument, if I say Ali accused has given money, then all those 25 witnesses who agree that yes, I have given money, ನನ್ನ ಹೆಸರನ್ನು ಜಮೀನಿಗೆ ಸೇರಿಸೋದಕ್ಕೆ ನಾನು ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತಂದ್ರೆ, when they should have been made accused. They have all been made witnesses. Now, accepting the voluntary statement, they speak of one bank transaction wherein 2 lakhs rupees has been
Online
transferred.
banking 3,50,000 ರೂಪಾಯಿ
2 lakhs has been transferred from my account to Karyanna because Karyanna acted as a broker in one of the joint venture which he introduced me to the party. I have also produced bank transaction statement of the said transaction, your lordship. In 1.5 laksha, the bank statement of Karyana is taken where it only says Annappa anta. Whether that Annappa is the same as petitioner is not been investigated into. Just because the name is shown, they implicate me. And the name of accused, the petitioner was taken on 3/7/22 itself. But in all the remand applications which were filed before the court from 4/7/22 to till the filing of the charge sheet, petitioner was not made an accused. He comes to be an accused only at the time of filing of the charge sheet. He was not taken into custody. He
No,
was
that's
not
not it.
investigated.
There is no bar.
There's no bar ownership. The name has been disclosed. He's not even shown as an accused.
Now, on whose voluntary statement you are in?
A2.
Where is the statement?
A2, I have filed the additional document, Your Lordship. The charge sheet I have filed. Charge sheet ali page 457 in the starter. Documents dated 29th August, Your Lordship. Idrali page 457. Voluntary statement of A2 starts. Ala 247. 240. I'm sorry, 247, Your Lordship.
Madam. Ah, 240?
247, it starts, Your Lordship. At 248, last para, he speaks of all the persons he conspired with. The name of the petitioner does not find a place here. He has not participated in the conspiracy. Page
Yes.
48, 248, Your Lordship, last para. Nanu, Satish Kumar, and the others. That is A2, A1, 4, 6, 7, 8, 17, and 5. These are all the government officials who have allegedly conspired to commit this offense. The name of the petitioner comes at page
256.
256, Your Lordship,
Yes.
second para. Here, he does not say how the petitioner even approached him. Because whether this word was spread across, that the officials are getting name inserted, and he does not even mention on which day he has received any money also. Random reference is given. May I read that para, Your Lordship?
Yes.
ನನಗೆ ಪರಿಚಯವಿರುವ ಗುಬ್ಬಿ ಟೌನ್ ವಾಸಿ ಅಣ್ಣಪ್ಪ ಸ್ವಾಮಿ ಎಂಬುವರು ತನ್ನ ತಾಯಿ ಮತ್ತು ಸಹೋದರಿ ಹೆಸರಿಗೆ ಸರ್ಕಾರಿ ಜಮೀನು ಮಂಜೂರು ಮಾಡಿಕೊಡುವಂತೆ ನನಗೆ ಕೇಳಿದ್ದು, ನಾನು ಹಣ ಖರ್ಚಾಗುತ್ತೆ ಎಂದು ಹೇಳಿದೆ. ಆಗ ಅಣ್ಣಪ್ಪ ಸ್ವಾಮಿ ಹಣ ಕೊಡುವುದಾಗಿ ಹೇಳಿಗೆ ನನಗೆ ಒಟ್ಟು 4 ಲಕ್ಷ ಹಣವನ್ನು ನೀಡಿದ್ದು, ಇದರಲ್ಲಿ 3.5 ಹಣವನ್ನು ಆನ್ಲೈನ್ ಪೇಮೆಂಟ್ ಮೂಲಕ ನೀಡಿರುತ್ತಾರೆ. ನಾನು ಅದರಂತೆ ಅಣ್ಣಪ್ಪ ಸ್ವಾಮಿರವರ ತಾಯಿ ಗೌರಮ್ಮ ಓಂ ನಾರಾಯಣಪ್ಪರವರಿಗೆ ಎಕಲ್ಕಟ್ಟೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 31ರಲ್ಲಿ ತಲಾ 4.2 ಗುಂಟೆ ಜಮೀನು ಇರುವಂತೆ ಹಾಗೂ ಅಣ್ಣಪ್ಪ ಸ್ವಾಮಿ ಅವರ ಅಕ್ಕ ಶಾಂತ ನಾರಾಯಣಪ್ಪ ಅವರ ಹೆಸರಿಗೆ ಎಕಲ್ಕಟ್ಟೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 31ರಲ್ಲಿ 4 ಎಕರೆ ಜಮೀನು ಇರುವಂತೆ ದಾಖಲಾತಿಗಳನ್ನು ಸೃಷ್ಟಿಸಿರುತ್ತೇನೆ. This is the allegation. He does not know when he received, which date the amount was transferred. Nothing is forthcoming.
Yes, Jagdish sir.
And most important, one more document, Your Lordship, at page 444. It starts, document starts from 430. This is an order by the DC, Your Lordship. Vishaya, page 430.
430 na 444.
430. 430 it starts. I'm referring to the subject in that order dated 8/7/22, Your Lordship. ವಿಷಯ ಗುಬ್ಬಿ ತಾಲೂಕು ಆಗಲ್ವಾಡಿ ಹೋಬಳಿ ಮತ್ತು ನಿಟ್ಟೂರು ಸಿಆರ್ಎಸ್ಪುರ ಕಸ್ಬಾ ಹೋಬಳಿಗಳ ಸರ್ಕಾರಿ ಜಮೀನು ಮಂಜೂರು ಮಾಡಿ ಸಾಗುವಳಿ ಚೀಟಿ ವಿತರಣೆ ವಹಿ ಕೈಬರದ ಪಣೆ ಹಾಗೂ ಎಂಆರ್ಗಳಲ್ಲಿ ಅನಧಿಕೃತ ವ್ಯಕ್ತಿಗಳನ್ನು ನಮೂದು ಮಾಡಿರುವುದನ್ನು ರದ್ದು ಮಾಡುವ ಬಗ್ಗೆ. All the names allegedly inserted have been cancelled. And the list ಯಾರ್ಯಾರ ಹೆಸರು ಪಾಣಿಲಿ ಮೆನ್ಷನ್ ಆಗಿದೆ ತಿದ್ದಿದೆ ಇಲ್ಲ ಅನ್ನೋದು ಬರುತ್ತೆ, Your Lordship. At page 4
ಅದರಲ್ಲಿ ನಿಮ್ದಿಲ್ವಾ?
ನಮ್ದಿಲ್ಲ. Page 434. Third column. ಅದರಲ್ಲಿ serial number 103 and 104.
Yes.
As against them, ಕೈಬಾರದ ಪಾಣಿ ಇಲ್ಲ. So this is just some political vengeance. They have just inserted some name, and at the time of filing of charge sheet without any investigation, ಇವ್ರನ್ನು ಕೂಡ investigate ಮಾಡಿಲ್ಲ, because all the other witnesses whose name they allegedly found, they have been made witnesses. ನಿಮ್ಮ ಹೆಸರಿದೆ ಇದರಲ್ಲಿ ಏನು ಅಂತ they have given their statements. ಇವ್ರ ಮದರ್ನು ಸಿಸ್ಟರ್ನು investigate ಮಾಡೋದಿಲ್ಲ, whether they were aware of this, whether they got it insert. Nothing of that sort has been done, Your Lordship, excepting the voluntary statement. Now their own documents say their name do not find place in the records.
Yes, Jagdish.
Your Lordship may take my synopsis which I have placed.
Vacating stay.
I have separate
Synopsis ಹಾಕಿದ್ದೀರಾ?
synopsis placed. You can place another copy. Place another copy.
ಹತ್ತೋಳಿ madam.
With respect to accused number 11, I did not make my submission.
11
11, I'm on record for 11 also. A11,
ಈಗ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದು A21 ಗೆ.
A21.
Now I made a details about each accused and their role, my lord. The first, my lord, that investigation has been completed. Investigation is pending. Now
Investigation pending.
It's pending.
173(8).
Yes, my lord. And investigation now has been transferred to CID and provisions of PC Act also been invoked. So that is by virtue of the.
No, that is for officers.
Officers and even
public servants.
Yes, even including these petitioners also, my lord, further investigation was pending. In the 173(8) itself speaks about it. Now with respect to present petitioner, my lord, where my learned friend argued, that page number 12, my lord, it describes about
clause 8.
Yes, my lord. Describes about the land which has been given and also speaks about the manner in which and date in which he received the payment or transfer the payment to accused number 2 also.
Then what basis did you draw if investigation is still pending?
Some of the accused were in custody because of that period of 60 days. Initially, charge sheet was filed. What has been challenged is only the initial charge sheet, and subsequently obtained a stay. Therefore, no investigation could be carried on thereafter. Now it is, Your Lordship may see that the friend said
the approach after the
charge sheet. Apart from this, nothing else can come forth because ಇದಕ್ಕೆ ಐ ವಿಟ್ನೆಸಸ್ ಇಲ್ಲ. ಹೆಸರನ್ನ ಎಂಟ್ರಿ ಮಾಡಿದ್ದಾರೆ.
ಎಂಟ್ರಿ ಮಾಡಿದೆಯಾ ಅಲ್ಲಿ?
ಎಂಟ್ರಿ ಮಾಡಿದ್ದಾರೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್.
In fact, my lord, I don't know how my learned friend said in the DC's order there is no reference to the present petitioner. That is also there in the present petitioners. I've given the file numbers also, my lord, 8.4. Family tree of so and so details shows that the Gauramma and Shantamma are the petitioner's mother and elder sister respectively. Discloses about the transactions, and there was a report also Tahsildar Sanke so and so. The names of Gauramma and Shantamma are found.
All right.
I pointed out at page 434
We'll consider.
ಅವ್ರ ಹೆಸರಿದೆ ಬಟ್ ಕೈ ಬಾರ್ದ ಪಾಣಿಲಿ ಅವ್ರ ಹೆಸರು ತಿದ್ದಿದ್ದಾನೆ ಅನ್ನೋದನ್ನ ಅವ್ರು ಹೌದು ಅಂತ ಇಲ್ಲ ಅಂತಿಲ್ಲ ಬಿಕಾಸ್ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಯಾರ್ಯಾರ್ದಿದೆ ನಮೂದಾಗಿದೆ ಅಂತ ಬರೀತಾರೆ.
At page 15 I had given a details of each accused and the beneficiary in the synopsis, which I just placed it.
ಈ CS ಪುಟ್ಟರಾಜಕ್ಕೆ ಏನು ಸಂಬಂಧ ಐತೆ?
ಪುಟ್ಟರಾಜುಗಿಲ್ಲ, ಬೆನಿಫಿಷಿಯರಿನ ಅಕ್ಯೂಸ್ ಮಾಡಿರೋದ್ರ ಬಗ್ಗೆ ದಟ್ಸ್ ವಾಟ್ ವಿ ಆರ್ ರೆಫರಿಂಗ್ ಟು.
ಅಲ್ಲ, ವಾಟ್ ಹ್ಯಾಪನ್ಡ್ ಇನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಲಿ ತಲೆ ಏನಾಯ್ತು?
ಅದು ಔಟ್ ಪೆಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಆರ್ಡರ್ ಇಸ್ ಕನ್ಫರ್ಮ್ಡ್.
This what I have written page 37.
Yes, your lordship.
Oh, this concerns that, is it?
Yes, your lord. Because he is no beneficiary. Amount transaction another 2 lakhs I admit, and I have produced a document also to say that yes, I have transferred to Karyana and because he was acted as a broker.
Ultimately, it's a public property has been tried to siphoned off by officials and other people. If they are not, they are.
Monday Urban Development Authority.
Allah, Gubi. Tumkur.
Gubi, this is Gubi.
Gubi, this is.
That was Monday.
That was Monday.
300 plus acres of land has been siphoned off in the name of.
It is not siphoned off. Recorded yesterday, none of them took possession, your lordship. Yaar hesaru documentation.
Attempt to siphon.
No,
nobody has taken possession of any land. Nobody tried to get the
government ತಗೊಂಡಿದ್ದಾರೆ ಎಲ್ಲ ಅದನ್ನ.
Because DC cancelled it. Otherwise, it could have continued.
Otherwise, it would have happened.
And even otherwise, no one tried to get the documentation changed into their names. Allegation is 2000 null entry agide anta. Till 22, nobody made an attempt to get the documents transferred into their respective names.
Abruptly, so 2000 lagi transaction up to 2022, it remained a transaction.
It remained. No one came to know about it.
2022 nalle ದುಡ್ಡು ಕೊಟ್ಟಿರೋದು ಅವರು ಅವಾಗ್ಲೇನೆ ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡು ಕೊಟ್ಟಿರೋದು. Lordship may see the dates of the payments.
No, your synopsis I'll see.
Yes.
Both the synopsis.
Dates of the payments.
To accuse number 11 ಇಷ್ಟು ಇಲ್ಲ, your lordship. ಅವ್ರ ಮುಂದೆ 9 ಜನರ ಹೆಸರು ಕೊಟ್ರು, ದುಡ್ಡು ಕೊಟ್ರು ಅಷ್ಟೇ ಹೇಳೋದು. ಯಾರು 9 ಜನರ ಹೆಸರು ಸೇರ್ಸಕ್ಕೆ ಹೇಳಿದ್ರು? I filed synopsis for both the cases here.
Yes, this criminal petition 12246 is accused number 11. Lakshmikant
9784.
ಓ, ಇನ್ನು ತುಂಬಾ ಜನ ಇದ್ದಾರೆ ಇದರಲ್ಲಿ.
Connected matters.
All are different accused, is it?
Different accused. In my table, I have given the names of the accusers.
I appear for 9784 and 11.
ಯಾರ್ಯಾರಿಗೆ ಅಭಿನಯ?
I appear for 34.1, which is criminal petition
All right.
11441.
ಆಮೇಲೆ
34.6, 9784 of 23.
that is A11.
Yes, sir.
Yes. ನಿಮ್ದೇನಿದೆಯಾ? Criminal petition?
6238/23.
Yes, 34.2.
Please.
Put it. Any other submission or same submission?
No, my lord, I have different submission. On the particular date, my lord, I was not at all working in the taluk office, my lord, as per their own records.
He's a public servant.
Public servant.
Receive 1.43 lakhs from different people.
ಅಲ್ಲ ನಿಮ್ಮ your
A19 Your Honor.
public servant.
Yeah, public servant.
Working as
Working as my lord, grade Tahsildar, madam.
ತಹಸೀಲ್ದಾರ್. You are not working, transfer ಆಗೋಗಿತ್ತಾ?
ಅಲ್ಲ ಅಲ್ಲಿ ಡೆಪ್ಯುಟೇಷನ್ ಮೇಲೆ ಅಲ್ಲಿ ಇದೆ 2 ತಿಂಗಳಲ್ಲಿ.
2 ತಿಂಗಳಲ್ಲಿ ಇವೆಲ್ಲ ಆಗೋಯ್ತಾ?
ತಹಸೀಲ್ದಾರ್ ಆಫೀಸಲ್ಲಿ ವರ್ಕಿಂಗ್. ಪೇಜ್ ಇದರಲ್ಲಿ
ಹೇಳಿ.
ಪೇಜ್ 91 ಅಲ್ಲಿ ಮೈ ಅಲಿಗೇಷನ್ ಇಸ್ ಸೆಟ್ ಔಟ್. ಈತನ ಗುಬ್ಬಿ ತಾಲೂಕ್ ಸೋನ್ಸೋ ಆದೇಶದಂತೆ 1/10/21 ಆದೇಶ ರೀತಿಯ ತಾಲೂಕು ಕಚೇರಿಯಲ್ಲಿ ಚುನಾವಣೆಯ ಶಿರಸ್ತರ ಮೇಲೆ ಜೊತೆಗೆ ಹಕ್ಕು ದಾಖಲೆ.
ಯಾವ ಪೇಜ್ ಓದ್ತಾ ಇದ್ದೀರಿ?
ಪೇಜ್ 91 ಮೇಲೆ
91
ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಲಮ್ ನಂಬರ್ 17 ಅದರಲ್ಲಿ A19 ಆರೋಪಿ 19 ರವೀಶ್ ಚುನಾವಣೆ ಶಿರಸ್ದಾರ್ ಮೇಲೆ 1/10/21 ಆದೇಶದ ಮೇರೆಗೆ ತಾಲೂಕು ಚುನಾವಣೆ ಶಿರಸ್ತರ ಹಕ್ಕು ಶಾಖೆ ಆಧಾರ ವಿಲೇವಾರಿ ಭೂಮಿಯ ನಿರ್ವಹಣೆ 3 ಮತ್ತು 9 ಪ್ರತಿಪಾದಿತ ನ್ಯಾಯಾಲಯದ ಕೇಸ್ 11 ERT ಶಿರಸ್ದಾರವರ ಸಹಯೋಗದೊಂದಿಗೆ ವಿಲೇವಾರಿ ಮಾಡುವ ಕರ್ತವ್ಯವನ್ನು ಈತನ ಆರೋಪಿ 2 ಕರಿಯಣ್ಣನವರ ಜೊತೆ ಶಾಮೀಲಾಗಿ ಕರಿಯಣ್ಣನವರಿಂದ ಹಣಕ್ಕೆ ಬೇಡಿಕೆ ಇಟ್ಟು ಒತ್ತಾಯದಿಂದ ಆನ್ಲೈನ್ ಮೂಲಕ ವಿವಿಧ ಕಂತುಗಳು 1,43,500 ಹಣವನ್ನು ಪಡೆದುಕೊಂಡು ಗುಬ್ಬಿ ಶಾಖೆಯಲ್ಲಿ ದೊಡ್ಡಗುಣಿ ಗ್ರಾಮದ ಅನಧಿಕೃತ ಖಾತೆಗಳು ಪಡೆಯಲು ಆರೋಪಿ 2 ಸಹಕರಿಸಿ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸೋ ತಹಸೀಲ್ದಾರ್ ಅವರವರ ಸಹಿಯಾದ RRT ಬಳಿಕ RRT ಶಾಖೆಯ ಆರೋಪಿ 14 ಪ್ರಕಾಶ್ ರವರು ಬಳಿ ಇದ್ದಾಗ ಆರೋಪಿ 19 ರವೀಶ್ ರವರು 16ರ ಸರ್ವೆ ನಂಬರ್ ಫೈಲ್ ಅನ್ನು AC ಕಚೇರಿಗೆ ತಲುಪಿಸಲು ಆರೋಪಿ ಕರಣವರಿಗೆ ಮುದ್ದಾಂ ಕೊಡಲು ಆರೋಪಿ 16ರನ್ನು ದುಷ್ಪ್ರೇರಣೆ ನೀಡಿದ್ದಲ್ಲದೆ ಸರ್ವೆ ನಂಬರ್ 95ರಲ್ಲಿ 10 ಜನ ಅನಧಿಕೃತ ವ್ಯಕ್ತಿಗಳ ಹೆಸರು ಜೊತೆ ಪಾಣಿಯರು ಸಹಕರಿಸಿ ನೌಕರನಾಗಿ ಹಣದ ಆಸೆಗಾಗಿ ತನ್ನ ಅಧಿಕಾರ ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡ ಬಗ್ಗೆ ಅಲಿಗೇಷನ್. My lord, the statement of accused number 2, my lord. He was arrested, my lord, on 4/7/2022. In this statement, my lord, he has
ನೀವು
never.
ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲೇ ಬಂದಿರೋದಾ?
ಇವೊಂದು ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್. ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅಮೌಂಟ್ ನಾನು ತಗೊಂಡಿದ್ದೆ ಅಂತ ನೋವೇರ್ ಸ್ಟೇಟೆಡ್, my lord. Moreover, my lord, the authorities, the investigation authorities have produced the relevant document, that page 248, my lord. ಪ್ರಕರಣ ತನಿಖೆ ಸಲುವಾಗಿ ಸೂಕ್ತ ದಾಖಲಾತಿಗಳ ಮಾಹಿತಿ ನೀಡಲು the persons who are working during the tenure, my lord. ಅದರಲ್ಲಿ ಪೇಜ್ 249 ಅಲ್ಲಿ 2022-23 ನಲ್ಲಿ ನಾನು ವರ್ಕ್ ಮಾಡಿದ 4/5/22 26/5/22 This is, my lord. And, my lord, the alleged amount, my lord, transferred to my account is that, my lord, pertaining to that, my lord, I have entrusted the A2 Karyanna for, my lord, may kindly peruse document number 275. Prime Minister Employment Generation Scheme ಅಲ್ಲಿ ಪ್ರೋಗ್ರಾಮ್ ಸ್ಕೀಮ್ ಅಲ್ಲಿ ನಾನು ಅವ್ರಿಗೆ ಒಂದು ಶೆಡ್ ನ ನಮ್ಮ ತಾಯಿ ಹೆಸರಲ್ಲಿ ನಿರ್ಮಾಣ ಮಾಡಕ್ಕೆ ಇವ್ರಿಗೆ
ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗಿರೋದು,
ಅದಕ್ಕೆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ಸ್ ಆಗಿದೆ. ಎಕ್ಸೆಪ್ಟ್ ದಟ್ ಅವ್ರ ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಎಲ್ಲೂ ಸಹ ಇವ್ರಿಗೆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗಿದೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಎಲ್ಲೂ ಸಹ ಅವ್ರನ್ನ ನೋವೇರ್ ಇಟ್ ಇಸ್ ಡಿಸ್ಕ್ಲೋಸ್. ಆ ಪರ್ಟಿಕ್ಯುಲರ್ ಪೀರಿಯಡ್ ನಾನು ವರ್ಕ್ ಮಾಡಿಲ್ಲ.
ಇದರಲ್ಲೇ ಇದೆ ಅಲ್ಲ? ಇನ್ನೇನು ಚೇತನ್? ನೀವು ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್ಸ್ ಏನು?
Two are government servants. One is revenue inspector, accused number 12, and accused number 6 is village accountant. And so far as Lord, accused number 10 and 15, my lord, they are not government servants.
That
Lord,
is
allegation is
34.5 and 34.7.
Yes, my lord. 34.4 and 7, my lord, are government servants, my lord.
4 and 7.
4 and 7. 34.3 and 5, my lord, they are not government servants.
All right. Yes.
The allegation is that, my lord, the private parties, my lord, for the benefit of their family members, my lord, they have given the bribe, my lord. That is the allegation.
Yes, sir.
My lord, if we, my lord, page number 76, my lord. My lord, is the charge sheet, which says that, my lord, the petitioner, my lord, accused number 15, my lord, has given amount of rupees 5 lakhs, my lord, to see that, my lord, the revenue records are changed in their father and mother's name. My lord.
Yes.
That is the allegation.
Yes, sir. A15.
Yes, my lord. A15, yes, my lord. A10, my lord, in the same page, page number 74. The allegation is that, my lord, to facilitate 9%, my lord, he has given amount of rupees 9 lakh, my lord. Lord, the beneficiaries, my lord, has not been arraigned as an accused.
ಅಷ್ಟೇನಾ ಇದರಲ್ಲಿದೆ ಎಲ್ಲ ಇನ್ಯಾರಿದೆ ನೀವು ಇನ್ಯಾವ್ದಾರು ಇದೆಯಾ ಅಷ್ಟೇ ಅಲ್ವಾ ರಿಸರ್ವ್
Let's say case of my lord's trap. She was the petitioner was working as a PSI. Let's say a complaint. A complaint has been filed. Let's alleging that one Yallappa, the police constable attached to the station, was demanding illegal gratification for allowing the complainant to transport the sand.
ನಿಮಿಷ
There is a trap statement.
Yes, sir. Sorry.
The police constable by name Yallappa, he claims to have demanded illegal gratification from the complainant for allowing him to transport the sand. Lords, in connection with that, Lords, it appears he has paid some amount, advance amount also. Ultimately, Lords, the complaint came to be filed only against Mr. Yallappa. Based on that, Lords, a trap was conducted. Yallappa was, found with the tainted currency notes. He was trapped red-handed. Because I am not accused in that the complaint and the FIR. After 3 days, this complainant appears to have given one more compact disc, stating that he had recorded my statement, the statement of the PSI also over the phone. So based on that, the investigation was carried out, and now the charge sheet has been filed against me as a accused number 3. Accused number 2 was a DYSP. He has been dropped from the charge sheet. Now I have been shown as a accused number 3. Plus, admittedly, the only evidence, the piece of evidence what the charge sheet depicts is my conversation recorded by the complainant. May kindly see the page number 86. That is when subsequently he produces one CD stated to be containing my conversation. Mahazar was drawn. The conversation with the complainant is extracted at page number 101.
Trap ಆಗಿದೆಯಾ?
101. Trap agide, accused number 1 has been
found with tainted currency.
Yes.
So nothing with you.
Nothing. I was not in the place also. My lords, now the only conversation against me has been extracted at page number 101, my lords. 101.
Yes, Patel.
My lord,
Sir.
trap Mahasar at statement of objection, page number 26.
I am there only.
In the tap Mahasar, that Yellappa has given a statement that I received it for the DSP and PSI. My lords may have 26 page.
I am there, sir.
At the trap Mahasar, he has given ಈ ಮೂಲಕ ನಿಮಗೆ ಕೇಳಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ಫೈರೋಜ್ ಚನ್ನಗಿರಿ ಎಂಬುವರ ಠಾಣೆಗೆ ಬಂದು ನನ್ನದು 2 ಟಿಪ್ಪರ್ ಲಾರಿ ಮರಳು ಪಡೆದುಕೊಳ್ಳಬೇಕು. ಡಿವೈಎಸ್ಪಿ ಸಾಹೇಬರು, ಸಿಪಿಐ ಸಾಹೇಬರು ಮತ್ತು PSI ರವರನ್ನು ಭೇಟಿ ಮಾಡಿಸಿ ಅಂತ ತಿಳಿಸಿದ್ದು. ಅದರಂತೆ ನಾನು ಅವರನ್ನು ಅಧಿಕಾರದ ಮುಂದೆ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದು. ಅಲ್ಲಿ ನಡೆದ ಅವರ ಮಾತುಕತೆಯಂತೆ ಆತ ಹಣ ಕೊಡಲು ಒಪ್ಪಿದ್ದು. ಅದರಂತೆ ಸಾಹೇಬರಿಗೆ ಕೊಡಬೇಕಾದ ಹಣವನ್ನು ನಾನು ತೆಗೆದುಕೊಂಡಿರುತ್ತೇನೆ.
ಈಗ ಒಂದು ನಿಮಿಷ, ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಏನ್ ಮಾಡಿದ್ರು?
My lords, I have been exonerated.
Who are the witnesses there?
My lords, I have produced the, my lords.
ಒಂದು ಮೆಮೋ ಹಾಕ್ತಾ ಇದೀನಿ ಯಾವ್ಯಾವ ಮಿಸ್ ಆಗಿದೆ ವಿಟ್ನೆಸ್ ಅಂತ.
ಓ ಸರಿ, ಕೊಡಿ.
ಫುಲ್ ಲಿಸ್ಟ್ ಆಫ್ ಮೆಮೋ ಇದೆ,
ಆಯ್ತು.
ಯಾವ್ಯಾವ ವಿಟ್ನೆಸ್ ಮಿಸ್ ಆಗಿದೆ ಅಂತ ಇಲ್ಲಿದೆ.
My lords, I have produced the comparative chart also. Comparative chart. Your lordship may kindly see the comparative chart submitted before this court.
27 witnesses, huh?
My lords, in all 27 witnesses, my lords, now the departmental inquiry was conducted and the evidence of the complainant, shadow witness, the second shadow witness, my lords, the investigating officers.
Who were examined, Heli?
My lords, the examination is the complainant has been examined.
Where do you get that?
My lords, may kindly come to my comparative chart.
Where you produced it?
Yes, my lords. Along with the judgments, I produced the comparative chart. My lords, may kindly come to, first one is Yellappa, accused number 1. He has been examined to show that whether it was demanded, demand was from me, on behalf of me ಅಂತ ತೋರಿಸೋದಕ್ಕೆ ಯಲ್ಲಪ್ಪನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ. Number 2, Fairoz, the informant. He has been examined. Number 3, Gopinath, shadow witness. Number 4, Ranjit Kumar, the second witness. My lords, then my lords, page number, next page, serial number 22 and 23, investigating officers.
ಅವರು ಇನ್ನ ಮಿಕ್ಕಿದ ಅಕ್ಯೂಸ್ ಮೇಲೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ರ?
ಹೌದು, ಅವ್ರಿಗೂ ಎಕ್ಸಾನರೇಷನ್ ಆಗಿದೆ.
ಅವ್ರದ್ದು ಎಕ್ಸಾನರೇಟೆಡ್?
ಹೌದು. Your lordship may kindly see.
ಟ್ರ್ಯಾಪ್ ಆಗಿರೋರು ಯಾರ ಮೇಲೆ? ಟ್ರ್ಯಾಪ್ ಆಗಿದ್ದು ಯಾರ್ದು?
ಅವ್ರ ಮೇಲೆ ಆಗಿಲ್ಲ, ಅವರಿಗೆ ಎಕ್ಸಾನರೇಷನ್ ಆಗಿಲ್ಲ. Only DYSP and PSI has been exonerated. Your lordship may kindly come.
So that man who was caught with tainted currency is not.
No, he has not been exonerated.
My lords may look at, they have not even examined the FSL report. ಬೇಸಿಕ್ ಥಿಂಗ್ಸ್ ಇಲ್ಲ, ಬರೀ ಅವ್ರ 4 ಜನದ ಹೇಳಿಕೆ ಮೇಲೆ ಮಾಡಿದ್ರೆ will it hold is visit?
ಅಲ್ಲ, tainted currency ಯಾರ ಹತ್ರ ಸಿಕ್ಕಿತ್ತು ಅವ್ರದ್ದು ಪರವಾಗಿಲ್ಲ, ಅದು ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ಬಟ್ ಅವನೊಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದ, ನಾನು ಇವ್ರ ತರವಾಗಿ ಕೇಳಿದೀನಿ ಅಂತ. ಅದ್ರ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಲೇ ಆಗಿದೆ. ಅಂಡ್ my lords, totally 27 witnesses ನಾವು ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಹಾಕಿರೋದು. ಇವ್ರು 6 ಜನನ ಅಷ್ಟೇ ಮಾಡಿದ್ದಾರೆ. ನಮ್ಮ ಇನ್ನುಳಿದವ್ರದ್ದು ಲಿಸ್ಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಇಲ್ಲಿ ಮಾಡ್ಲಾರ್ದವ್ರು.
ನೋಡಿದೆ ನೋಡಿ.
Lords, may I, Fairoz, the complainant ದು ಎವಿಡೆನ್ಸ್ ಆಗಿದೆ ಇದ್ರೊಳಗಡೆ. Your lordship may kindly one.
Lords, evidence, even if the complainant now retracts, the law is settled. Even if by circumstantial evidence, if I can prove.
Actually, complainant will always.
My lords may kindly come.
My lords, now the law is settled that even if the face of the complainant retracting, if I can prove demand and acceptance, even by circumstantial evidence, the owner shifts on him under 20 to prove it, to rebut it. Presumption.
My lords, page number 14, my lords. 14. My lords, about 5th line, ಪ್ರಶ್ನೆ ಇದು ಒಂದೇ ನನ್ನ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಇದ್ದಿದ್ದು, ಫೋನ್ ಅಲ್ಲಿ ಮಾತಾಡಿದ್ದೀನಿ ಅಂತ. ಆರೋಪಿ ಭಾರತೀಯವರು ನಿಮಗೆ ದೂರವಾಣಿಯಲ್ಲಿ ಲಂಚದ ಹಣವನ್ನು ಕೊಡುವಂತೆ ಕೇಳಿರುತ್ತಾರೆಯೇ? ಇಲ್ಲ.
ಅಷ್ಟು ಬಿಟ್ಟು ಬೇರೆ ಮಾತೇ ಇಲ್ವಾ?
ಇಲ್ಲ, ಬಿಟ್ಟರೆ ನನ್ ಮತ್ತೇನು ಇಲ್ಲ.
ಅಲ್ಲ, ಅಲ್ಲೊಂದಿದೆ, ನೆಕ್ಸ್ಟ್ ಒಂದಿದೆ ನೋಡಿ. ಈ ಸಂದರ್ಭದಲ್ಲಿ
ಅದು ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಇದ್ರದ್ದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮಾರ್ಕ್ ಮಾಡಿಸಿದ್ದಾರೆ, ಡಿಫೆನ್ಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. And I have not even ಅದರೊಳಗೆ ಡಿಮಾಂಡು ಇಲ್ಲ ಅದು ಇದ್ರು.
Yes sir, anything else?
Lords, one last thing. After, as my learned friend pointed out, after giving the second CD, there is another pre-trap mahazar that is drawn. ಅದರಲ್ಲಿ ಸಾಕಷ್ಟು ಕನ್ವರ್ಸೇಷನ್ ಇದೆ. ಅದಕ್ಕೆ ಅದನ್ನ ನಾನು ಮೆಮೊ ಮಾಡಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಕಂಪ್ಲೇಂಟ್ ಎವಿಡೆನ್ಸ್
ಅಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಎವಿಡೆನ್ಸ್ ಇದ್ರೂ there is now a conversation. ಅದಕ್ಕೆ ನಾನು FSL ರಿಪೋರ್ಟ್ ಅವ್ರದೇ ಕನ್ವರ್ಸೇಷನ್ ಅಲ್ವೋ ಹೌದು. All these things, my lords, have to be gone into. Complainant I don't need to say that even if he retracts and goes hostile, we can prove it otherwise. Now, my lords, the only crisp question that needs to be asked is in the light of the accused who was trapped red-handed, making a statement
not
that
this accused.
Not accused. He has made a statement at the trap mahazar only, not now. That I received it on behalf. Now again in departmental inquiry, he has retracted. So too many things are now flying. It is a full-blown trial. They should not shy away from the trial, is my respectful submission. And even otherwise, my lords, there are many other witnesses that need to be taken, and it needs to go into a full-blown trial, is my respectful submission. Especially after charge sheet being laid and much of things having transpired now.
Charge sheet, exoneration, ಎಲ್ಲ ನೋಡ್ಬೇಕು.
The charge sheet ಅಲ್ಲಿ 27 witnesses ಹಾಕಿದ್ದೇವೆ, 6 ಮಂದಿನ ಅವರು ಡೆಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ ಅಲ್ಲಿ ಮಾಡಿ. Along with that list, I have given a short synopsis of it. Not like please.
Yes.
Lords, another memo to second pre-trap ಏನಾದ್ರು.
ಇಲ್ಲ ಇದು ಯಾವ second?
ಅದು pre-trap now they
facts dictate. The petitioner, accused number 3, is at the doors of this court, calling in question proceedings in special CC 217 of 2023 registered for offence punishable under section 7A of the Prevention of Corruption Act. Heard so and so. On 3/1/2019, the second respondent registers a complaint before the Lokayukta police alleging demand and acceptance, alleging demand of bribe. A pre-trap mahazar is drawn by the then Anti-Corruption Bureau on 3/1/2019, and on the pre-trap mahazar being drawn, a trap is laid and the tainted currency notes are seized from the hands of accused number 1. Accused number 1. The petitioner is accused number 3, a constable.
No, PSI. PSI.
Working as a police sub-inspector.
He was not accused in FIR.
Police sub-inspector. The petitioner was not accused in the FIR, but the police conduct investigation pursuant to registration of the crime, and during investigation find that find the conversation between the petitioner and the complainant with regard to demand or acceptance, and draw the name of the petitioner as accused number 3 in the said charge sheet. The concerned court takes cognizance of the offence and registers a special CC so and so 217 of 2023. The registration of the crime, the registration of special CC is what has driven the present petitioner accused number 3 to this court in the subject petition. The learned counsel appearing for the petitioner, taking this court through the documents appended to the charge sheet or even the charge sheet, would seek to contend that there is no allegation or demand or acceptance against the petitioner. Neither the petitioner is caught with the tainted currency. All that happened, qua accused number 1 or accused number 2 at the 2.
Accused number 2 was DYSP, but he has been dropped
in the charge sheet.
Qua accused number 1 and not the petitioner. He would seek to place reliance upon, the learned counsel would seek to place reliance upon the evidence of the complainant, where the complainant himself would, contending that the complainant himself has deposed, a complainant himself in evidence says that there was no demand from the hands of the petitioner. Therefore, the learned counsel submits that the entire allegations now boil down to a person who was caught with tainted currency, i.e. the accused number 1. The learned counsel further submits that on the same set of facts, a departmental and therefore has been exonerated. Exoneration of which has been accepted by the disciplinary authority, and the departmental inquiry has thus ended in favor of the petitioner. The learned counsel submits in the light of the departmental inquiry, ending in favor of the petitioner where probabilities are preponderant. It as what would require in a criminal trial is proof beyond all reasonable doubt. The learned, he would seek quashment on all the aforesaid grounds. The learned counsel, Baby Patil, representing the respondent, takes this court through the statement of objections to contend that that even if the complainant has retracted from the complaint and contended that the petitioner has not demanded any amount, it would not mean that the respondent cannot prove demand and acceptance in a full-blown trial. He would submit that the pre-trap Mahazar -2 would clearly pin the petitioner down, as there are conversations between the petitioner and the complainant. In that light, the learned counsel submits that it is a matter of evidence and the petitioner to come out clean in a full-blown trial. A indulgence under section 482 of the CRPC at this juncture would be contrary to law, is the submission of the learned counsel, Baby Patil. Insofar as the exoneration in the departmental inquiry is concerned, the learned counsel submits that all the witnesses, there were 27 witnesses in the criminal trial. In the departmental inquiry, about 6 witnesses are examined, and the key witnesses, the FSL report or the author of the FSL report, is not even made a witness in those witness in the departmental inquiry. He would submit that the that the apex court in the judgments that the petitioner wants to rely on has clearly held that if all the circumstances are identical, qua witness or the documents, then the departmental inquiry can become a foundation perhaps for quashment of the proceedings, but not otherwise. He has placed a memo contending that depicting the witnesses examined, witnesses not examined, the purport of their examination and non-examination. The learned counsel for the petitioner would join issue contending that he has also produced a memo where about 6 to 7 key witnesses that are necessary to be examined are examined in the departmental inquiry. And in the departmental inquiry, it was found that the petitioner has neither demanded nor accepted any amount for the departmental inquiry to continue. The learned counsel submits that the petition be allowed on the strength of the judgment of the apex court in the case of Ashu Surendranath Tiwari versus so-and-so 2026, 9 SEC page 636. And the judgments rendered in the aftermath of Ashu Surendranath Tiwari or earlier to that which have been followed by the apex court in Ashu Surendranath Tiwari. The I've given my anxious consideration. Reserved. Please.
Obliged. Deeply obliged.
I am for the petitioner in this matter, my lord. The respondent number 2, PSA, has filed the private complaint against the petitioner for the offences punishable under sections 177 and 197 of the IPC, my lord. And pursuant to the filing of the said PCR, the Honorable Trial Court has taken cognizance and for the said offences and issued a process against the petitioner, my lord. The allegation is that, my lord, the petitioner is a constable, my lord. He had given false declaration before the police inspector that there was no pending criminal proceedings against him.
Against whom?
Against the petitioner, my lord, for the purpose of getting the promotion.
Oh, criminal case pending itta?
Yes, yes, my lord.
What criminal case was that?
That is the offence punishable in section 188 IPC, my lord.
188 case pending itta nimmele?
Yes, my lord. And in that case, the petitioner already been discharged, my lord. And declaration given on 21/12/2016, my lord. And this private complaint came to be filed on 27/10/2023. It is barred by limitation under section 468 of CRPC, my lord.
ಯಾವತ್ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ದು?
27/10/2023.
Incident?
21/12/2016, my lord.
Offense 188.
The offense.
ಎಷ್ಟು punishable?
3 years, my lord. For the offense punishable as 177 IPC, maximum punishment is
3 years,
6 months.
6 months.
And 197, maximum punishment, second proviso, maximum punishment is 3 years, my lord.
Extendable only up to 3 years? Extendable up to 3 years, huh?
Yes, yes, my lord. Yes.
ಅದರಲ್ಲೇ ಹೋಗ್ಬಿಡುತ್ತೆ. The petitioner is before this court, calling in question proceedings in CC 2364 of 2023, registered for offences punishable under section 177 and 197 of the IPC. The state is the complainant. The police sub-inspector is the complainant. The petitioner himself, ನೀವ್ಯಾರು?
Constable, my lord.
Petitioner himself, a constable. The petitioner was working as a police head constable at Coast Guard Police Station in Udupi district, was initially appointed as a police constable and was promoted later as a police head constable. The issue in the list does not pertain to the promotion of the petitioner. The second respondent, on finding that the petitioner has, while filling up the application or representation that he was entitled to promotion, had indicated that there was no crime registered against him. It was found later that a crime for offence punishable under section 188 was indeed pending at the time when the petitioner's case was considered for promotion. The second respondent notices and registers the crime for offence punishable under section 177 and 197 of the IPC for IPC. The police, an investigation is ordered, and the investigation madidara.
Illala.
PCR.
PCR. The cognizance is taken on the said offences, and the concerned court registers CC 2364 of 2023. The learned registration of the criminal case is what has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner, Balakrishna, submits that that this court need not go into the veracity of the crime or delve deep into the matter. The learned counsel submits that the proceedings will have to be quashed only on limitation. The limitation force as depicted under 468 of the CRPC. The learned additional SPP, though would submit that it is a matter of trial for the petitioner to come out clean, would not dispute the position with regard to the delay in registering the complaint of an incident that had happened 6 years ago. I have given my anxious considerations on. The afore narrated facts are not in dispute. The only issue that now falls for consideration is whether the complaint so registered against the petitioner for offence punishable under section 177 and 197 of the IPC is hit by limitation as obtaining under section 468. The offences, therefore I deem it appropriate to notice the offences. 177, 197 read as follows. 197 of the offence under 177 is punishable with 6 months, and
3 years.
197 3 177 is punishable to a maximum of 3 years imprisonment, and 197 is 6 months. Therefore, on both the
197 is 3 years.
That's what I said first. 197 3 years, 197 3 years, 177 6 months. Therefore, both the offence put together even would amount to 3 years maximum imprisonment for the so and so. Section 468 of the CRPC reads as follows. Subsection 2 of section 468 mandates that the offences, the the maximum punishment, the limitation would run, not the order of taking of cognizance, the registration of the complaint. Therefore, the incident in the case at hand has alleged, the incident in the case at hand is the taking of promotion by the petitioner. This happens in the year 2016-17. The second respondent appears to have found that the petitioner was involved in a crime for offense punishable under section 188 of the IPC after 6 years of grant of promotion.
And he came to know in 2017, but initiated proceedings in 20.
Something bad. Enel this way. 197, 468 ಆಯ್ತಲ್ಲ ಆಮೇಲೆ 468 extraction nilsi. The complainant, though comes to know of the factum of taking of promotion by the petitioner in the year 2016-17, allegedly notwithstanding the fact that a crime was pending for offense punishable under section 188 of the IPC, does not initiate any proceedings. The proceedings come about only in the year 2023 when he registers a private complaint in PCR 66 of 2023 on 27/10/2023. Therefore, what can be safely discerned is for a promotion that was taken in the year 2016 and 17, and the factum of it being aware of by the second respondent, chooses to initiate proceedings after 6 years. In that light, the bar under section 468 of the CRPC would undoubtedly kick in and would lead to obliteration of the proceedings on the ground of limitation. On this sole ground, the petition deserves to succeed. Allowed, quashed.
Much of it.
Yes.
37.
It's a case of disproportionate asset. The issue is, my lords, the crime was stated to have been committed under the pre-amended.
Problem is
withdrawal of sanction.
17/1/2019. Alva?
ಹೌದು.
ಏನಲ್ವಾ?
17.
Sanction was issued in the year 2000.
Yes, 19/9/2024 ಕೇಳಿರೋದ್ನ ಇದು.
ಹೌದು.
ಇವತ್ತೇ ಬಂದಿರೋದು.
ಹೌದು.
Sanction is withdrawn. Sanction is granted.
Granted.
Sanction is withdrawn.
Withdrawn.
And after the amendment, again sanction is sought for. ಅದೇನಾಯ್ತಾನೆ ಇದು?
ಇಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ
After
ಕೇಳಿಲ್ಲ.
retirement, the charge sheet was filed.
What they will do is, even after the post amendment, they will file a charge sheet saying that now the sanction is not required because he is retired.
Now, Lord, the already 11 witnesses have been examined and 39 documents are marked.
Charge frame ಆಗೋಗ್ಬಿಟ್ಟಿದೆ.
ಆಗಿದೆ.
ಅದೇ problem.
Now, my humble submission is, if the sanction is held to be, my lords, the required for this particular case.
But you petition file ಮಾಡಿರೋದು ಯಾವತ್ತು ಸರ್?
Petition is filed on
29th May
27/5/24.
2024. ಆ ಸ್ಟೇಜ್ ಏನಿತ್ತು ಅವತ್ತು?
As on that day, my lords, it's about 10 witnesses are examined.
Frame ಆಗೋಗಿತ್ತು.
My lords, may I make one submission? I will leave it to my lords.
Because generally that's the view I take, and special ಆಗಿ ಇದಕ್ಕೆ ಬೇರೆ.
ಅಲ್ಲ, if the sanction is required ಅಂತಂದ್ರೆ, it goes to the root of the matter. It will go to the root of, my lords may kindly ultimately.
No, we direct the court to consider that also while passing an order.
Lords, now whether it is applicable to this person.
That submission also you can take.
Lords, now
we follow Srinivasan and say during the proceedings it can be done.
Unfortunately now in the
2023 SCC take that.
At the time of taking the cognizance, Lords,
Srinivasan, please.
Lords,
it can be gone into even at that stage.
Lords, now the transfer
2020.
Lords, may kindly see the order taking the cognizance where the learned judge has made an observation. What is it is, my lords, he has already retired, sanction is not required antane observation ಮಾಡಿ cognizance ತಗೊಂಡಿದ್ದಾರೆ. Lordship may kindly come to page number 19. Plus the relevant,
Now,
the
one minute.
observation.
1 minute.
Yes.
First, ನೀವು ರಿಟೈರ್ ಆಗಿದ್ಯಾ ಅವತ್ತು?
Let's I
31/8/2020.
31/8/2020.
ರಿಟೈರ್
Plus the
ಆಗಿದ್ದು. correct?
investigation is completed on 10/7/2018.
ಹೌದು.
10/7. Millards, the prosecution sanction initially accorded on 17/1/2019.
Correct.
Millards, sanction has been withdrawn on
12/3/2020.
12/3/2020. I retired on 31/8/2020. 31/8.
No, on 18/2/2022.
Yes, 19/3/2022.
Yes.
19/3/2022. Now the cognizance is taken.
Yes.
On the ground that you have retired, there is no sanction required.
No sanction required.
Now the first withdraw agogittalla.
How? Let's now the what? Millards?
Why was it withdrawn?
Millards,
Withdrawn, they are given one more representation stating that not the properties of his brother has been added and to requested to delete those properties, the valuations from the charge sheet, and that those documents also have secured now, Lord. And on the basis of that representation,
it was withdrawn by the competent authority.
Please.
Matte it was not, sanction was not granted at all.
As on the date of taking cognizance, he
There
was
should be
retired.
sanction. He had retired, but was on the date. It's a peculiar case.
Let's, in fact, a similar issue was actually came up before. Let's, I have only one copy, but I'll pass it on.
ಯಾವ್ದು ಕೊಡಿ?
Kindly see the judgment of Kerala High Court, wherein Millards, the page number 11, the same issue was raised. Issue was raised because the sanction is required, necessity of the sanction.
So sanction is required. I'm not saying that.
Necessity of the sanction is required at the time of taking the
So even retire admire sanction is required. Lapsing is there. Supreme Court judgment. Lapsing mandates that sanction is required even if you're retired. But lapsing was interpreting not the amendment, it was pre-amendment.
Yes.
Now with the amendment, it is not required until cognizance is taken.
Yes.
For all the facts that have happened earlier.
Yes.
Before in this case, in fact, in Millards, the
copy kodi.
Lordship kindly pay.
We'll continue at 2:30, copy kodi.
Please, please.
Kumar sir. ಪರವಾಗಿಲ್ಲ. Yes. ಅವ್ರು ಮುಗಿಸಿದ್ದಾರೆ.
Yes, sir. I'll make a submission. I filed this general objection just to draw the attention of the Lordship how the entire company's operations are carried out. As far as he is concerned, the association with the company up to 2017 where the offense has taken place. Though he claims that I have resigned before the 2013 Act came into force. That's what their contention is. But as far as the allegations and his own admission per se, and it is a carve within which he is the one who has facilitated the entire incorporation to till the company came into that. That is our submission, Millards. With that, what happens, Millards? Section 446. Just I will read for a minute, Millards. Section 447 of the Companies Act 2013, which defines what is fraud.
These acts have happened prior to the amendment.
That is, there is no amendment question here.
No, 440.
No. 440 amendment, that is nothing, Millards.
ಆಯ್ತು 2:30 ಬನ್ನಿ. ಒಂದು 10 minutes.
10 minutes. 2:30 ಇನ್ನೊಂದಿದೆ ಅದು ಮುಗಿಸಿ ಬರ್ತೀನಿ.
ಮುಗಿಸ್ಕೊಂಡ್ ಬನ್ನಿ, ನೀವು ಬಂದಾಗ ತಗೊಂತೀನಿ.
I will come.
Whatever time you come.
That's kind permission.
ಮಾಡಿ. ಮಾಡಿ. ಸೆಟಲ್ಮೆಂಟ್.
Serial number 40.
ನನ್ನ ಮುಂದೆ ಇದೆಯಾ? ಕೊಡಿ.
My Lord's kind permission.
ಒಂದು ನಿಮಿಷ. There's one matter. 39 ಏನು?
Representing R2, my lord.
Foxona.
Yes, my lords, what happened here, my lords? My lords, the marriage was solemnized. Let's kindly come to.
Age of the victim?
19, my lord. On the date of marriage, my lord, 17 years, 3 months, my lords.
Now she is 19, my lord.
Now, my lords, after that FIR was registered on 10/6/2024, my lords. My lords, when at the time of pregnancy, ಹೊಟ್ಟೆ ನೋವು ಅಂತ ಹೇಳಿದಾಗ
ಕರ್ಕೊಂಡ್ ಬಂದಿದ್ದಾರೆ, ಹಾಸ್ಪಿಟಲ್
ಕರ್ಕೊಂಡು ಹೋದಾಗ ಡಾಕ್ಟರ್
ಅದು ಗೊತ್ತಾಯ್ತು.
Both are now married, my lords. They
made a scene out of saying that we are troubling.
ಹೌದು, troubling them.
Yes, my lords. That is what happened, my lords.
But they should.
ಈಗ who's in custody?
No, my lords. It is released on.
ನಾನೇ ಬೇಲ್ ಕೊಟ್ಟಿದ್ದೇನೆ.
Yes, no, my lords.
Filed a bail petition and pending. All right.
Now the
17 years, 3 months now.
But They should only, unnecessarily they made a allegation against the police officer.
My lords, no, my lords, that allegations are true, my lords. I have filed an affidavit to that effect, my lords. The
In that
respondent
case,
number
my lord,
2.
we'll also file an
My lords, it
ಅಲ್ಲ
is
ಈಗೇನ್ ಸೆಟಲ್ಮೆಂಟ್ ಇದಾಗಿದೆಯಾ? Have you drawn some
no stage
ಅಲ್ಲ DNA report ಬಂದಿದೆಯಾ?
DNA report, my lords.
Madam, DNA report ಇದೆ. I asked the DNA report to be placed. Reports of delivery and DNA that are conducted after delivery shall be placed before the court. ಇದೆಯಾ ಅಲ್ಲಿ?
Birth certificate.
Birth certificate is a DNA report. Jagdish sir, get the DNA report. ನಾಳೆ ತಗೊಳ್ಳಾಗತ್ತಾ? ಇಲ್ಲ
Next week.
we'll take it on 8th, 9th. ಅವ್ರು ಬರೋದನ್ ಅವ್ರನ್ನೇ ಕರೆಸಿದ್ರಿ?
ಇಬ್ರು
ಯಾಕೆ ಕರೆದ್ರಿ?
happily living, my lords.
Happily living ಅದು ತೋರ್ಸಕ್ಕ?
ಅಲ್ಲ, no, my lords.
Then
they are happy with the marriage, my lords.
happiness is a relative term, sir.
This is what we did not ask them. They produced that pregnant lady and your lordship's.
ಹೌದು, you got the lady. ಅಲ್ಲ ಅವಾಗ ಹಾಸ್ಪಿಟಲ್ ಕಳಿಸೋ ಬದಲು.
My lords, whatever allegation made, my lords, it is true, my lords. They have forced them to give the statement, my lords. In this complaint also, my lords.
ಈಗ ಅದೆಲ್ಲ ಆಯ್ತು.
The complaint, my lords.
ಈಗ ಮದುವೆ ಆಗಿದೆ, ಮಗು ಆಗಿದೆ, ಇರ್ಲಿ. Yes. DNA report ಅಂತ. I'll look into the DNA and close it. Yes. This court on 4/7/2024 had passed the following order. Pursuant to the said order, it transpires that the victim has delivered and the petitioner and the victim are now living together after their marriage. I have married and delivered after their marriage. What is waiting or wanting is the complete compliance with the order dated 4/7/2024 and the subsequent order, which is production of a report of the DNA after the birth of the child. Birth certificate is placed on Memo Akutaki. Birth certificate is placed on record. It transpires that the victim at the time of the occurrence of the incident was 17 years and 4 months. Today, the victim is 19 years. They are married and the child is born from the wedlock. In that light, list the matter on 9th at 2:30 p.m. Maran Karspedi. We close it. So the report kotre. Next date.
The leave of the court, my lord. Serial
was an interim order operating subject to me depositing 25 lakhs, my lord. That was almost 1 year ago.
482 ಅಲ್ಲ?
ಹೌದು. ಅದರಲ್ಲಿ ಆಕ್ಸಿಸ್ ಬ್ಯಾಂಕ್ಗೆ my lord had given specific directions to the bank. I had arranged for funds. Now, when I write an email to the bank to permit me, I'm just placing that memo, my lord, with that email. They say, you go contact the concerned police department for defreezing of the account. They are not letting me to deposit the money also to comply with this order.
ಮಧ್ಯಾಹ್ನ ತಗೊಂತೀನಿ. I'm coming back. Yes.
You
have some. ನಾಳೆ. ನೋಡಿ what tomorrow we'll take it.
Please.
Tomorrow at 2:30.
Serial number 43.
40. Respondent, petitioner yaru? If have informed them, bandre illa andre
lordships kindly serial number.
Arun enu?
My lord, the serial number 42 is also a similar case of POCSO where accused is 19 and 20 and victim is
interim order ಇದೆಯಲ್ಲ ಈಗ?
ಇದೆ please. That's why I'll keep the parties present.
9th January. Yes.
Lord, your lordship were pleased to dispose of writ petition 29438 of 25 with a direction to conclude the trial in 8 weeks.
ಯಾವುದು?
There was one civil suit for specific points. Your lordship had given a direction for concluding the trial in 8 weeks. That 8 weeks period is coming to an end. Lord, one of the documents had got impounded, because of which the file went to the deputy registrar's office.
Extension of time.
Just extension, Lord, your lordship. List tomorrow.
Tomorrow 2:30.
So
number 41, my lord.
Hey, Angad, today itself we'll get it.
Serial number 46, my lord. There is a compromise petition, compromise arrived between the parties. The date is fixed. We will keep the parties present.
Tomorrow?
First week of January.
9th.
Obligation.
Serial number?
46, please, your lordships. In the meanwhile.
Both the counsel for the petitioner and the respondent complainant submit that the settlement has been arrived at and would report the settlement on the next date. To report such settlement, list on January the 9th, 2026.
If this memo is taken on record, please, your lordships.
The memo is filed to that effect. The same is taken on record. Yes.
41, my lord, serial number 41. This honorable court passed the order. with
Lords,
regard
there is an
to-
interim order, Lords, I am for the complainant, Lords. Lords, neither.
ಏನ್ ಬೇಕೀಗ?
ಏನಿಲ್ಲ ಸ್ವಾಮಿ. The question, my lord, is that this honorable court permits.
Question we will answer after lunch.
Your lordship, serial number 40, your lordship.
ಮೇಡಮ್ ಯಾವ್ದು ಟೈಮ್ ಬೇಕು ಕೊಟ್ಟಿರಿ ಇಬ್ರು ಬೋತ್ ಸೈಡ್ಸ್ ಇದ್ರೆ ಮಧ್ಯಾಹ್ನ ಹೆಂಗ್ ಕುಂದಲ್ಲ ಅಪ್ಪಿದೆ.
My lords, serial number 11, your serial number 11, my lords. I'm appearing on behalf of SPP, your honor.
SPP?
Yes, my lords. Objection has to be filed, my lords. So 1 week of time may be given, my lords.
ಇಲ್ಲಿ ತಾಹಿರ್ ಇಲ್ಲೇ ಇದ್ರಲ್ಲ.
ಇಲ್ಲ, objection file ಮಾಡ್ತೀನಿ on the next.
6 months, 7 times they have taken time.
Wait.
Life
Maybe
is all
taken
this.
Wait.
They will say all that, there is no objection is required.
ಆಯ್ತು.
I'm waiting
For
since
lunch ಇದ್ರೆ ಹೆಂಗೆ
11:30.
ಆಫ್ಟರ್ ಲಂಚ್ ತೊಂದ್ರೆ ಆಗುತ್ತೆ.
Since 11:30 I'm waiting.
48 a week time, my lord. The interim order may be extended, my lord. Mute ಮಾಡಿ. ಅದು ಕ್ಲಾಶ್ ಆಗ್ಬೋದು. ಹೋಗ್ಬೋದಾ ಇಲ್ಲ? ಒಂದ್ ನಿಮಿಷ. Sorry. further hearing at 2:30 PM, 61.
61. ಯಾವ್ದು ಮೇಡಮ್? Password?
62.
Please. First, this is that matter, my lords, where PRR told, it was notified, PN was issued, my lords.
They told.
I had a discussion.
Told
with
alva?
Please, I had a discussion with the concerned.
Please, my lords.
So, my lords, they are so afraid for 2 weeks, my lords, they are trying to resolve this matter.
All right.
A date may kindly be fixed after 2 weeks.
Thanks.
Please, please, grateful.
Stay there.
Sufficient opportunity granted, my lord. Stay
Yeah.
there. Interim order may be extended.
There is an interim.
The Learned Counsel Ajay Kumar M submits that the issue would perhaps be resolved if 2 weeks' time is granted.
Please.
In that light, list this matter 9th January for further hearing at 2:30 PM.
Please.
Interim order subsisting would continue till the next date of hearing.
9th.
Grateful.
January.
9th January.
Please.
Yes.
Great.
9th Jan, madam. Yes. Now go back to. Huh? Appeals. The appeals ಮುಗಿಸ್ಕೊಂಡು ನಾವು ಬಿಡ್ತಾ ಇದ್ದೀವಿ. Appeals password.
Password. 22.
ಹಾ ಅಲ್ಲೇ ನನಗೆ ಒಂದೇ ನಿಮಿಷ. ಇನ್ನೊಂದೆರಡು ಅದಕ್ಕೆ ಮುಂಚೆ ಒಂದೆರಡು ಪಾಸ್ವರ್ಡ್ ಇದೆ.
Till number 11.
ಹಾ Tahir. No, why is it coming before me only?
Because Lordship has read the
Earlier order.
Earlier similar matter as well, not with the same petition, similar matter.
Same crime number? Then it has to come here. Yes.
But it is very short issue, Lordship.
Yes.
For FIR issue. Here, Lordship, there was a petition, NIA case also was there. In this
Correct.
NIA case, not.
Correct.
And look at this honorable court. The reasoning given was the earlier judgment. Lordship, judgment also have reduced it. Lordship, find petition number 12509. Page number 293, Lordship. 293.
All right. Yes, Heli.
Para number 20. The procedural judgment and by the export as quoted is above. What would unmistakably emerge that it's not a knowledge that can be multiplied by that. But for the past and accused by every same from the complainant or different accused on different or very same incidents. The case in hand from the distinction from those well settled principle of law that FIR would be hit by the doctrine of sameness. There is a case of writing have two different jurisdictions. One is from the jurisdiction of DJHL police station, another is the jurisdiction of KGHL police station. The incident of violence are different as narrated in those respective complaints. The complaints may be policemen, but they are different. Different complaints have narrated different incidents, although those incidents figures from the solitary fact. Therefore, what would become applicable is the law laid down by the expert in the case of Anju Chaudhary and the judgment of the Region Bench of High Court of Andhra Pradesh. Consider all that's been relied upon the present counsel, preparing for the petitioner and answer the same against the accused by holding that multiple FIRs are permissible. Lordship, kindly appreciate. What I comprehend from this reasoning is that, Lordship, the two I was never seeking a I was seeking the merging of FIR of the DJHL in one side, KGHL on one side. But what reasoning was given that appears to me that Lordship understood that I am making attempt to club both the incident together, and on that premises the petition was filed. Lordship, here two petitions are there. It is one set of offences are in KGHL, other set of offences are DJHL. And I was seeking in this same petition the different petition. My Lordship permit me, I will reduce my argument, complete my argument very short point.
File my objection, my lord.
All right, now what's the stage?
Evidence commenced, my lord. Charges is framed and evidence is commenced independently in all the cases.
Evidence is commenced?
So, Lordship, nothing has been commenced. This is the stage of all the cases. Still charge is not framed. Even Lordship, assume that for a moment. Even charge, I'm not seeking the quashing of the charge sheet.
Correct, you're only saying one should go on.
Clubbing it. If the same stage will be continue.
I'll file my objection.
Even the evidence we recorded same will be considered.
This requires some consideration, my lord.
You can always club the things and do it. Why multiple cases?
You
file your objections, not a problem. You file your objections. What is the next date, Tahir?
Next date is multiple cases or dates also mentioned. Also.
18/12, 8/12.
It is based on the earlier date. Now all the dates are in month of December only.
All right. We'll give him one.
I seeking a stay also in the proceeding as an interim prayer.
Stay agbitre kashta na.
I want to dispose it. I don't want to.
Correct. That is why even I want to dispose it, not stay.
Here also they took us for sufficient time for objection. If Lordship will see the order date 24.
No, finally I will grant them a week's time. Next week by 5th December, if you don't file, then we will pass orders hearing him. Heard the learned counsel Mohammed Tahir appearing for the petitioner. The learned counsel submits that multiple FIRs are registered on the same incident and seeks clubbing of all the FIRs and taking up a trial together, which would be in tune with law. The learned HCGP Tejesh seeks a week's time to file a statement of objections. Time has been granted on umpteen number of occasions for filing of statement of objections. In that light, as a last chance, a week's time is granted to file statement of objections. List the matter on 5th December. Objections, if any, by then. Yes.
Special PP in this matter, not HCGP.
Yaru?
Withdrawal and
ನೀವು
special
special
PP,
PP,
please.
special public prosecutor Tejesh ಅಂತ.
Please.
Further hearing 22.
ನೋಡಿ ಒಂದು ಸ್ವಲ್ಪ ಹೊತ್ತು ಮಾಡಿ ಆಮೇಲೆ ನೋಡಿ.
And only with reference to the application filed, may not under section 220.
No, they have not argued on the merit of the matter. Now, clubbing application plus ಇನ್ನೇನ್ ಮಾಡಿದ್ನೀವು? Clubbing ಒಂದೇ ಅಲ್ಲ?
Clubbing ಒಂದೇ ಮಾಡಿದ್ದಾರೆ.
Yes.
So I'll restrict my not submission only with reference to the application that I have filed. On may I bring to your lordship's kind notice. Now the wordings of not section 223 may not of CR.
Yes. Yes.
Section 223, what persons may be charged jointly? The following persons may be, not your lordship kindly may not observe these two not words. Following persons may, number one is may, discretion of the court, may be charged and tried together.
Directory.
Charge, one is directory. I'm not charged and tried. Apex court may not interpret the word charged and tried, saying when one's trial concludes with reference to one set of the matters, you cannot file such an application under section 223. At the most, what you can do is keep this appeals pending, let the trial in the case that is pending before the trial court go, and then hear all of them together. That's all.
Correct. Now, when cases are pending, this is decided already.
That situation also has been considered by the apex court. Let's keep these appeals pending. That's all it says. Not by bringing.
So now you mean, sorry to digress. Now are you suggesting that I should keep this pending and let the trial go on in that?
That's what apex court has said.
The court has said it can't be done.
That's what in fact, I have all the judgments on the point. I'll bring to your lordship what the apex court has said. It's not that I'm saying anything. May I just bring to your lordship notice?
Yes.
A few judgments on the point.
Yes.
Though I have cited in as much as 16 judgments. But I will be referring to your lordship and I will be troubling your lordship only with not serial number 1 to 7.
No, you can cite all the 16.
Repetition of not what is there.
Yes.
But the first one, 1971 part 3 SCC 983.
Yes, yes.
But paragraph number 5 and 6 may not may kindly be seen. But in page 5 and 6.
Yes, sir.
Paragraph 5, not in page 5. Turning to the provisions of the code, section 230, that's not under the old code. 233 embodies the general mandatory rule providing for a separate charge for every distinct offense and for separate trial for every such charge. The broad object underlying the general rule seems to be to give to the accused a notice of the precise accusation and to save him from being embarrassed in his defense. by the confusion which is likely to result from lumping together in a single charge distinct offences and from combining several charges at one trial. There are, however, exceptions to this general rule, and they are found in section so and so. These exceptions embrace cases in which one trial for more than one offence is not considered likely to embarrass or prejudice the accused in his defence. The matter of joinder of charge is, however, in general discretion of the court, and the principal consideration controlling the judicial exercise of this discretion should be to avoid embarrassment to the defence by joinder of charges. On the appellant's argument, the only provision requiring consideration in section 235(1), which lays down that if in one series of acts so connected together as to form the same transaction, more offences than one are committed by the same person, then he may be charged with and tried at one trial for every such offence. This exception, like the other exception, merely permits a joint trial. This is what it says, may joint trial of more offences than one. It neither renders a joint trial imperative, nor does it bar or prohibit separate trials. Then,
yes.
Para 6, I'll permit me to read from page number 6 onwards.
Yes, yes.
Defense should be held to be binding in the case or on basis of principles of issue estoppel, which is applicable to the criminal trial and is accepted in India. Separate trial on the charge of causing so and so death, as already observed, is not contrary to law, even if a joint trial of this offence along with the other offence were permissible. Let us see if the joint trial was permissible. That would depend on question whether the present offence was committed in the course of same transaction in which the other offence was committed. Now, this matter was required to be considered by the trial court. Kindly mark not these 3 lines. Now, this matter was required to be considered by the trial court at the beginning of the trial, and it is not to be determined on the basis of result of the trial. This view of the apex court in 1971 is fortified not in the subsequent judgment that your lordship will find, page number 9. Naseeb Singh, serial number 2, page number 9. Not the latest, probably 3 judges. Paragraph number 21, not at page 30.
Yes, sir.
Page 30. She so and so speaking for Constitution bench observed in Uka Kolhe case as under. An order for retrial of the criminal case is made in exceptional cases and not unless the appellate court is satisfied that the court trying the proceedings had no jurisdiction to try it, or the trial was vitiated by serious illegalities or irregularities, or on account of misconception of the nature of the proceedings, and on that account.
Second one,
that has to be done at the initial stage. What they did, in fact, what they had approved this honorable court.
When would the illegalities emerge? At the outset, if you say trial should be conducted, if one of the reasons for conduct of a retrial at the hands of this court is that there have been several illegalities in drawing up the trial.
For which
how can you envisage that in the beginning of the trial? It is only after the conclusion of the trial.
That's what apex court says. That's what apex court says. That cannot be done once trial is concluded, when appeal is pending.
But what is that the sentence of the apex court that if there is retrial can be ordered if there is serious illegality?
For which apex court says you will have to assess the evidence, which virtually amounts to not hearing the appeal. It says assess the evidence anತಾರೆ.
ಅದಕ್ಕೆ ನಸೀಬ್ ಸಿಂಗ್ ಅಲ್ಲಿ 357-58
ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡುವಾಗ irregularity was noticed.
ಅದೆಲ್ಲ ಡಿಸ್ಕಸ್ ಮಾಡಿ ರೀಟ್ರಯಲ್ ಯಾವಾಗ ಆರ್ಡರ್ ಮಾಡಬಹುದು ಅಂತ 56, 57, 58.
Recording of 313 statement would come into picture only after the recording of evidence was concluded.
Yes. No, whether joint trial was required or not will come only after the trial.
Not for which apex court says we have to read the evidence.
Other appeal will have to be heard.
Appeal will have to.
Oh, you mean to say that the threshold question of that kind cannot
That's
be.
What it says.
Para 29 alli ಇದೆ.
By page 46, your lordship will find in that compilation. Para 56.
ನಸೀಬ್ ಸಿಂಗ್ ನೋಡಿದ್ರೆ ಈ ಕೇಸ್
ನಸೀಬ್ ಸಿಂಗ್ ಹೇಳ್ತಾ
ಇಲ್ಲ, ಈ ಕೇಸ್ ನಸೀಬ್ ಬೇರೆ ತರ ಇದೆ.
Yes. not 56, not page 46, not 56.1213.
Exactly, ಅಲ್ಲೇ ಬನ್ನಿ.
I was referring to not 56.2. The 56.1, the statutory provision neither renders a joint trial imperative, nor does it bar or prohibit separate trials.
It is not imperative.
Of course.
Nobody is saying it is imperative because
No,
it's
they
only
came
may.
up, not in fact.
May ಅಂತಿರೋದ್ರೆ may does not make something imperative unless there is circumstances.
Please, not they came before this honorable court, this very accused, the appellate.
That is adhe ತೋರಿಸಿ ಅದು ಯಾವುದು.
Please, may I just kindly have a look at.
No, did they come before this court asking for joint trial?
Prayer not in this order is extracted.
ರತ್ನಕಲಾ madam ತಾನೆ? Yes.
Otherly, page 5 is the prayer.
Hello, page
5 is the first prayer, not page 6, not is the second prayer. The first prayer was to not quashing the remaining charge sheets. Second was.
Treat it as supplementary charge sheet ಅಂತ.
ಹೌದು.
ನಾಲ್ಕು charge sheet ಯಾಕೆ supplementary ಅಂತ treat ಮಾಡಿ?
Say that it's one trial. They wanted to ultimately say.
Charge sheet stage ಅಲ್ಲಿ ಇತ್ತು ಇನ್ನು ಅದು.
ಅದು charge sheet ಆಗಿತ್ತು. It was the stage when the trial may not commence.
ಅಲ್ಲ ಒಂದೇ ಟ್ರಯಲ್ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಇಲ್ಲಿ?
ಅದು not ಇಲ್ಲಿ page 6 ಅಲ್ಲಿ issue writ of mandamus directing respondent to treat the charge sheets in so and so as respectively as supplementary charge sheet filed in mains, that special CC 105 of 2003. But they wanted not clubbing of all the CCs.
Where did they want clubbing?
But they said treat the charge sheets filed in so and so
clubbing
as
of
supplementary charge sheet.
Clubbing of charge sheet.
They give up not this prayer in this very petition. They say we are not pressing on this prayer.
Correct. There is no decision on that.
They approached this honorable court. They did not press upon it. Subsequently, also during trial, they did not file any such application.
No, you mean to say they approached this court. They did not press upon it. They are barred from impressing upon it now.
They had an opportunity, not when the trial commenced, when the charges were read over. If really, my lord, they were under the impression that there should be a joint trial. It is not a case where, my lord, accused are not represented by advocates. They are all represented, my lord, by advocates. They never have not made a prayer before the trial court that all the cases
are they making it for the first time here?
Yes.
Before this court, in this petition? All right, that we will answer. Yes.
On this page 46, not 56.2, I was bringing to Lordship.
Yes, yes.
The matter is required to be determined by the trial court at the beginning of the trial, and it is not to be determined on the basis of result of the trial. This is where not the bar is. Then not. Then on page 47, para 61, not last 3 lines. It would also say, in this case, the trial may not commenced. Almost not 11 years back. Page 47, para 61, last 3 lines. With a lapse of over 7 years since the date of incident, a retrial would not advance the cause of justice, but would result in a serious miscarriage of justice. The judgment of the High Court is travesty of justice also. This is the crux of the issue, not in this case. Then, third one, not Lalu Prasad. I had cited this case before your lordships.
For another case.
Para 10, 11, and 14.
Yeah, Tahir or case.
I know the same.
Yes, yes.
NA case.
Case, yes.
Really. On page 55,
ಇದೆಲ್ಲ ಪ್ರಸನ್ನ ಕುಮಾರ್ sir.
Please.
All these judgments, of course, they speak in a singular voice. One, that it is not imperative. It should be at the beginning of the trial. But this statements of the apex court is laced with two circumstances. One is prejudice, one is failure of justice.
Of course.
If they are able to show prejudice or is the result of a non-trial or whatever now they are asking has resulted in failure of justice, then whether it is there or here, we will have to consider it.
For which?
Consider it. Because
for which?
It's a criminal appeal.
I understand. For which, not apex court says, not page serial number 7 of the judgment. 133.
ಅದಕ್ಕೆ ಈ ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಎಲ್ಲ ಹೇಳಿರೋದು ಕರೆಕ್ಟ್ ಅದೇನು
ಅದಲ್ಲ 133 ನಲ್ಲಿ what is said by the apex court is 133. But relevant not would, is at page para 60.
One ನಿಮಿಷ. ಅದೇ 3 ಆದ್ಮೇಲೆ ತಗೊಳ್ಳಿ ಅಂತ.
3 ಆದ್ಮೇಲೆ ತಗೊಳ್ಳಿ ಅಂತ.
ಅದೇ ಪ್ಯಾರಾ 60 ಅದೇ ಹೇಳಿದ್ರು.
After conclusion of the trial,
Supreme Court,
take
later
up these
judgment, a
appeals.
larger bench of the Supreme Court said it is not possible. You can't remember. You keep one case and.
ಮುಗಿಸ್ಬಿಡಿ.
I'm sorry.
Yes, sir. Yes, sir.
Para 60, not at page 152. Keep the appeals pending, take it up after the disposal of the trial. And not in Lalu Prasad Yadav's case, not which you have also not seen, all the accused must be heard. All the accused must be, opinion must be sought whether they want joint trial.
ಇಲ್ಲಿ ಯಾವ ಅಕ್ಯೂಸ್ ಬಾಕಿ ಇದ್ದಾರೆ ಇಲ್ಲಿ?
But now the one of the accused is saying, I don't want joint trial.
Who is our accused? ಬದುಕಿಲ್ಲ.
Company is there.
Accused is no more. He will tell anything.
But in fact, this issue, whether company could be prosecuted in the absence of not the director,
Yes.
has been considered by this.
Yes, 305 ಇದೆ. Yes.
305.
No, those cases are still pending there. ನೀವು ನಿಮ್ ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್ ತಾನೆ, ನಿಮ್ದು ನೋಡ್ಕೊಳ್ಳಿ. ಅವ್ರ ಆಯ್ತಾಯ್ತು, ಸರಿ ಮುಗಿಸ್ಲಿ ತಾಳಿ, ಪ್ರಸನ್ನ ಕುಮಾರ್ ಮುಗಿಸ್ಲಿ.
But then not your lordship will find.
Lalu?
One more submission of
Lalu Prasad Yadav.
Lalu Prasad Yadav only. Not one of the submission
Para
was that
10.
entire evidence is cut and paste. Cut and paste ಮಾಡಿ ಅಂತ ಇದ್ರ 50 page 59 Supreme Court ಹೇಳಿದೆ.
ಯಾವ್ದು? ಲಾಲು ಪ್ರಸಾದ್ ಯಾದವ್ ಅಲ್ಲ.
If your case is that everything is one and the same, then let the evidence in.
Then it is a fit case for a joint trial.
ಅಲ್ಲಿ ಆಗೋಗಿದೆ, ಈಗ ಟ್ರಯಲ್ ಆಗೋದಕ್ಕಿಂತ ಮುಂಚೆ ಹೇಳಬೇಕು. All these cases say that you should come up with this contention.
No, the appeal remedy is available to unscramble a scrambled egg.
And then the apex court says how to hear the.
Generally you cannot.
For which apex court say appreciate the evidence and then decide anta. That's where not the.
ಹೇಳಿ.
On this page 59,
Lalu Yadav.
Yes. Before we part, it must be mentioned that it has been complained that the appellants would be forced to hear the same evidence 5 to 6 times. If the appellants or any of them feel aggrieved by this, and if they so desire, they may apply to the special judge that evidence recorded in one case and documents marked as an exhibit in one case be used as evidence in other cases also. This would obviate their having to hear the same evidence in 5 to 6 different cases. We are sure that if such an application is made, the same will be considered by the special judge on its merits after hearing all the other accused.
ಅದಾದ್ರೂ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಇದ್ರಲ್ಲಿ.
ಇವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು.
ಅದೇ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲದೆ ಕೋರ್ಟ್ ಮಾಡಿರೋದು ಅದನ್ನೇ.
Not they were aware of their rights. They come up before this honorable court. Withdraw the prayer. For the first time, not in the appeal.
Whether that can be done or not.
That case, ಇನ್ನೊಂದಿದೆ, one more view. Not serial number 4, page 60.
Para 31, 31.
Please.
Singh is followed. Para 32, Ali Nasib Singh is followed. Nasib Singh. 33, 34 is what is said.
Para 28, not page 71. In this case. In the middle of this para 28, the identification of such mistakes at appeared stages, which could have easily been spotted and corrected during trial, does not only affect the finality of cases, but also affect the credibility of the criminal justice system as a whole. The trial court does the job.
One thing we'll have to, because ಎಲ್ಲ ಇಟ್ರಲ್ಲಿ ಅಂತ ಕಳಿಸ್ತಾ ಇದ್ರು.
Then not para 32, not reiteration of not Nasib Singh. Page 74, not para 51.4. 51.5 not.
Where?
51.3 and 51.5, page 74 not. I saw above this para 33.
Nasib Singh follow.
Nasib Singh extracted.
Quotation from Nasib Singh.
Please, my lord. The possibility of conducting a joint trial will have to be determined at the beginning of the trial and not after the trial based on the result of the trial. The appellate court may determine the validity of argument that there ought to have been a separate or joint trial only based on whether the trial had prejudiced the right of the accused, that your lordship cannot have observed. Then not 51.5, conviction or acquittal of the accused cannot be set aside on the mere ground that there was a possibility of a joint or separate trial. Please, my lord. To set aside the order of conviction or acquittal, it must be proved that the rights of the parties were prejudiced because of joint or separate trial, as the case may be.
That's exactly what I said.
Please.
All the rights of the parties are laced with rights or obligations, laced with two concepts: prejudice, failure of justice.
Adana young marbeku anta para 35 le helta. 35 no. This is what
That's exactly what prejudice.
Kindly permit me to just first 10 lines of this para 35. It could be seen that the sole basis of the High Court's reasoning in arriving at a finding of prejudice in the impugned decision is that a joint trial was not permissible. The finding is unsustainable, and in fact, there is no finding of actual prejudice or failure of justice as a result of joint trial, as necessitated by law. As noted above, the High Court ought to have analyzed the facts of the case to return the finding of the actual prejudice. Mere non-compliance of the procedure contemplated under Section 223 does not ipso facto render the trial as invalid, and the same cannot form the basis of returning a finding of prejudice and failure of justice. The said conclusion, these two lines I was bringing to lordship by notice. The said conclusion must emanate from the facts of the case after a thorough examination of facts and evidence on record. Which virtually will not apex court says matter will have to be heard.
Next line.
Please, it is not a case where joint trial precluded the respondent number 1 and 2 from presenting a valid defense. It is also not a case where separate evidence of the prosecution witness could have made. These are a different, contrary this one.
No, facts of those cases.
Facts of those. Thorough examination of the facts and evidence on record will have to be seen, which may not, in my humble submission, again would require hearing. Not these judgments would say. And if they were to say there is a defect in framing of charge, then 464, 465 would take care after the judgment.
Again prejudice.
For which trial is appeal will have to be heard.
Amale.
Then serial number 8. Under what circumstances a de novo trial should be ordered? Or while considering an appeal, powers under Section 386, page 153. Paragraph number 41. Paragraph number 41, page 173. First, the appellate court hearing a criminal appeal from a judgment of conviction has power to order retrial of the accused under Section 386 of the Code. This is clear from the bare language of Section 386B. Though such power exists, it should not be exercised in a routine manner. A de novo trial or retrial of the accused should be ordered by the appellate court in exceptional and rare cases, and only when the opinion of the appellate court such course becomes indispensable to avert failure of justice. Surely, this power cannot be used to allow the prosecution to improve upon its case or fill up the lacuna. A retrial is not the second trial. It is continuation of the same trial and same prosecution. The guiding factor for retrial must always be demand of justice. Obviously, The exercise of power of retrial under section 386B of the code will depend on the facts and circumstances of each case, for which no straitjacket formula can be formulated, but the appeal court must closely keep in view that while protecting the right of an accused to fair trial and due process, the people who seek protection of law do not lose hope in the legal system, and the interests of society are not altogether overlooked.
ಅದು ಥಿಯರಿ ಪ್ಯಾರಾ 44 ನೋಡಿ ಪ್ರಾಕ್ಟಿಕಲ್ ಆಗಿ ಏನ್ ಮಾಡಿದ್ರು.
Please.
Indispensable.
Of course.
In those facts, of course. Yes.
Exceptional case. For which not evidence will have to be read. That's what.
ಅದೇ ಹೇಳಿಲ್ಲ. ಅಲ್ಲ ಅದನ್ನ if you have to connect the dots, then yes.
Evidence ಓದಬೇಕು, evidence ಓದಿ, then you will have to be not certain.
Next.
Not serial number 11. Not. I made a submission that they could have raised this issue earlier. But Apex Court has said, not in Pradeep Puder versus State of Karnataka, page 119. That's under MMDR Act. Not paragraph number 4040 mechanism.
Pradeep Puder. ಅದ್ರಲ್ಲಿ ಕನ್ಕ್ಲೂಷನ್ಗೆ ಹೋಗ್ಬಿಡಿ ಪ್ಯಾರಾ 108. ನೀವು ಪ್ಯಾರಾನ ಓದ್ಬೇಕಲ್ಲ, ಕನ್ಕ್ಲೂಷನ್ ಅಲ್ಲಿ ಎಲ್ಲ ಇದೆ.
Page 223 ನೋಡಿ, I will bring to you para 40.
ಓದಿ ಯಾವ್ದು ಹೇಳಿ. 223
page 223 para 40 But section 465 has been extracted. Just below that,
curable defects.
The general principle which is embodied in section 465 CRPC is that a finding or order is not reversible due to irregularities unless a failure of justice is proved. Subsection 2 of section 465 provides that while determining whether there has been a failure of justice, the appellate court shall have regard to whether the objection regarding the irregularities could and should have been raised at an earlier stage in the proceedings. The observation in Rattiram distinguishing Gangula Ashok on the basis of the stage of trial thus takes its support from section 465(2) of the code, where a classification is sought to be made on the basis of challenge vis-a-vis stage of the proceedings. Then para 41, section 465 stipulates that the order passed by a court of competent jurisdiction shall not be reversed or altered by a court of appeal on account of any irregularity of the proceedings before trial or any inquiry. It is settled law that the cognizance and pretext so and so, so and so.
That was a case where
Please,
cognizance was taken on a police report.
The issue is
without giving any reason, and the charges that were framed were an amalgam of two different MMDR and IPC.
Ultimately, the fact remains that when whatever cases are covered under did you take this contention before the trial court? You faced the trial for 15 years and just keep quiet.
Your bottom line is that in sense your foundation is that you that they had to take this contention at the outset. Now having suffered conviction, they cannot go back and say that yes, we had to joint trial agidre, it would have been. Now the issue is whether while answering an appeal and 386, this court can direct a retrial for that purpose without getting into evidence. That is all you have to convince.
Evidence, that's what I brought to
you. Evidence wherever he has said go into the evidence. That at the threshold, can this court answering an appeal travel at the periphery and annul it and send it back to delve deep into that? That you may have to answer. Yes, answer.
That's what serial number 14 and 15 of the judgment says. Its burden is on the accused. Serial number 15 at page 295. paragraph number 18, my lord. The general principle, that is for the accused to prove, failure of justice, of course. Para 18 at page 305. This is for the accused to prove that omission to frame charge has occasioned a failure of justice.
Para 23 at 307.
Please. But I am not for a moment saying that appellate court will have no jurisdiction. Definitely not. All that I am saying is,
no, the
for determining whether a joint trial could have
everything
been
is
done.
writ large before the appellate court. Everything is
Of course. That's what
powers
86
are
also says.
too wide.
Definitely, definitely. It is much wider than what the trial court could have
Yes,
done.
yes.
But it's not the fact.
It is continuous.
Of course. With little higher powers, of course. Not but
Higher
deciding that.
higher powers.
But whether they could have taken this contention will have to be taken. To see whether there is really a failure of justice, evidence will have to be assessed. Therefore, my submission was that this application cannot be considered. Apex court also has said that you await for the trial of the other case.
So they have not submitted anything on merits. There's only a joint trial application that is being argued.
And Lalu case, Apex court has said you must hear all the accused.
But we'll see. One accused is saying,
Not only here, there's a trial pending. We don't know who are the accused persons there.
ಅಲ್ಲಿ ಬಿಡಿ ಬೇರೆ ಇಲ್ಲಿ accused who's wanting no don't do a joint trial accused illa.
That is covered by judgment of this honorable court 305 CRPC. Even in the absence
company,
of
yes.
Company.
That will. No, company ಏನಂದ್ರೆ company to what extent? Not for the offense. Company will be liable for 34.
Of course.
Company only 34.
Sanofi India versus CBI that has been addressed by this honorable.
ಬೇರೆ ಏನಕ್ಕೂ ಆಗಲ್ಲ. Company only 34.
ಅಷ್ಟೇ.
And 34 is not a substantive offense. It is only for the purpose of fine.
Not only this, the other trial pending. We do not know who are the accused.
ಅವ್ರಿಗೆ ಗೊತ್ತು.
ಅಲ್ಲ ಅದನ್ನ ಇವ್ರು ಅಪೀಲ್ ಡಿಸೈಡ್ ಮಾಡಕ್ ಬರಲ್ಲ. ನಾವು ನಿಮ್ ಜೊತೆ ಟ್ರಯಲ್ ಮಾಡ್ತೀವಿ ಅಂತ ಇವ್ರು ಹೇಳಕ್ ಬರಲ್ಲ. ಅವ್ರನ್ನ ಕೇಳಬೇಕು.
ನಾವು ಪ್ರಸನ್ನ ಕುಮಾರ್ ಸರ್. ಇದ್ರಲ್ಲಿ ಕನ್ವಿಕ್ಷನ್ ಆಗೋಗಿದೆ. ಇನ್ 3 ಜನದ ಬಾಕಿ ಇಟ್ಕೊಂಡು ಯಾಕೆ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ? ಅಲ್ಲ ಸೆವೆರಲ್ ಅದರ್ ಅಕ್ಯೂಸ್ಡ್ ಅವ್ರ ಕನ್ವಿಕ್ಷನ್ ಆಗಲ್ಲ ಹಾಗೆ ಆಗತ್ತೆ. ಯಾಕೆ ಹಾಗೇನಿಲ್ಲ ಅಂದ್ರೆ ಅದು ಹಾಗೇನಿಲ್ಲ ಆಗ್ಬಿಟ್ರೆ ಅಲ್ಲ ನೀವ್ ಹೇಳ್ದಂಗೆ ಹಾಗೇನಿಲ್ಲ ಆಗ್ಬಿಟ್ರೆ ಈಗೂ ಉಂಟೆ ಆಗತ್ತೆ.
Entrustment is one single letter. PC Act is invoked. The allegation in the entire 9 cases that you have colluded with other accused. How can they say?
No, the offense against all these, charges against all these were so intertwined. It was impossible more itkondu mekkidu.
No, it depends on the time. The period during which it is committed. Not easy for a moment suggesting ಇಲ್ಲ ನಾವೆಲ್ಲ ಒಟ್ಟಿಗೆ ಕೂತ್ಕೊಂಡು ಕಾನ್ಸ್ಪಿರಸಿ ಮಾಡಿದ್ವಿ. One ನಿಮಿಷ.
No, the conspiracy for what purpose is the same. All right. Conspiracy, yes, it can, the meeting of minds can happen
different
anywhere.
accused to different times.
So conspiracy, minds are met and hatched in secrecy. That we'll see when
then
it is
tomorrow
executed.
they may contend. No, I was not a part of this conspiracy. He is different, I am different.
Because
we are not part of same conspiracy. When it comes here, they will say, no, it was a full conspiracy. Not easy. Not on the lighter side.
Earlier concept of what when criminal law began, earlier concept of what criminal conspiracy was. Conspiracy is hatched in secrecy and executed in darkness. ಅಷ್ಟೇ ಇದ್ದಿದ್ದು. ಈಗೆಲ್ಲ ಅದೆಲ್ಲ ಏನಿಲ್ಲ. Hatched in secrecy ಅಷ್ಟೇ. ಅವಾಗ ಬೇಕಾದ್ರೆ execute ಆಗುತ್ತೆ.
To be on the lighter side, he is my learned friend Naik suggesting ಇಲ್ಲ ನಾವು ಆಲಿಬಾಬಾ ಮತ್ತು 40 ಜನ ಕಳ್ಳರು ನಾವೆಲ್ಲ ಒಟ್ಟಿಗೆ ಇದ್ವಿ ನಮ್ಮನ್ನ ಒಟ್ಟಿಗೆ ಮಾಡಿ ಸಪರೇಟ್ ಮಾಡ್ಬಿಡಿ ಅಂತ ನಾನು ಹೇಳಿದೆ. That is not the case here. ಇಲ್ಲ ನೀವು ಹೇಳ್ತಿರೋದು. Not our charge sheet is different. Not time is different. Not there are different accused persons for different part of the charges. Conspiracies. Even to determine the question that they have raised, evidence will have to be ready.
Yes, sir. ಅದೊಂದು you have to convince. ಏನ್ನ? ಇನ್ನು ಕ್ವೆಶ್ಚನ್ ಪೂರ್ತಿ ಕೇಳಿಲ್ಲ ನಾನು. No. Appellate court can do it without getting into evidence. A threshold, as I told you, can in the periphery move into the issue, conviction, set it aside and send it back for retrial without getting into evidence. He says every evidence has to be looked into. And one more thing, court in an appeal stage can look into evidence andre, it should be complete evidence as if you're answering an appeal or again at the periphery. That's all.
I have filed this application. If this application is decided in my favor.
You need not go into the merits.
That is how your lordship started hearing on this preliminary issue. That was the observation.
No, I started hearing.
Yes.
But if I have to pass orders, then you should give me ammunition.
That is the reason, last time when the lordship heard me in
Huh.
I gave the initial facts to show that it is part of the same process. How the facts are interpreted. That is the reason I gave that booklet and I gave the charge sheet of other three cases and showed the number of documents which is relied upon, how these are interconnected, all those things I have pointed out last time.
Judgments.
Therefore, that fact is sufficient.
Judgments ಕೊಟ್ಟಿದ್ದೀರಾ?
Judgments.
I issue.
Same kind as
Then I will hear Nagesh sir.
Yes, ma'am.
On this issue, sir.
What I submitted to your lordship the other day is number one, charge is framed against the accused for an offence under section 409. On the ground or on the score that he was, and first accused was entrusted with the properties in question. And 409, my lord, would give us an indication that he has conducted himself contrary to the terms of entrustment. That is the case of the prosecution. Obviously, there is a case of the prosecution. But he has been convicted for an offence under section 379 and 420. That is number one. He could not have committed an offence under section 379 because he being the first accused in the case, even right from the time when the forest offence crime came to be registered, accused property in trust ಮಾಡಿದ್ದಾರೆ ಇವರು. Where is the question of he committing theft? That is number one.
ಆ ತರ ಲ್ಯಾಕಿನೇ ತುಂಬಾ ಇದೆ. That they're all facts. See, facts.
Without going into the evidence.
They're all facts on record.
Yes.
So facts on record ಲ್ಯಾಕಿನೇ ತುಂಬಾ ಇದೆ. Facts are stubborn.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಏನು ಹೇಳಿದೆ ನಾನು ಅಂತಂದ್ರೆ the other submission which I made was, for me, my lord, the conviction is for an offence under section 379 and 420. But no other charges framed against me, be it for an offence under section 406, 409 with the aided assistance of 120B or under section 34. 34 illa, 120B no illa. Straight away, my lord, I am charged with having committed.
409.
Allah, 379 and 420. Aurge the custodian of the property 409. Illa 379 hang barutte. I should dispossess a person who is in lawful possession of the property without his knowledge or consent, is how theft has been defined under section 378.
Yes.
Was my submission. Is it their case that I dispossess with that man without his knowledge or consent? ಅದು ಹೇಳಬೇಕು. 420 ಪ್ರಶ್ನೆ ಬರೋದೇ ಇಲ್ಲ ಇದರಲ್ಲಿ. The other day 420 ಬರಲ್ಲ. 450 420 ಬರೋದು. I don't know how I am convicted for an offence under section. ಅದಕ್ಕೋಸ್ಕರ my learned friend Mr. Prasanna Kumar should have some grace and tell me, look here, you are right. Instead of you getting the benefit of an acquittal judgment of acquittal straight away, you are asking for remand. Let it go. Otherwise, I am entitled for a judgment of acquittal.
Submissions my senior friend has made. Submission which my learned senior friend has made. They have been considered, my lord, in several judgments. If there is a conviction without charge, what should happen? What is 465, 464? Lord, we have learned all this from him.
Point I can ask before your lordship is
that, of course,
my learned friend said the evidence, whether evidence could be looked into or not. ಇಲ್ಲಿ evidence ಎಲ್ಲಿದೆ ಅಂತ. Cut and paste is not evidence. That's what the Supreme Court has said. My lord, I invited my lord's kind attention to the law laid down by the Supreme Court, not Lallu. Lallu is earlier. The latest judgment of the Supreme Court, which came to be delivered on September 12th, 2025. Maman Khan's case. It is no longer evidence. It can't be read as evidence in the case.
Maman Khan, yes.
Maman. Well, may I request you lordship to kindly turn to page 17, 20 and 25. This is the latest statement of the Supreme Court. Not only they must be tried together anta, but also cut and paste ಮಾಡ್ಕೊಡುದು ಅಂತ. That is not evidence. You can't read that as evidence.
ಆಮೇಲೆ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಸರ್, ನೀವು ಹೇಳಿದ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಆಫ್ ಲಲ್ಲು, ಇಟ್ ವಾಸ್ ಓನ್ಲಿ ಪಾಸಿಂಗ್ ರೆಫರೆನ್ಸ್. ಪಾಸಿಂಗ್ ರೆಫರೆನ್ಸ್ ಅಲ್ಲಿ ಈಗ ಇನ್ನೇನ್ ಕೆಳಗೆ ಹಾಕ್ಬೇಕಾದ್ರೆ ಇದೊಂದು ಹೇಳ್ಬಿಡಿ ಅಂತ ಹೇಳ್ತೇವೆ ಅಷ್ಟೇ. ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ, ಅದರಿಂದ ಹೇಳಿದ್ದು ನಾವು ಹೇಳ್ತೀವಲ್ಲ, ಅದು ಬೇಕು ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ಯೂಸ್ ಮಾಡ್ಕೊಳ್ಳಿ ಎವಿಡೆನ್ಸ್.
ಅಲ್ಲ, ಈಗ ಅವ್ರು ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ ಅಂದ್ರೂ ನೋಡ್ಬೇಕು ನಾವು ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ ಆಗಿದ್ಯಾ ಅಂತ. That's why I am saying that it's virtually appreciation of evidence. But this appeal
cut and paste ಅಲ್ಲಿ ಯಾವ appreciation?
But we will have to see not each of the cases whether it is done or not. We do not know what are the
allegations. ಐವೋದು cut and paste. ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ ಐವೋದು ಕಾಮ full stop. I don't know how my learned friend Melod in his wisdom would endorse. Yes, it is separate evidence which came to be recorded. It can't be a separate evidence. It is no longer evidence in the eye of law. Well, this is what the Supreme Court has said in Maman. This is on September 2025.
Yes, yes.
Lallu Melod is in 2003. Have a look at this paragraph, Melod, at page 17. Kindly go to page 17. Internal page 17 of the judgment. From the above, the following proposition stands reiterated. First, their lordships would deal with 218, then 219 and 223. The decision to hold a joint or separate trial must ordinarily be taken at the outset of the proceedings. The two paramount, etc. Well, now kindly go to the next page. Roman 4. Roman 4. Evidence recorded in one trial cannot be imported into another, which may give rise to serious procedural complications if the trial is bifurcated.
ಅಲ್ಲೊಂದು ಸೆಂಟೆನ್ಸ್ ಇದೆ, ಜಾಯಿಂಟ್ ಟ್ರಯಲ್ ಮುಂಚೆನೆ
ಕೇಳಬೇಕಾಗಿತ್ತು.
ನಾವು ಜಾಯಿಂಟ್ ಟ್ರಯಲ್ ನಾನು ಕೇಳ್ತಾನೆ ಇಲ್ಲ ನಾನು. I am not asking for joint trial. But here next order is an order of conviction or acquittal.
Hearing of the appeal.
Yes, sir. Yes.
An order of conviction or acquittal cannot be set aside merely because a joint or separate trial was possible. Interference is justified only in the miscarriage of justice.
Reputation.
There is actually nothing new said.
Nothing.
Naseeb and Lalu put together this has.
Naseeb is followed in subsequent judgment of Manikanta. Naseeb is followed in Manikanta.
ಅದ್ಯಾವುದು?
ಅದು latest.
ಇದಾದ್ಮೇಲೆ
2024.
No, I've seen both of them, but there's nothing new.
ಇದರಲ್ಲಿ ನಸೀಬ್ ಅಲ್ಲಿ it is a full bench judgment.
Yes, ನಸೀಬ್.
ನಾನು ಅದರ ಮೇಲೆ
ಎಲ್ಲಿ ವ್ಯತ್ಯಾಸ ಆಗುತ್ತೆ ಅಂದ್ರೆ ಸಾಹೇಬ್ರು ವಾಯ್ಸ್ ಮಾಡ್ಯುಲೇಷನ್ ವ್ಯತ್ಯಾಸ ಆದಾಗ ಜಡ್ಜ್ಮೆಂಟ್ ವ್ಯತ್ಯಾಸ ತರ ಕಾಣುತ್ತೆ ನಮ್ಗೆ.
ಇಲ್ಲ ಅದೇ ಅಂತ.
Manikanta paragraph 14 to 24 minute and Naseeb following Naseeb Melad Manikanta.
ಬೆಳಗ್ಗೆ ಎರಡು ಓದ್ದೆ. Opposing senior without not getting updated with all the judgment is not possible.
ಜೀವನದಲ್ಲಿ ಏರಿಳಿತಗಳಿರಬೇಕು.
ಹೌದು, ಏರಿಳಿತ ಇರಲೇಬೇಕು. Not even in our heart thing it shows.
My learned friend has said Melad
voice in the hiಡಿದು ಲೈಫ್ ವರೆಗೂ ಏರಿಳಿತ ಇರಲಿಲ್ಲ.
ಇದರಲ್ಲಿ Melad in the case of Maideen, may I just request you
paragraph sir?
Melad paragraph 40 Manikanta ಅಲ್ಲ.
ಮಣಿಕಂಠನ್ ಇದೆ.
ಮಣಿಕಂಠ ಇದೆಯಲ್ಲ.
paragraph
14 to 24. Following
Naseeb
Singh Melad, and they would refer to Best Bakery case also.
Best Bakery now.
Same thing, Melad. What has been said in
Best Bakery joint trial was permitted.
Yes, joint trial. Remand.
Specific circumstance.
Zaira
Habibul. That is Best Bakery.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಮೈದೀನ್ ನಲ್ಲಿ this is what the Supreme Court has said. Paragraph 46 Melad.
ಮೈದೀನ್ ಯಾವುದು?
ಮೈದೀನ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅದು.
ಧಾರವಾಡದ ಮೈದೀನ.
Well, this is in 2022, volume 14, Supreme Court case 392.
ಇಲ್ಲಿ ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಬಿಡಿ.
ಹೌದು, ಅಲ್ಲಲ್ಲ ಒಂದ್ ಕೇಸ್ ಇಟ್ಕೊಂಡು ಇನ್ನೊಂದು ಕೇಸ್ ರಿಮೂವ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ. That would be an answer to my learned friend submission. Kindly go to paragraph 46.
Yes, already marked.
Yes, Madam. There is one more angle to be considered, that is whether to remand one case to the High Court for first decision, that is the case in which the evidence was not considered, and we may proceed to decide the other case here. We find If we adopt such a procedure, then no fruitful purpose would be served. And in fact, it would be an exercise resulting in complications and contradictions and even conflicts. If we proceed to hear one appeal wherein the evidence has been considered by the High Court and we agree with the same, then it would influence the High Court in deciding the other matter on remand. Further, even if you could hold back this appeal and avoid the decision of the High Court in the matter, which we remand, then also the High Court would not be able to take an independent decision or be influenced by the judgment as would be entertaining one appeal. Moreover, if we allow one appeal, which we are holding back, then nothing may remain for the High Court to decide. It is not fine. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ 3 more cases are pending.
ಅದೇ ಗೊತ್ತದೆ.
ಹೌದು. ಈಗ supposing my lord your lordship were to hear and dispose of this appeal in the merits of the matter, what happens then? Is it not going to influence the mind of the court in 3 other cases in which we are taking our trial?
No, this
in relation to the same FIR. It is not a different FIR. It's only one FIR.
Yes.
And ಜೊತೆಗೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಏನ್ ಹೇಳ್ತಾ ಅಂತಂದ್ರೆ ಇಟ್ ಇಸ್ ಓನ್ಲಿ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ 5 lakh tons. ಇಲ್ಲಿ ಏನಾಗಿದೆ 5 lakh tons ಆಗೋಗಿದೆ, ಅಲ್ಲಿ 3 lakh tons ಎಲ್ಲಿಂದ ಬಂತ ಹಾಗಾದ್ರೆ?
ಅಲ್ಲ, ಅದು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆಯ್ತು.
ಅಲ್ಲ, ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಪ್ರಿಜುಡಿಸ್ ಆಗುತ್ತೆ ಅಂತ. That is what the Supreme Court has said.
That's why I said, even when Prasanna Kumar sir said, it is laced with prejudice and failure of justice.
ಅಲ್ವೇ obviously.
ಇದು ಇದಕ್ಕೆ ಅಪೀಲ್ಗೆ 482 ಆದ್ರೆ ಮಿಸ್ಕ್ಯಾರೇಜ್ ಆಫ್ ಜಸ್ಟಿಸ್.
ಇದರಲ್ಲಿ ಈ ನಸೀಬ್ ಸಿಂಗ್ ಕೇಸ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಆಫ್ಟರ್ ರೆಕಾರ್ಡಿಂಗ್ ಆಫ್ ಎಂಟೈರ್ ಎವಿಡೆನ್ಸ್, paragraph 29, it was at the stage of
ಅಲ್ಲ ಟ್ರಯಲ್ ಆಗೋಗಿತ್ತು.
Yes, recording of evidence was completed. 313 statement was recorded.
It was remitted back.
Yes, it was remitted back.
ಟ್ರಯಲ್ ಮಾಡಕ್ಕೆ ಅಂತಾನೆ ಕಳಿಸಿದ್ದು. ಅದು ಅದಕ್ಕೆ ಹೇಳಿದ್ದು, ಅದೆಲ್ಲ ಥಿಯರಿ ಹೇಳಿದ್ದಾರೆ. ಬಟ್ ಅಲ್ಟಿಮೇಟ್ಲಿ ಮಾಡಿದ್ದು ಇಂಡಿಸ್ಪೆನ್ಸಿಬಲ್.
ನಸೀಬ್ ಸಿಂಗ್ ಫುಲ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ 4+2 quorum.
ನಸೀಬ್ ಸಿಂಗ್ ಪ್ರಕಾರ ನಸೀಬ್ ಬೇರೆ ತರ ಇದೆ.
In fact, what the Bombay High Court would say following the judgment of the Supreme Court, ಅವಾಗ Supreme Court ಹೌದು, ನೀವು ಬೇಕಾದಷ್ಟು ಒಂದು FIR ಮಾಡಬೇಕಾದ್ರೆ you can't file separate charge sheet, you have got to file only one charge sheet and supplementary charge sheets ಅಂತ. ಇಲ್ಲಿ
that you have failed because that is what projected before this is Nagaratna, sorry, Ratnakala.
Even in the chart which my friend Mr. Nagan Naik has given, ಇದರಲ್ಲಿ ಏನು ಕಾಮನ್ ಅಂತ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ. ವಿಟ್ನೆಸ್ PW 1 1 2 2 3 ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಆನ್ ಫ್ಯಾಕ್ಟ್ಸ್ not they should say something. Witnesses may be same, but what they speak not in different cases.
Our High Court judgment, my lord, was earlier and the Supreme Court judgment is later. This is in 2023.
ಅಲ್ಲ, ಅದು ಗೊತ್ತಾ ಹೇಳಿ.
ಆಮೇಲೆ ಬಾಂಬೆ ಹೈಕೋರ್ಟ್ 2025. ಈಗ ಇಷ್ಟೇ. Kindly imagine the situation, my lord. In this Bombay High Court judgment, my lord, good number of cases were registered in different parts of the country. Even Satinder Singh Basin case nallume,
yes,
118 cases were registered. Adake the Supreme Court has said, no, if there is only one in relation to one FIR or different FIRs, you can't file different charge sheet at different places. All have got to be treated as supplementary charge sheet in one FIR.
They merge everything.
Yes, it gets merged.
Merge everything, treat the other charge sheet as supplementary charge sheet and continue the trial.
But in this case, what Apex Court order is, CBI is permitted to register FIR or FIRs ಅಂತ.
CBI can file FIR or FIRs. ನೀವೇನ್ ಮಾಡಿದ್ರಿ?
Not we have filed FIRs, but not wherever.
FIRs ಅಲ್ಲ, FIR.
Not wherever.
ನೀವು FIR ಫೈಲ್ ಮಾಡಿ ಚಾರ್ಜ್ ಶೀಟ್ಸ್ ಹಾಕಕ್ಕಾಗಲ್ಲ.
Wherever, no, it can also.
ನಮ್ಮದು ಒಂದೇ FIR ಗೆ ಮೊಹಮ್ಮದ್ ಚಾರ್ಜ್ ಶೀಟ್.
Not this is of course not a 482 petition. They can simply argue whatever they want. This is an appeal. Which how appeal will have to be considered? No, I need not say because they are all not seniors to me.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಅಬ್ಯೂಸ್ ಆಫ್ ದಿ ಪ್ರೊಸೆಸ್ ಆಗಲ್ಲ, ಇದು ಆಗೋಗಿದೆ.
In fact, in one of the judgment, your lordship has ruled this is a doctrine of sameness.
ಇದು
yes, ಬೈರೇಗೌಡನ ಕೇಸ್ ನಲ್ಲಿ it has got to be treated as a supplementary charge sheet ಅಷ್ಟೇ ಬೇರೆ charge sheet
2022 ಅಲ್ಲೇ ಬರುತ್ತೆ.
ಹೌದೌದು
21
ಹೌದೌದು 20th of September 21
ಅವಾಗ ಫಸ್ಟ್ ಟೈಮ್ 482 ಕೂತಿತ್ತು.
ಅದು ಅಪೀಲ್ ಅಲ್ಲಿ ಹೇಳಕ್ ಬರಲ್ಲ ಅಷ್ಟೇ, ಎಲ್ಲ ಪೊಸಿಷನ್ ಆಫ್ ಕರೆಕ್ಟ್ ಇದೆ, ನಾಟ್ ಇನ್ ಅಪೀಲ್.
In fact, your lordship has referred to TT Antony, Amit Shah, all that, and said doctrine of oneness.
And I have said supplementary charge sheet and
And
treat
Joseph, unfortunately, my lord, visualize the situation. They have been treated as separate charge sheets, fine. Each one of the cases, my lord, I am convicted and sentenced to undergo 7 years imprisonment. Concurrent finding, sentence ಅಲ್ಲ, independent ಆಗಿ ಮಾಡ್ಬೇಕು. ಅದು 42 ವರ್ಷ ನಾನು ಜೈಲಲ್ಲಿ ಇರಬೇಕು ಅಂತ.
ಅಲ್ಲ, ಅದು ಸೆಂಟೆನ್ಸಿಂಗ್ ಬಿಡಿ.
ಅಲ್ಲ, ನಾನು ಹೇಳಿದ್ದು ವಿಚಾರ. ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ, held to be guilty, no sentence at all. ಇದೇ ಕೇಸಲ್ಲಿ.
Sentencing is bad.
ಅಲ್ಲ, ನಾನು ಯಾಕೆ ಹೇಳಿದೆ ಅಂತಂದ್ರೆ, throughout.
Not only this, there is one more case. ಅದು ಅದಲ್ಲ. He is already convicted for an offense in the jail. ಜೈಲಲ್ಲಿ they get into a brawl. ಒಬ್ರು ಒಂದು ಹೊಡಿತಾರೆ, ಅದೊಂದು FIR. ಪಕ್ಕದ ಸೆಲ್ಗೆ ಹೋಗಿ ಇನ್ನೊಬ್ರಿಗೆ ಹೊಡಿತಾರೆ, ಅದೊಂದು FIR. ಇನ್ನೊಬ್ರಿಗೆ ಹೊಡಿತಾರೆ, ಇನ್ನೊಂದು FIR. 8 FIR for 8 incidents on the same day, beating 8 people. So that is, ಅದರಲ್ಲೇ I have written supplementary treat ಮಾಡಿ, this cannot be done at all.
Imagine this situation.
There's a more relevant situation.
But imagine this situation. A case of murder. Half a dozen persons are injured. Half a dozen persons are injured over there along with the deceased. Would there be 6+1 charge sheets?
That is what your FIR/S ಕೊಟ್ರು ಅಂದ್ಬಿಟ್ಟು charge sheet/S ಮಾಡ್ಬಿಟ್ರೆ.
ನಮ್ದಕ್ಕಲ್ಲ ಅದು. ನಮ್ದು it is only in relation to the FOC 17 ಮಾತ್ರ ಅಷ್ಟೇ.
ಅಲ್ಲ, ಅದು
ಅದಕ್ಕೆ ಮಾತ್ರ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ has said further investigation. That's all.
Will consider. ಬರೀ application ಮಾತ್ರ.
ಇನ್ನೂ ಒಂದು ಏನಾಗಿದೆ ಅಂದ್ರೆ, why it warrants remand is for this reason, my lord. Earlier the investigation was taken up initially by the local police. Thereafter, my lord, the local police would transfer the investigation to CID.
CBI, it was given to me by the Supreme Court.
ಅಲ್ಲ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಮೇಲೆ ಕೊಟ್ಟು.
ಹೇಳ್ತೀನಿ ಅದನ್ನ ಆದ್ಮೇಲೆ CID ಆದ್ಮೇಲೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ CID
ಆದ್ಮೇಲೆ CID
then my lord, that Samaj Parivartana would take up the issue before the Supreme Court and all that.
3 categories ಮಾಡಿ Supreme Court.
CEC was formed and CEC would submit a report indicating that further investigation is needed at the hands of CBI, a special investigating agency. Well, what the Supreme Court does is, the investigation and the result of investigation that has been done as on the date of the Supreme Court passing the order shall be kept in abeyance.
Oh.
What happened to that? Where is that record?
ಇಲ್ಲ, kept in abeyance. Supreme Court said independently you proceed ಅಂತ ಇವರು.
ಅಲ್ಲ, no, Supreme Court does not say whatever you have done stands vanished.
ಅದು that is whitewashed ಅಂತ ಹೇಳಿಲ್ಲ.
ಇಲ್ಲ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ ಅಂತ.
Transfer ಮಾಡಿ ಅಂತ.
Yes, my lord. Supreme Court has issued a direction to the CID to transfer the entire investigation which you have done. Well, at para 26.
Accusal coordination ಇಲ್ಲ. ಮತ್ತೆ ಕಾನ್ಸ್ಪಿರಸಿ ಹೆಂಗಾಗತ್ತೆ?
Ink page 26. This is out of the Supreme Court.
Well, accused are not talking to each other here. Conspiracy ಹೆಂಗಾಗತ್ತೆ? I think that will help you further. In case I'm not yet made a whatever.
Against a dead man.
ಅಲ್ಲ, ಅವ್ರ ಕಂಪನಿ ಬೇರೆಯವರು ಇದಾರಲ್ಲ, ಬೇರೆ ಅಕ್ಯೂಸ್ ಅವ್ರಿಗೆ. he is not arguing for the dead man. ಯಾರನ್ನ?
They all will have to be heard.
ಅವ್ರು ಡೆಡ್ ಮ್ಯಾನ್ ಹೇಳ್ತಿದ್ದಾರೆ, ನೀವೇನ್ ತೋರಿಸ್ತೀರಾ?
He is arguing for a dead man. He is arguing for a dead man.
ಅಲ್ಲಿ ಡೆಡ್ ಮ್ಯಾನ್ ವಾಕಿಂಗ್ ಆಗ್ಬಿಡದ
ಪಿಕ್ಚರ್ ಅಲ್ಲಿ.
ಅದಕ್ಕೆ
ಒಂದು ನಿಮಿಷ. Ask him to keep quiet for a minute. Let me complete.
That I'm aware.
1 minute.
Yes.
Internal page, ink page 21, my lord, out of the Supreme Court. Your lordship wanted to know whether records have been transferred by the CID to the CBI.
Yes.
What happened to those records then? Well, order dated 7/9/2012.
Keeping it in abeyance ಗೊತ್ತಿತ್ತು ನನಗೆ. ಆಮೇಲೆ
ಅದೆಲ್ಲ ಇದೆ. Order, no, transfer the records to CBI ಅಂತ. Page 26, my lord.
Records must have been transferred to the CBI.
ಇಲ್ವಲ್ಲ? No, not brought on record at all. ಎಲ್ಲಿದೆ ಅದು? ಏನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ, ಏನ್ ಎವಿಡೆನ್ಸ್ ಇದೆ ಅಲ್ಲಿ? ಅಲ್ಲಿ ನಮ್ಮ ಹೆಸರುಗಳೇ ಇಲ್ಲ. ತೋರಿಸ್ತೀನಿ ಬೇಕಾದ್ರೆ ನಾನು ಸಮನ್ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗೋದು. Kindly go to page 26.
I am there.
Internal, para 2.
Pursuant
to the institution of the FIRs by the CBI as directed above, further proceedings in case number 189 of 2010 investigated by CID Karnataka shall remain stayed. The CID Karnataka shall hand over all the records in regard to that case to the CBI.
ಅಲ್ಲ ಅವ್ರು ತಗೊಂಡಿದ್ದಾರೆ, ತಗೊಂಡ್ಬಿಟ್ಟು ಮಾಡಿದಾರ.
ಅಲ್ಲ ಅದು 207
ಕೋರ್ಟ್ ಹಾಕ್ಬೇಕಲ್ಲ ಅದನ್ನ.
They have mixed up ಅದು ಇದು ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ ಮಿಕ್ಸಪ್ ಇಲ್ವೇ, ಏನೂ ಇಲ್ಲ.
Naseeb Singh, in fact, appeals were remanded back from the Supreme Court. The High Court to be heard on merits.
Sorry, Naseeb Singh ಅಲ್ಲ, ಇನ್ನೊಂದ್ರಲ್ಲಿ next 20 Justice Satish Chandra Sharma ಅವ್ರ statement ಇದೆ ನೋಡಿ. Adil go to para 44. Though it is said para 40 to 43, it should be at the outside. Then ella prejudice prove madu. Ultimately, it is sent back saying it is indispensable in this case for a retrial.
For which one evidence will have to, otherwise not their contention that everything is same.
That is exactly what I left. Evidence at the periphery or evidence in depth. Evidence in depth will be considering the appeal itself. That we'll see.
Please.
ಇನ್ನೇನಿದೆ?
ಇನ್ನೊಂದು ಪಾಯಿಂಟ್ ಏನು ಅಂತಂದ್ರೆ ಇದರಲ್ಲಿ ಅದನ್ನೇ ಕೂಡ ಹೇಳಬೇಕು. ಅಲ್ಲಲ್ಲ ಒಂದು ನಿಮಿಷ ಮಿಸ್ಟರ್ ನಾಯಕ್. My learned friend has referred to an order which came to be passed by a coordinate bench of the small court.
ರತ್ನಕಲಾ ಅವರದ.
ಹೌದು. May I just request you lordship to kindly turn to paragraph 2 at internal page 6 of the order. That is issue a writ of mandamus or an order or direction in the nature of mandamus directing the respondent to treat the charge sheets 11, 15, 54, 53 and 37 and 38 at annexure F, HKM, OQ respectively as supplementary charge sheet in special CC number 105/2013.
This is crime number.
But this is in relation to the what they have registered as 16A. Ido 11, 15 and 54, that is in 17A. That is in relation to theft of 5 lakh metric tons of iron ore. ಅದೇ ಬೇರೆ ಇದೆ ಬೇರೆ.
That explains.
ನಾನು ಮಾಡಿದ್ದಲ್ಲ, ನೀವು ಮಾಡಿರೋ prayer.
ಹೌದು ಸರ್. No,
I have not made it.
No. What I am saying is
that explanation you will find in para 4.
Yes. What I am saying is the prayer I have already sought for, that came to be heard and disposed of with a finding contrary to what you have sought for. ಅದನ್ನ ಆ ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ. ಮತ್ತೆ again, how can you re-agitate the issue was the submission which came to be made by Valaran friend. That was totally different. The prayer sought for was for treating the charge sheets that are filed as supplementary charge sheets to that case. Yes, that is still pending.
Well, I think
17A is decided.
These appeals relate to, I think, not special CC 11, 15, 54 and 53. No, they're all not noted here. Special CC number.
ಇದರಲ್ಲಿ
ಅಲ್ಲ ಅದು ಪೆಂಡಿಂಗ್ ಇದೆ ಇನ್ನು.
ಪೆಂಡಿಂಗ್ ಇದೆ. But imagine the situation, my lord, in those 3 cases, if the court were to hold on the basis of the evidence that would be made available to the court, there was no excavation at all, no transportation at all, no rising at all. ಅವಾಗ ಏನಾಗಬೇಕು? ಅಲ್ಲ ಅವಾಗ ಏನಾಗಬೇಕು ಈ ಕನ್ವಿಕ್ಷನ್?
ಅದಕ್ಕೆ he is saying ಆ ತೀರ್ಮಾನ ಮಾಡೋವರೆಗೂ ಇಲ್ಲಿ ತೀರ್ಮಾನ ಮಾಡಬೇಡಿ ಅಂತ.
ನಾನು ಹೇಳಿದ್ದಲ್ಲ, ಹೇಳಿದ್ದು ತಮಗೆ ತೋರಿಸ್ತಾ ಇದ್ದೀನಿ.
ಆಯ್ತಾಯ್ತು, ಈಗ ಅದನ್ನೇ ಹೇಳಿದ್ದೀಗ. Yeah, what should happen, madam?
Whether you could have taken this objection at the initial stage. 11 ವರ್ಷ ಆದ್ಮೇಲೆ ಬಂದು ಇಲ್ಲ ಇಲ್ಲ ನನಗೇನು ಗೊತ್ತಿಲ್ಲ ಅದಾಗ್ಬೇಕಾಗಿತ್ತು.
That I'll have to answer. Possible I'll want.
Please.
Yes. On these ನಿಮ್ದೇನಿದೆಯಾ ಹೇಳಿ. ಇಲ್ಲ ಇದೆ ಹೇಳಿ ಸರ್. ಪಿಂಕ್ ಬುಕ್ಲೆಟ್ ಯಾವುದು ಪಿಂಕ್ ಬುಕ್ಲೆಟ್ ಕೊಡಿ ಮೇಡಮ್.
ಏನಿದು ನಾಯ್ಕ್ರೆ? ನಾಯ್ಕ್ರೆ, you want to refer to this? ಇದೇನ ಕೊಟ್ರಲ್ಲ ಏನಿದು? ಅದು ಇದು ಹಿಂದೆ ತಮಿಳ್ ಒಂದು ರೋಬೋ ಮೂವಿ ಬಂದಿದೆ ಸ್ವಾಮಿ. ಅವ್ರು ಸುಮ್ನೆ ಹಿಂಗೆ ಬ್ರರ್ ಅಂತ ನೋಡ್ತಾನೆ ಆಗತ್ತೆ. ಆತರ ಏನೋ ನೋಡಿ ಮಾಡ್ಬೇಕು ಅಂತಿದ್ರೆ ಸುನಿಲ್ ಅವ್ರ ದಪ್ಪ ಕೊಟ್ಟಿದ್ದಾರೆ.
ನಾನು ಪ್ರತಿಯೊಂದು ಕೇಸಲ್ಲೂ ಕೊಟ್ಟಿದ್ದೀನಿ. ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ ಹೇಗಾಗಿದೆ ಅಂತ ಅನ್ಬಿಟ್ಟು ನಾನು ಸ್ಪೈರಲ್ ಬೈಡ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಯಾವ್ಯಾವ ವಿಟ್ನೆಸ್ ಅಂದ್ರೆ ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ ಆಗಿದೆ, ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಿ ಐಒ ಇನ್ ಆಲ್ ದಿ ಕೇಸಸ್.
And the quantity plus the ಯಾವ ಶಿಫ್ಟಲ್ಲಿ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಆಗಿದೆ in all 9 cases. First 1 to 6 5 7 8 and 9
ಪೆಂಡಿಂಗ್ ಇದೆ.
ಈ 9th ಕೇಸಲ್ಲಿ ಏನಾಗಿದೆ? ಎರಡು ಅಡಿಷನಲ್
ಎಸ್
ಇದರಲ್ಲಿ A1 ಗ್ರೀವೆನ್ಸ್ ಮೇಲಿಂಗ್ A1 4 captains submit 5 Narendra to look at Narendra is the booking is the company that block that. And this Chandrakant Naik is the person who conducted this. Now the allegation in that case is that they have colluded with these people and seized only 24 leaves instead of seizing the entire system. Now, the charge sheet is not based on the official statement they have stated. Charge sheet they have filed based on the export. But I point out they are not even based on export. There is no logic. Kindly have a look at the first case.
ನೀವು ಕಾಪಿ ಪೇಸ್ಟ್ ಹೇಳ್ತೀನಿ ಅಂದ್ರಿ. ಮೆರಿಟ್ ಮೇಲ
ಅವರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನು ಅಂತಂದ್ರೆ ಟ್ಯಾಕ್ಸ್
now we are only in this on this application. ಈಗ ನೀವು ಆ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ you said what is the prejudice caused ಅಂದ್ರೆ ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ
ಈ ಫ್ಯಾಕ್ಟ್ಸ್ ಇಟ್ ಇಸ್ ಪಾರ್ಟ್ ಆಫ್ ದಿ ಸೇಮ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡುವಾಗ ನೋಡಿ ರಾಷ್ಟ್ರ ಕೈಗೆ
498
accused ಕೇಳುತ್ತೆ ಕೋರ್ಟ್ ಫ್ರೇಮ್ ಮಾಡು when it is part of the same last time what I accused it is part of the same transaction.
I am entitled to for a trial of including all facts in one trial. That was my first argument because when I argued in the Dharwad. But I will point out from these facts. Idರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ these charge sheets are filed 9 different charge sheets not based on export, not even based on stevedores, not even based on quantity. What they have done, those who have approached the High Court for release of the material, they selected those 9 and filed the charge sheet. There is no basis for it. It is not based on the identification of seized material. Even now, even today, before the court, there is no material to show that which is the material seized by them. Because the people who have seized the material before the court has accused, nobody has identified the heaps, nobody has identified the quantity. In all the entire 9 charge sheet, the allegation is you colluded with other accused. Because they rely upon one memo saying that this is the entrustment made to you. Then if the same memo is used in 9 cases as a part of the conspiracy, Lord, is it not a case for a single trial?
No, the same memo is used for 420, is used for 379, is used for 409.
Everything, same memo they have used and same seizure.
Same two different accused.
Not, it is not like that. But if
ಅಲ್ಲ ನಾನು ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಬಿಡ್ತೀನಿ.
if somebody is not the
ಅಲ್ಲ ಹೇಳ್ಬಿಡ್ತೀನಿ ಇದರಲ್ಲಿ ಒಂದು ನಿಮಿಷ ಪ್ರಸನ್ನ I'll ಮುಗಿಸ್ಬಿಡ್ತೀನಿ. ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ ಈಗ ಫಸ್ಟ್ ಕೇಸ್ ನಾವು ತಗೊಳ್ಳೋಣ 53 ಸ್ಪೆಷಲ್ ಸಿಸಿ 53 ಇದರಲ್ಲಿ ಮಹೇಶ್ ಬಿಳಿಯಾ ಇಸ್ ಪೋರ್ಟ್ ಆಫೀಸರ್, ಲಕ್ಷ್ಮೀ ವೆಂಕಟೇಶ್ವರ ಮಿಂದಲ್ ಫರ್ಮ್
ಆಫೀಸರ್
ಪೋರ್ಟ್ ಆಫೀಸರ್. ಆಮೇಲೆ ಅಕ್ಯೂಸ್ ನಂಬರ್ 3 ಮಹೇಶ್ ಕುಮಾರ್, he is not an exporter who sold the material to ಮಲ್ಲಿಕಾರ್ಜುನ್ ಶಿಪ್ಪಿಂಗ್. ಅಲ್ಲಿಗೆ ಫಸ್ಟ್ ಕೇಸ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಪೋರ್ಟರ್ ಯಾರು ಇಲ್ಲ. ಫಸ್ಟ್ ಕೇಸ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಪೋರ್ಟರ್ ಯಾರು ಇಲ್ಲ. ಸೆಕೆಂಡ್ ಕೇಸ್ ಅಲ್ಲಿ ಆಶಾಪುರ ಇಸ್ ನಾಟ್ ದಿ ಎಕ್ಸ್ಪೋರ್ಟರ್. ಸೆಕೆಂಡ್ ಕೇಸ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಪೋರ್ಟರ್ ಇಲ್ಲ. ಥರ್ಡ್ ಕೇಸ್ ಅಲ್ಲಿ ಈ ಕೇಸಲ್ಲಿ ಎಕ್ಸ್ಪೋರ್ಟರ್ ಬಂದು ಸತೀಶ್ ಸಾಯಿ. ಸೆಕೆಂಡ್ ಕೇಸಲ್ಲಿ ಸತೀಶ್ ಸಾಯಿ, ಥರ್ಡ್ ಕೇಸಲ್ಲಿ ಸತೀಶ್. ಫೋರ್ತ್ ಕೇಸಲ್ಲಿ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಶಿಪ್ಪಿಂಗ್ ಇಸ್ ದ ಅಗೇನ್ ಎಕ್ಸ್ಪೋರ್ಟರ್. ಫಿಫ್ತ್ ಕೇಸಲ್ಲಿ ಇಲ್ಲ, ಮಲ್ಲಿಕಾರ್ಜುನ್ ಶಿಪ್ಪಿಂಗ್ ಇಸ್ ದ ಎಕ್ಸ್ಪೋರ್ಟರ್. ಸಿಕ್ಸ್ತ್ ಕೇಸಲ್ಲಿ ಸ್ವಸ್ತಿಕ್ ಈಸ್ ದ ಎಕ್ಸ್ಪೋರ್ಟರ್. ಅಲ್ಲಿ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಶಿಪ್ಪಿಂಗ್ ಇಸ್ ಓನ್ಲಿ ಸ್ಟೀವ್ಡೋ. ದೆನ್ ಸೆವೆಂತ್ ಕೇಸಲ್ಲಿ ILC is the exporter. ಈ ಎಂಟೈರ್ ಬ್ಯಾಚ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಪೋರ್ಟರ್ ಬೇಸಿಸ್ ಮೇಲೆ ಮಾಡೋದಿದ್ರೆ they could have prosecuted, they could have made 3 cases based on ILC, based on Mallikarjun Shipping and Swastik Steel. Suppose if they were registering the case based on the stevedores, then they should have prosecuted Mallikarjun Shipping, Adani, Salgaonkar and Rajmal Singh. This is not based on exporter, not based on stevedore, not even based on Caesar. If Caesar ಅಲ್ಲಿ ಮಾಡಿರೋದ್ರಿಂದ
ಕನ್ವಿಕ್ಷನ್ ಅಂತ ನೀವು ಹೇಳ್ತಿರೋದು
ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟೇನೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಇರ್ಲಿ,
ಅವ್ರ ಸ್ಪ್ಲಿಟ್
ಅದಾದ್ಮೇಲೆ ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ ಚಾರ್ಜ್ ಇದು ಕನ್ವಿಕ್ಷನ್ ಇಸ್ ನಾಟ್ ಬೇಸ್ಡ್ ಆನ್ ಎವಿಡೆನ್ಸ್.
Therefore, my submission, these facts are not interconnected. Therefore, the separate trial and another 3 cases I am yet to face. That is the prejudice. Now, in view of this finding, but I cannot defend that. I will have to suffer conviction in the other 3 cases.
Or he is confident of acquittal.
Or ilve or client illa.
This court will allow the appeals and it will result in acquittal. Therefore, I am saying, Lord, I am confident there. Because
he is taking charge because acquittal adru conviction adru his client is not there to face.
So it is not like that.
34 is a company.
It is not like that.
Therefore, my submission is that it is interconnected fact.
After looking into the submissions.
On this, Prasanna sir, on this will finish.
Kindly bear with me.
Oh, I have to bear with, yes.
May I request Lord to kindly take up exhibit P116, Lord, 3430, just to point out.
ಯಾವ್ದ್ರಲ್ಲಿ ಯಾವ್ದು petition?
In criminal appeal number.
ಅವ್ರದ್ದು ಯಾವ್ದು ತಗೊಳ್ಳಿ ಮೇಡಮ್.
2084. Where is that? Special CC 37. 2084.
2084.
Paper book.
ಒಂದು ಫೈಲ್. ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಯಾವುದು? ಇಲ್ಲಿದೆ ಮೇಡಮ್, ಅಲ್ಲೇ ಇದೆಯಾ? ಟೂ 2084 ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಯಾವ್ದು? ಸೀರಿಯಲ್ ನಂಬರ್ ಅಲ್ಲ, ನಿಮ್ 2084 ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳಿ.
Yes, sir. This document is marked to indicate the total number of cash sheets. I did write 189. There are 39 cash was indicated in page 3422, 3433. What happened is not pursuant to the direction of the honorable Supreme Court. All these statutes were handed over to CBI.
ಅದು ಹಿಸ್ಟ್ರಿ ಎಲ್ಲ ಗೊತ್ತು ಬಿಡಿ.
Subsequently, not detached, they brought to only 9 statutes. What the honorable Supreme Court said was, if each one has fails, under further investigation, further investigation.
By registering separate FIR. Yes.
Comprehensive investigation comprising excavation, transportation, and all the Supreme Court further says, out of the total quantity.
Excavation ಗೆ ಇವ್ರು ಮಾಡಿದ್ರ ಇನ್ವೆಸ್ಟಿಗೇಷನ್? ಇನ್ನೂ ಅಲ್ಲಿದೆ. ಅಲ್ಲ, as you said, ಪ್ರಸನ್ನ ಸರ್, ಎಕ್ಸ್ಕವೇಷನ್ ಆಗಿಲ್ಲ ಈ ಕೇಸಲ್ಲಿ ಅಂತ ಬರ್ದ್ಬಿಟ್ರೆ ಪೆಂಡಿಂಗ್ ಇದೆಲ್ಲ ಹೋಯ್ತು.
ಅಲ್ಲ ಇವರು issue is when they commenced the trial in 2014, did they not know all this? ಈಗ ಪಾಪ ಎಲ್ಲ ಚಾರ್ಟ್ ಎಲ್ಲ ಮಾಡಿ ಅದು ಇದು ಒಟ್ಟಿಗೆ ಅಂತ ಇದ್ದಾರೆ. They could have done this exercise earlier. Now it's an appeal. Appeal will have to be heard based on the evidence available.
First we'll have to see the scope of appeal in sir.
ಆ ತರ ಬರಲ್ಲ, ಎಲ್ಲರೂ ಕಾನೂನು ಒಂದೇ.
ಸುನಿಲ್ ಕುಮಾರ್ ಇರಲಿಲ್ಲ.
And records, not as clearly said that IMC has exported totally 9.86 lakh metric tons.
Those things are pending there still.
Out of that, our business is quantity.
Yes.
So therefore, not the registration of separate FIR as very severe as pointed out, completely without restriction. Now, what they have done is, after collecting the documents collected during investigation by the CID in 39 charge sheets, they do not want to return it back to the court. And once these documents were handed over,
ಅದೇ ಎಲ್ಲಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಲ್ಲಿ. ಸೀನಿಯರ್ ತೋರಿಸಿದ್ರಲ್ಲ ಅದೇ ಆರ್ಡರ್. ಇನ್ನೊಂದಿದೆಯಾ ಕೊಡಿ. ಹಾ, 451, 457 ಅಪ್ಲಿಕೇಶನ್ ಇದು. ಹೌದು.
Seeking for release on the belief that only 9 charges will be filed. Because central court of when they approach this order, state could come and say the state because higher some pending. Then about this order is to pass. Direction to investigating officers. Paragraph onwards. Para 8. During hearing of IA 1,2017 by this court, it was repeatedly directed to the central by order dated selection. Concerned investigating officer neither appeared nor complied with the direction of the court. Said acts/functions of the investigating officer fully under non-cooperation to the investigating officer. Also, details of the direction and interfering in administration of justice. In absence of information, IA 1 and IA 2 of the date were disposed of. Then throughout the special judge will not issue direction to the CBI will find forward in so all the materials have written not created as part of the charge sheet in the 9 cases. Not as had not already made any. And there was another investigation is order. Whatever the report we submitted should be as a supplementary charge sheet. But the weight of these 39 charge sheets, what happened is for 268 as a like CID would file BIR. That was suppressed. Now I am being prosecuted. It is in that context I made an application in pending cases, all 3 cases, to secure all these documents first. I'm sure what was I have seen. The evidence will clearly reveal that now what they are seeking to proceed based on the selective material. This is some discipline law. But in the 6 cases where the commission is recorded this opportunity was made, and in fact not in the 3 pending cases, 34 cases, the prosecution has filed an application seeking for transfer. That was rejected. It was opposed to by everyone.
ಬಟ್ ನೀವು ಹೇಳಿದ್ದೆಲ್ಲ ಈಗ ಪೆಂಡಿಂಗ್ ಇರೋದು. ಹಾ, ಇನ್ಯಾವುದಕ್ಕೆ ಸೀರಿಯಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಅದು ನೋಡು. ವಿಲ್ ಸಿ. We'll decide about. ಎಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ದೀರಾ? ಥೈಲ್ಯಾಂಡ್ಗ? ಥೈಲ್ಯಾಂಡ್ಗೆ ಹೋಗ್ಬೇಕು? ನೋ ನೋ ನೋ, ಪರ್ಮಿಷನ್ ಕೊಡಲ್ಲ. ಸೌತ್ ಥೈಲ್ಯಾಂಡ್ ಅಂದ್ರೆ ಹೂ ಅಂತೀರಾ ಮತ್ತೆ? ಎಸ್. ಅದೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ. SVPನೇ, ಶಾರ್ಟ್ ವ್ಯಾಲಿಡಿಟಿ ಪಾಸ್ಪೋರ್ಟ್. ಅದೇ ಸೇಮ್ Prasanna Kumar, whatever order I pass, as a short validity passport and your travel itinerary ಕೊಡ್ಬೇಕು ಅವ್ರಿಗೆ. ಇದರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಬರಬೇಕು, ಆರ್ಡರ್ ಆನ್ IA. No, we'll see. We'll answer. ಅಲ್ಲ, ಇಲ್ಲಿ ನಿಮ್ಗೆ ಯಾವ ಜಾಯಿಂಟ್ ಟ್ರಯಲ್ ಇಲ್ವೇ ಇಲ್ಲ, ಅಲ್ಲಿರೋದು. Those cases are not before me. ಅಂಡ್ ಈ ಕೇಸಲ್ಲಿ ಜಾಯಿಂಟ್ ಟ್ರಯಲ್ ಆದ್ರೆ ಅಲ್ಲಿ ಜಾಯಿನ್ ಆಗುತ್ತೆ ಎಲ್ಲ.
That's what apex court also has said.
ಅಲ್ಲಿ ಅಕ್ಯೂಸ್ಡೇ ಇಲ್ಲ.
ಅವ್ರ ಆತ್ಮ ಬರ್ಬೇಕು.
ಅಲ್ಲ, ನೀವು ಅಕ್ಯೂಸ್ಡ್ ಇಲ್ದೇನೆ ಇಷ್ಟು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋರು ಆತ್ಮ. 34 ಮಾತ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್.
ಅಕ್ಯೂಸ್ಡ್ ಇಲ್ಲದೆ ಇದ್ರು ಕಾನೂನು ಪ್ರಕಾರ ಅವರೊಬ್ಬರೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇರೋದು.
ಅಲ್ಲ, ಅಕ್ಯೂಸ್ಡ್ ಇಸ್ ನೋ ಮೋರ್, ಹಿ ಇಸ್ ಡೆಡ್ ಅಂತ ಕಾನೂನು ಪ್ರಕಾರ ಎಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರೆ. ಲೈಟರ್ ವೇಸ್. ಎಸ್ ಎಸ್, ಇದ್ರಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. The petitioner has preferred an application seeking issuance of a full validity passport for a period of 10 years on the score that his passport has expired, and every time he has to take a passport every time he has to take a short validity passport to travel beyond the shores of the nation. The said application, insofar as it seeks passport for a period of 10 years, stands rejected. However, in the light of the settled principle of law, as also the circular issued by the Government of India and Ministry of External Affairs, GSR 570 of 1993, the petitioner becomes entitled only to a short validity passport. It is the law in this regard is settled, Santosh Madam, so and so, in which this court has held as follows. In the light of the said circumstance, the petition, the application stands allowed, albeit in part. The petitioner is held, the respondent passport authorities are directed to issue a short validity passport in terms of GSR 570 of 1993. And when the petitioner is wanting to travel beyond the shores of this nation, the travel itinerary be placed before the concerned court. Yes. CBI ಗೆ ಆಯ್ತು ಸರಿ. ಇವಾಗ ಇದು ಕನ್ವಿಕ್ಟ್ ಆಗ್ತದೆ. ಎಸ್ ಎಸ್. ಬಟ್ ಟು ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಸರ್ ನೀವೆಲ್ಲಿದ್ರಿ? ಅಲ್ಲ ನೀವು ಅದೇ ಸಬ್ಮಿಷನ್ ಜಾಯಿಂಟ್ ಟ್ರಯಲ್ ಹಾ
Lord, in special CC 53, my lord.
Which petition are you
53, your lordship.
Criminal appeal, which
Criminal appeal 1995, my lord.
One moment.
Acha. 24.1 and 24.3, my lord. 24.3, my lord, it is. Lordship. In this, my lord, 24.3 is the partnership firm, my lord. Shri Lakshmi Venkateswara Minerals. 24.1, my lord, is
one moment.
Partner, my lord.
You submit, are you on merits or whatever they have submitted other melena? Merits I have not heard anybody. I am only on the application seeking a remand for the purpose of conduct of joint trial. ಅದು ಹಿಯರ್ ಮಾಡಬೇಕು ಅಂದ್ರೆ ಒಂದು ಸಪರೇಟ್ ಆಗಿ ಹಿಯರ್ ಮಾಡ್ತೀನಿ ಬೇಕಾದ್ರೆ.
Separate you Lakshmi.
ಆಯ್ತು ತೊಂದರೆ ಇಲ್ಲ.
On merits, my lord.
On merits, if you want the appeal to be heard, then we will hear it later.
Yes.
We'll fix it in first.
This may be segregated. They need not face again another trial, my lord. That already evidence is on record.
No problem. Allah, if you are on a different footing on that, yes, we'll hear it. Then January 9th.
Please.
Yes. Interim order ಇದೆಯಲ್ಲ ಅದೇನೇ ಸಸ್ಪೆಂಡ್ ಆಗಿರೋದು ಅಷ್ಟೇ.
Yes, yes.
Conviction appeal interim order. ಬೇಲ್ ಮೇಲೆ ಇದ್ದಾರೆ ಅಷ್ಟೇ.
ಅದು ಗೊತ್ತಾಯ್ತು, ಅದಕ್ಕೆ ಬೇಲ್ ಮೇಲೆ ಇದ್ದಾರೆ.
And there is interim order
ಮಾಡಿದೀವಿ.
Interim order also there, my lord. That may be continued.
Whatever is there will continue. Yes. Prasanna Kumar, we'll hear it later.
Please, please.
Heard the learned senior counsel Shri Hasmat Pasha appearing for the petitioner in so and so. The learned senior counsel submits that he is not, along with the other counsels, in submitting that answering submitting an application seeking conduct of a joint trial and remand in these proceedings. Learned senior counsel submits that he would argue the matter on its merit. Therefore, list the matter on 9th January at 2:30 p.m. Yes. Interim order and the continue. Yaud sir? 24.1 and 3. Yes. Mikidella reserved.
Please.
Dealing. Dealing ಮಾಡಿ ಮಿಕ್ಕಿದೆಲ್ಲ reserved. Only on this application. Nagendra Nayak. Yes.
Please.
List continue. Madam. Madam. List continue.
Pastor 28.
Le Kumar. Is there? Password. Burley. I'll take it when he comes. Leave here. Yes. Next.
41.
400 minutes.
ಇದರಲ್ಲ ಬೆಳಗ್ಗೆ
He was there. 41. Lord's offense is 498 AM lords. Which is state against all the accused lords, including the husband lords.
Including the husband.
Yes, lords. The only lords, grievances lords. That the at least investigation should go on against the husband lords.
It is a French fries case. French fries case.
It is famously known as French fries case.
French fries,
Lords, that's only thing is, Lords. Lords, the accused husband is, Lords, in America. Lords, he has filed 2 petitions before the family court.
Correct, sir. This is the case where the wife complains.
I agree.
In
That's-
India, that she was not.
No,
given-
Lords. But the allegation, Lords, she, when.
ಅಲ್ಲಿ ಶುರು ಆಯ್ತಲ್ಲ
ಹೌದು.
ಅಲ್ಲಿ ನೀವು ನೋಡಿ ಅಲಿಗೇಷನ್
I saw,
ನೋಡಿದ್ರೆ
Lords. It is my.
KFC ಲಿ ಫ್ರೆಂಚ್ ಫ್ರೈಸ್ ಕೊಡಿಸಿಲ್ಲ ಅಂತ ಅಲಿಗೇಷನ್.
I saw, Lords. Lords.
How 498?
Lords, there are so many other allegations also, my Lords.
Yes.
That is only one pair of notes it is referring to, my Lords. Lords, let the investigation should go on at least against the husband.
For French fries? Huh? ಡ್ರಾಮಾ ಸೀರೀಸ್ ನೋಡಕ್ ಬಿಟ್ಟಿಲ್ಲ ಅಂತ ಕರೆಕ್ಟ್ ಅದೊಂದು ಇದೆಲ್ಲ ನೀವು
There are other allegations as well, my Lords.
ವಾಟ್ ಅಲಿಗೇಷನ್ಸ್ ಅದೇ ಎವ್ರಿಥಿಂಗ್ ಇಸ್
Lords, kindly see, Lords.
ನೋ ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಸರೌಂಡೆಡ್ ಅರೌಂಡ್ ದೀಸ್ 2 ಫ್ಯಾಕ್ಟರ್ಸ್. ಪಾಕಿಸ್ತಾನಿ ಡ್ರಾಮಾ ಸೀರೀಸ್ ವಾಸ್ ನಾಟ್ ಅಲೌಡ್, ಫ್ರೆಂಚ್ ಫ್ರೈಸ್ ಕೊಡ್ಲಿಲ್ಲ, ಇದು ನೆಟ್ಫ್ಲಿಕ್ಸ್ ನೋಡ್ಬೇಕಾದ್ರೆ ಪಾಪ್ಕಾರ್ನ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂದಂಗಾಯ್ತು. ಎಸ್ ಅದಕ್ಕೆ 498 323.
I'm not, she has filed 2 petitions before the family court. Plus, one is for divorce and another is for JNWC. But both the matters, not on at their instance, not referred to mediation. That's not even.
ಇವಾಗಲೂ ಸೆಟಲ್ ಮಾಡ್ಕೊಂತೀರಾ ಮಾಡ್ಕೊಳ್ಳಿ.
Lords, I am ready, Lords.
To go back?
I am ready to go back. From day one, I am saying, Lords,
sir,
I am ready to go back.
Ready to go back? Huh?
And I, in fact, contacted my learned friend, Lords, since Lords several times. I'm ready for reconciliation.
Why did you stop Pakistani dramas to be watched? ಅದಕ್ಕೆ ಡ್ರಾಮಾ ನೋಡಬಾರ್ದು ಅಂತ ಹೇಳಿದ್ರ. ಮೈಕ್ ಕೇಳಿಸಲ್ಲ. In your place?
Yes, means America.
America, correct.
Yes. In spite of that, my lord, she has not cooperated.
No, I am sorry, my Lords. Let this statement be on record, my Lords. I will, my Lords, immediately go, my Lords.
As per the statement rendered by the husband before this honorable court, the lordship observed with regard to the passing of the order when this honorable court passed the order initially.
ಏನು
ಅದೇ French fries.
What?
ನನ್ನ ಆರ್ಡರ್ ಇಲ್ಲೇ ಕೊಡಿ.
ತಮ್ಮ ಆರ್ಡರ್
ಇದೇ ಕೇಸಲ್ಲಿ ಪಾಸ್ ಮಾಡಿ.
ಅದೇ ಕೇಸಲ್ಲಿ ಪಾಸ್ ಮಾಡಿ.
ಬಟ್ ಕಂಪ್ಲೇಂಟ್ ನೀವು ನೋಡಿದ್ರೆ ನವೀತ್.
I see, Lords, I saw the complaint.
Lords, these are day-to-day happenings between a husband and wife.
I agree, Lords. I'm not on that.
Skirmishes in a family.
Yes, Lord.
Can it be projected as 498 offenses, you tell me? Now you come to the complaint, page 18 ಬನ್ನಿ.
Lords, page number 19.
Jewelry ಎಲ್ಲ ಆಯ್ತು.
Yes, Lords. Page number 19.
Page number 20, my lord.
Para 8.
Para 10. Page number 20. Para 10.
Allegation ನೋಡಿ, para 7.
Yes, Lords.
ಅದಕ್ಕೆ divorce correct ಆಗಿದೆ. My husband and I left for Texas in 2 months in India, called for other day. I was called out every other day for doing cooking and cleaning. I was told I was not good enough. All right. Cooking, and because my parents are so constantly told by my mother, I was pregnant for first child, delivery due, parents got it, but COVID hit, in the mentally tortured. Went to travel USA, lockdown, quarantine. I had to deliver the next day.
Para 10, my lord.
Doctor thought it was not safe for me to go back. After my delivery, after my delivery, my husband didn't want me to eat French fries.
And rice and meat. Because
and meat because I would put on weight. ನಿಮ್ಮ ಇಂಟ್ರೆಸ್ಟ್ ಅಲ್ಲೇ ಹೇಳಿದ್ದು. ಅದಕ್ಕೆ 498 ಏನಾ?
Let's kindly see next paragraph as well.
ಆಮೇಲೆ after few months my daughter and I had gone out for clothes. ಆಯ್ತು. When I asked husband to get us new stuff, he denied. ಅದು 498 cruelty.
Let's kindly come to paragraph 11, Lords.
What, sir?
Paragraph 11, Lords.
Yes, sir. After she left, ಎಲ್ಲಿ ಒಂದು cruelty ಅನ್ನೋದು ಎಲ್ಲಿದೆ ನೋಡಿ. You did not take me to vacation to Turkey. They went to Turkey. They didn't want me and kids to join.
Lords, kindly see, Lords. They all, Lords, went for a picnic, Lords, leaving their wife.
ಅದು 498
Lords, no, I'm not saying that, Lords. I'm not saying, Lords. Kindly see the treatment he has made to the wife, my Lords.
That is fit for MC case.
That is pending in before the family.
Lords, the MC he himself has filed, my Lords.
No, how will these amount to 498?
Let's torturing the wife, Lords.
Torturing the wife.
Lords, Even silence, not sometimes is a torture, my lords.
Correct. This is correct. Silence.
No, she has left the wife, my lords, alone with the kids. But and she is, my lords, nobody
America.
in America, my lords, nobody was there to take care.
No, I understand the plight, but there are many cases where the wives are driven to the wall and then they
Lords,
complain.
she has got 2 kids, my lords. Lords, it is a case for, my lords, reconciliation.
Reconciliation, yes, if he is agreeable, I have no problem. But he'll be husband, ಬೇರೆಯವ್ರದೆಲ್ಲ ಅಂತೂ ಸಾಧ್ಯವೇ ಇಲ್ಲ. Both of you have problems in US, you've drawn every family member here.
I'm not pursuing on lords 2 to 4 lords. At least
Mother-in-law, father-in-law ಏನ್ ಮಾಡಿದ್ದಾರೆ?
At least against lords, the husband lords, at least the investigation should go on lords.
Paralysis patient,
Her
father-in-law.
husband,
Father-in-law.
Father-in-law.
A 65-year-old, now 70.
Father-in-law, mother-in-law, other-in-law.
I'm not pursuing it.
We'll take
I'm
it
not pursuing it.
ಅಲ್ಲ ಯಾರು brother-in-law ನದು?
Brother-in-law. ಅವ್ರದ್ದು ಏನ್ರಿ ರೋಲೇ ಇಲ್ಲ. ಅವ್ರದ್ದು allegation ಇಲ್ಲ.
Mother-in-law, father-in-law, brother-in-law.
I'll not pursue against on any of them, lords, except husband.
No other-in-law?
No other-in-law.
Husband.
Husband is in America, my lord. It is not.
French fries ಕೊಡಿಸ್ಬೇಕಾಗಿತ್ತು.
Para 11 ಅಲ್ಲಿ also she speaks about physical.
ಅದು ಸುಮ್ಮನೆ ಕೇಳ್ತೆ. ತರ 11 ಅಲ್ಲಿ ಇದೆ. But ಎಲ್ಲ these are all minor skirmishes. It's a little bordering on physical torture ಎಲ್ಲೂ ಇಲ್ಲ ಜಗದೀಶ್ ಸರ್. Physical torture ಎಲ್ಲಿದೆ?
Third line after that.
It is in para 11 it is there, lords.
As soon as they came back from Turkey, my mother was ill and admitted to hospital. My husband was going along with the mother.
Mentally and physically torture.
ಅದು ಹೇಳಿದ್ರ ಏನಂತ ಹೇಳ್ಬೇಕಲ್ಲ. What is the specific overt act at any time? Then you have not treated your wife well, sir.
No, I treated my lord, my wife well, but in spite of my cooperation, my lord, she is not in a position to leave.
ಆಯ್ತು again reconciliation ಆಗತ್ತಾ?
Reconciliation 4 times ಆಗಿದೆ family.
ಇಲ್ಲ, he has never attended
video call ಅಲ್ಲಿ ಆಗಿದೆ.
He has never attended, not even once.
Video call ಅಲ್ಲಿ 3 times ಆಗಿದೆ video call.
He has not attended, not even once he has attended.
When are you coming to India?
I'll check it up on it. Because Trump region, it is very difficult, my lord, to get back.
Trump ನಿಮಗೂ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ.
ಎಲ್ಲರಿಗೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಅಲ್ಲಿ. ಎಲ್ಲ ಆಲ್ ಓವರ್ ವರ್ಲ್ಡ್ ಪ್ರಾಬ್ಲಮ್ ಮಾಡಿಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ ಬಂದ್ರೆ ವಾಪಸ್ ಕೂಡ ಹೋಗಕ್ಕಾಗಲ್ಲ.
It's not possible at all. Unemployed ಆಗ್ಬಿಡ್ತಾರೆ.
Lords, we will go, my lords. We will go, my lords.
ಅವರೇ unemployed ಆದ್ಮೇಲೆ ನೀವು ಹೋಗಿ ಏನ್ ಮಾಡ್ತೀರಿ?
No, lords, he is employed. He is doing good for us. He is doing good at therefore, lords.
If he leaves United States and comes ಹೋಯ್ತು.
ಅಷ್ಟೇ. Very difficult.
And lords, the kids are lords, American citizens, lords. They're born in America.
They're born there.
They're born in America. If you permit me, lords, we'll go, lords.
ಎಲ್ಲಿಗೆ?
Lords, if we
we'll see. Charge sheet ಆಗಿದ್ದೀರಾ?
ಇಲ್ಲ.
FIR stay ಆಗಿದೆ.
FIR stay, not let investigation should go against husband, lords.
We'll see.
Yes.
ಬೇರೆ ಯಾರು ಎಲ್ಲ of course I'll quash. Husband ನೋಡೋಣ. ಇಲ್ಲ ಅಂದ್ರೆ ನೀವು ಸೆಟಲ್ಮೆಂಟ್ ಬರಲ್ಲ ಅದು.
ಹೌದು.
Reserved.
Obliged.
Interim order subsisting will continue to the disposal of the petition.
Obliged, lords.
ಯಾಕೆ ಬರಕ್ಕೇನು ಹೇಳಿಲ್ಲ? We'll see. Yes. ಕುಮಾರ್ ಸರ್ ಇದಾರೆ. ಕುಮಾರ್ ಸರ್.
28.
You have to give report it over. Mine, yours is the birth matter.
Sir, Rashid,
What great things here.
their contention is that the 2013 Companies Act came into force with effect from 1st January 2014. He has resigned as a director of the company in the year 2011-12 itself. Now they want to seek that I have no role in the entire company affairs. He does not want, he can't be prosecuted. The offences which have been alleged are after he resigned from the company as a director. So may I draw attention of my learned friend's petition connected with the LOC matter, where paragraph number 7 onwards, the notices have been issued by the police from in the year 2019 to him. And he is the one who has gone and before all authorities and given statement. What way he was connected? If he was not a director,
Correct. If he had nothing to do.
what was the necessity for him to go and answer for anything? One. Second thing is, my lords, facts decide application of law. Here is a case.
Correct. There is no doubt. Facts decide.
Now, in this factual matrix and fulcrum of the entire case is that a chartered accountant who was a promoter director incorporated the company and subsequently acted as a chartered accountant or statutory and also tax consultant, and is deeply involved. Monies have been transferred to his account from this account. This is what the sequence which requires a matter of trial. Finally, kindly see section 447 definition of fraud under the Companies Act. Let's may I draw the attention what the fraud means.
447 comes in after the amendment or what?
But
447.
2013 Act.
That's what he was director in 2012.
That's what his subsequent involvement in the company and transfer of funds from his account to company account to his account. That is all the matter of trial only, my lords. He cannot deny that I have no complete relationship after the 1/4/2013 or 1/1/2013. If he makes a statement that I had no financial transactions, I had no relationship with the company in any capacity, Lordship, whatever they argued is.
Why did you do all that?
Kindly see, there
You were
was
representing the company throughout.
Lord, when I received the notice, I have gone and responded. Lord, I have not represented the company.
No, my lord. You received individual notice?
Yes.
Individual notice.
Individual.
Sorry, buddy. Kutkodi. Yes.
Individual notice.
All right. Yes, yes.
So kindly see the paragraph 7, 8, 9, 10. These are the admissions of his own in another statement. So the funds have been transferred from this company's account to his account. And kindly see the fraud minutes. Now he has continued till 2018. It is not the case that after he resigned from the directorship of that company, he has not continued in any capacity or in any way or not received any fund from that company. If that was the case, my lords, what he said and the Supreme Court judgment also said that once he resigned,
over.
But it is not the case. Factually, he has been continued in association with the company.
In what capacity?
My lords, as a chartered accountant, as a tax consultant, and in what form and all account, but funds transfers are there to his account. That's the important.
That may be fees from the company.
That is a matter, because that is not a matter which requires, because what is the fee? What is that amount to transfer? That is a fraud amount what we are alleging, because it's a fraud to the tune of few 100,000
You're
crores.
telling fraud is a fee or fee is a fraud?
That's one. Kindly see that 443, because first their submission I would like to cross it, because as far as factual matters is concerned, his association has continued till 2018, not just merely the date on which he resigned from the company as a director. One aspect. Second aspect, I just read the fraud definition of that section 447 of the Companies Act.
Yes, sir.
Which will give little strength to my case.
Yes, yes.
Can you
see
see
case is weak, Antana.
No. Little strength.
Oh, little strength.
Little more strength.
More,
Sorry.
that is
Little more strength.
Yes, yes.
I'm so sorry. Objectives are always qualified prefixal. Without prejudice to any liability, including repayment of any debt under this Act or any other law for the timing in force, any person who is found to be guilty of fraud involving an amount of at least 10 lakhs rupees or 1% of the turnover of the company, whichever is lower, shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may be extended to 10 years, and shall also be liable to fine, which shall not be less than the amount involved in the fraud, but which may extend to 3 times the amount involved in the fraud. Provided that where the fraud in question involves public interest, the term of imprisonment shall not be less than 3 years. I'll skip this thing, then I'll go to fraud. Fraud in relation to affairs of a company or any body corporate includes any act, omission, concealment of any fact or abuse of position committed by any person or any other person with the connivance in any manner with intent to deceive, to gain undue advantage from, or to injure the interest of the company or its shareholders or its creditors or any other person, whether or not there is any wrongful gain or wrongful loss. Wrongful gain means the gain by unlawful means of property to which the person gaining is not legally entitled. Wrongful loss means loss by unlawful means of property to which the person losing is legally entitled. Now, what the complaint we have filed means, after the investigation by the company's inspectors appointed under Section 206 of the Companies Act matters. There, we have asked a number of documents. Nothing has been provided. I have filed the statement of objections. The manner in which they were conducting the entire business of the company, it is not the first time, my lords. They have been coming to India in different avatars, different forms. In the year 2006, they came as Gold Quest Net. So it went to Supreme Avatar, sorry. 2006, matter went up to Supreme Court, committee was appointed and gold, whatever deposit was returned, some issues. Then they incorporated in 2012. By the time that got closed, they came out with new one. And it is a QA group of Malaysia and routed through Hong Kong, one QNet. And they say we are franchisee. And they have got two companies incorporated, Transio and Vanamala Tours and Travels. They are also, shares are held by the Malaysian group, QA group. And amount is being transmitted through those companies. This is what the company for which it has been incorporated. And manner in which they are doing the business. Kindly see the statement of objections, only 2 paragraphs, my lords. Your lordship will, within no time, will know what exactly in the manner in which they are fooling the public and collecting the money. Statement of objections filed day before yesterday.
Day before yesterday?
Yes, ma'am. In the criminal petition. In LOC matter, it was filed very long back.
Idralli.
221. Manars, just complaints are there at page number 2 onwards. What are the nature of complaints received by various investors, how they were made to invest and why they.
QNet, I am aware.
QNet, that's. And the manner, the kind of the modus operandi is also explained by paragraph 5, 6, 7, 8 manners, which will throw the complete light about this involvement. He is a chartered accountant and tax consultant, and he received money till he associated till the 2018. If he makes a statement that I have not received, there are no transactions between the company and myself, certainly he stand as far as
there is transaction. He's not denying it.
No.
He's saying it's fee.
That's what it is a matter of trial, because it is a fraud is allegation. Allegation is fraud, not anything else. If there is other things, certainly you could have been. Since that matter has been met, this is not a case where the power under section 482 requires to be exercised. It's all economic offences matters. It is not like a regular IPC offences where the description of even the complaint as well as allegations are. Here it's a complete web cop. So they create such a nexus, and it's a menace to the society. General, because public are made to invest and they will be losing. In this case, many people have committed suicide. They borrowed money, invested money, they did not pay. This, sir. There are many cases, such cases, incidents are, complaints are there. It's a big bunch is available. Even today, complaints are being let. ED has initiated. The even SEBI's public notice has been issued saying that they are collecting money in this form. See, this is a company which cannot, even in the form of a chartered accountant or anything, should not be permitted to facilitate. If at all he has got anything, he can always prove his innocence before the trial court. At the end of the stage, if it is entertainment, there are other directors who are also forming part of the same group and who are beneficiaries. He says they are the one who are in my touch and who are the one who are instructing me. That is was his statement given to other polices also. So every matter can be decided there. Suppose this is entertained, it will have ramifications in other cases also. Other persons also have filed, accused also filed the criminal petitions saying in the similar fashion, which cannot be entertained. In my respective submission is that the criminal petition requires to be dismissed. There is no prima facie case. He cannot, there is no, this is an undisputed point. He said that he was there till 2018 and amount has been transferred. Whether its amount is the fraud amount or any other thing, that requires
matter of trial.
That's a matter of trial. That requires to be. Judgments which he has referred does not apply to the facts of this case matters, because facts differ.
Facts make the law.
No. That's application of law can be based on the facts of the case. And one judgment, the Delhi High Court matters. It's only to say one observation that paragraph 19. Sorry, I'll place with the memo. It only says that economic offences are detrimental not only to the economy of the nation but also the society at large. The underprivileged and downtrodden are often at the receiving end of the paragraph 19 minutes. Last. After effects of such offences, extraordinary powers of this court are not meant to be exercised at the disposal of someone. And this is an observation of Delhi High Court in one of the economic offences matter minutes.
Anything else, sir?
Not just two submissions. Like I pointed out, I was the one who said in my reply to the show cause notice that I continued as an auditor. Even after that, in the complaint, that is not their case against me. There is no specific averment as against me on any role or anything. And secondly, the submission was, in fact, this had come up earlier also. Your Lordship had asked us whether it will affect anybody else. There is
So
no
you are a
other
chartered accountant.
there is no other similarly situated director at all, former director.
You're a
Former director at all, who resigned even before the operations began. So this will not affect any other taxpayers.
Yes, then.
My lord, mine is that LOC issue.
So LOC is an offshoot of this.
Yes, no, I'll only.
What are you on?
I'm only telling those facts because my learned friend has stated on this chart accountant stating that he has done transactions relating to the company. As a chart accountant, the institute permits that you can collect the money on the client's account and pay their income tax or the TDSs. These things have been done, and apparently there is no allegation in the complaint which has been filed saying that the monies are being transferred. The only allegation what has been made is he was the director for 4 months. Now the LOC has been issued based on the letter issued on 4/4/2019 by the Ministry of Corporate Affairs. That letter, what has been issued, my lord, my learned friend has placed that letter at page 88, my lord, of his rejoinder to my petition.
LOC galva.
LOC ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ LOC RD is directed to issue LOC for the concerned directors only. When the LOC gets issued, the letter is issued by the RD saying that the LOC is issued on all the directors. My lord, there were 2 directors initially who incorporated the company. That is the chartered accountant and one of his junior. The junior's name is there are Shubha Tulasira. They had incorporated only, and they were their directors only for 2 months and 3 months. The moment they got the DIN, they came out of the company. And the allegation is that he was an executive director. He was not an executive director. He was only a director for the limited purpose of commencing the company and providing professional services. That's all.
Yes, had reserved.
Just
Long pending.
One point. In the complaint itself, in the notice also, there is a reference to that economic offense wing and CID having initiated. But in the charge sheet again, I am not.
Synopsis ಹೇಳಿದೆ.
Even I have provided.
Notice allo ಹೇಳ್ತಾರೆ. They rely on that.
Even I have provided.
Hyderabad police station is concerned.
Yes, Chidanand, ನೀವು ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ.
Synopsis data I have provided.
Hyderabad police station investigation is totally different matters. Hyderabad police. There are 32 FIRs across India matters.
Yes.
This is under 447 different footing.
We'll see.
Sorry, Manoj, sorry. I was held up with some 2 3
ಏನ್ ತೊಂದರೆ ನಾವು ಇಲ್ಲಿ ನಮ್ದು ಔಟ್ ಆಫ್ ಟರ್ನ್ ಕೂತಿರೋದು ಸೊ ತೊಂದರೆ
That's one.
We will adjust to your timing.
One indulgence matters. That railway land acquisition matter reserved for orders. Some work is held up in
21/7 ಅಲ್ಲ 21/7 section 21/7
yes,
notice
21/7 2013 act.
Justice MI Arun ಅವರು
Yes. Because work is getting little.
No problem. So next week.
Operation. I'm not pressurizing matters, only intelligence.
3 months ಆಗಿಲ್ವಲ್ಲ. Next week. Yes.
37.
ಏನಿದು?
Let's, the morning, my lord has heard for some time.
It is sanction.
Regarding the sanction, I gave one judgment of the.
ನಾಳೆ ಹಾಕಿರ್ತೀನಿ. Let me see. I'll post it tomorrow. ನಾಳೆ 2:30. We'll try to pass orders tomorrow.
Interim order.
That will continue. Yes.
Fast over 61.
Sorry, Manoj.
No problems. That's why I told you I am out of turn here. ನೀವೆಲ್ಲ ಕೆಲಸ ಮುಗಿಸ್ಕೊಂಡು ಬನ್ನಿ ಬೇಕಾ?
Please have it another day, Manoj. I've told him. It's been going on from yesterday, today,
No
tomorrow.
problem, sir. We'll take it on 8th, not December. Interim order ಇದೆಯಲ್ಲ? 8 January. So that I'll be here.
Yes. Great.
Yes, no problem. ಅದು rest seal number 61, no?
61.
Interim order stands extended to the next date. It's absolute. It's absolute. Yes. 8 January for the hearing. Yes, ma'am. No problem. Well, first week of January. 9th, IO. Interim order ಇದೆಯಲ್ಲ madam? No interim order. ಅದನ್ನೇ continue ಮಾಡ್ಬಿಡಿ. Yes. Huh?
Some statement, Your Honor.
Jail drama.
ಓ ಚಪಾತಿ ಲಟ್ಟಣಿಗೆ ಹೊಡೆದಿರೋದು. ಸರಿ ಸರಿ ಆಯ್ತು ಆಯ್ತು.
ಈಗ ಆಲ್ಕೋಹಾಲ್ ಮ್ಯಾನುಫ್ಯಾಕ್ಚರರ್ಗೂ ಹೋಗಿದೆ.
ಗೊತ್ತಾಯ್ತು. ಹಾಗಾದ್ರೆ 9th ಬರ್ಲಿ. ಕಂಟಿನ್ಯೂ ದಿ ನೋ ಎಂಟ್ರಿ ಮಾಡಿ. ಎಸ್. ನೋಟಿಸ್ ಆಗಿಲ್ವಾ? ನೋಟಿಸ್ ಆಗಿದೆ ಇವ್ರಿಗೆ. ಎಸ್ ನೆಕ್ಸ್ಟ್ 45.
2018 ಕಂಪ್ಲೇಂಟ್ ಇತ್ತು, 2024 ನಲ್ಲಿ ನೋಟಿಸ್ ಬಂತು. ಸೊ ವಿ ಕೇಮ್ ಅಂಡ್
ಏನು
2008 ನಲ್ಲಿ ಇನ್ನೊಂದು ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ರು.
ಈಗ ಸ್ಟೇ ಮಾಡಿದ್ದೀನಲ್ಲ.
One police woke up into 2024 and issued notice to me.
There is no interim order?
There is an
There
interim
is
order. And my
I
lord has
appear for
also
the
asked-
respondent number 2.
This is my interim order. ಅಂದ್ರೆ ಡೀಟೇಲ್ ಆಗಿದೆ.
2 and 3, respondent number 2 and 3, complainant, the complainant.
For 16 years, why it was not investigated into?
My lords, based on my application, when the order sheet is
Correct.
produced.
Order sheet 6 ನಿಮ್ಮ application ಮೇಲೆ start ಆಯ್ತು, but 16 years what are they doing?
Because what happens, my lord, your lordship may peruse the order sheet of the learned trial court, my lords. Await report anta hogutte. Then notices and it's been issued to the IO to send the report and everything. So despite that, my lords, the IO doesn't comes up before the court giving the status. Thereafter, what happens, my lords, the learned trial court says that post this matter after the final report has been placed before the court. So there, my lords, the next date of hearing won't be reflected. Thereafter, what happened, my lords, I make an endeavor before the learned Chief Judicial Magistrate, my lords, to direct to put up the file.
ಆಯ್ತು, ನೀವು ಮಾಡಿದ್ದೀರಾ. In all this jugglery, what has happened is time has ticked off. 16 ವರ್ಷ ಆಗಿದೆ.
My lords, at the cost of the respondent police, my lords, my complaint is being.
So we will punish the police. No problem.
My lords, what happens, the order sheet only peruses, my lords, await final report antane heltare, my lords. But nevertheless, this notice is.
Jagdish sir, why investigate
Initiated a departmental
against them?
When I take my step, my lords, that let the matter be listed before the trial court, my lord, then the matter is advanced. And later on.
ಏನ್ ಎನ್ಕ್ವೈರಿ ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
Notice has been issued.
ನಿಮಗಲ್ಲ ಸರ್, ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ.
ಕರೆದಿಲ್ಲ.
ನಿಮ್ನ ಯಾಕೆ ಕರೀತಾರೆ? ಅಗೇನ್ಸ್ಟ್ ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ ಡೈರೆಕ್ಟ್ಲಿ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ. ನೀವು ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀರಿ. ಎಸ್. List the matter next week or first week?
First week.
List the matter in the first week. Heard the learned senior counsel Dhananjay Joshi appearing for the petitioner, Swamini for the complainant, and learned additional SPP and Jagdish. The learned additional SPP to place on record as to what has become of the departmental inquiry that is initiated against the investigating officer who kept quiet for investigating officer / yes, who kept quiet for 16 long years and then woke up from deep slumber only when an order was passed at the hands of this court or an application filed by the complainant before the concerned court. The court also has left the matter getting adjourned from time to time, awaiting the report without taking any action against the investigating officers who have just sought to hoodwink the concerned court by not filing the charge, not filing their final report. Therefore, the learned additional SPP shall place on record the action taken against them or the stage at which the departmental inquiry is against them. List on the first week, 8th. Yes. Interim order subsisting will continue to the next date of hearing.
Great.
ಅವ್ರದ್ದು ಮುಗಿಸ್ಬಿಟ್ಟು ಆಮೇಲೆ ನೀವು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ತಗೊಂಡು.
In the meantime, civil suits have taken place.
ಅದೆಲ್ಲ will answer everything on merits. Not a problem. Yes.
Great.
Obviously 16 ವರ್ಷ ಆದ್ರೆ ಎಲ್ಲ ಆಗಿರುತ್ತೆ.
Supreme Court go open that.
ಮತ್ತೆ
Finding of facts also have been established.
Yes. 230 ಮೂಡ್ ಬಂತ ಮೇಡಮ್ ಯಾವ್ದಾರು? 230 ಮೂಡ್ ಇದೆಯಾ? ಅದು ಹೆಂಗದ್ದ?
46 section 47.
ನಿಮ್ಗೆ ಹೇಳಿಲ್ವಾ ಚಂದ್ರಶೇಖರ್? 47 ನೀವಾ? Phoenix Splash.
petitioner,
ಯಾಕೆ ಇಲ್ಲಿದೆ 2013
2013, my lord, this initially, my lord, as per Anishar GH and J.
ಡಿಕ್ಟೇಟಿಂಗ್ ಹಾಕಿದ್ನ ಯಾವತ್ತಾರ
ಇಲ್ಲ ಅಂದ್ರೆ ಹಿಯರ್ ಸ್ವಲ್ಪ ಹಿಯರ್ ಮಾಡಿದ್ರಿ ಸ್ವಾಮಿ ತಾವು, ಆಮೇಲೆ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಹಾಕು.
Let it come before the regular. Post the matter before the bench having roster. Yes.
My lord,
482 other
pressing,
petition na?
ಅಲ್ಲ ಏನು ಅಂತಂದ್ರೆ ಅಲ್ಲ ಇದ್ರಲ್ಲ ನನಗೆ
Like, you're not pressing the petition ಅಂದ್ರೆ ನಾನೇ ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ.
ಅಲಾಟ್ಮೆಂಟ್ ನಾನು ಅಲಾಟ್ಮೆಂಟ್ ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೆ, ಈಗ ಅದ್ಯಾವುದು ನಾನು ಪ್ರೆಸ್ ಮಾಡಲ್ಲ ಬಿಕಾಸ್ ನಾವು
ಪೆಟಿಷನ್ ಯಾಕೆ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ?
ಅಲ್ಲ ಪೆಟಿಷನ್ ಯಾಕೆ ಅಂದ್ರೆ ಮೈ ಲಾರ್ಡ್ ಐ ಆಮ್ ದ ಎಂಟರ್ಪ್ರಿನರ್, ಮೈ ಅಪ್ಲಿಕೇಶನ್ ಸಿಂಗಲ್ ವಿಂಡೋ ಏಜೆನ್ಸಿನಲ್ಲಿ ಅಪ್ರೂವಲ್ ಆಗಿತ್ತು. ನನ್ಗೆ ಏನಾದ್ರು ನನ್ಗೆ ಅಲಾಟ್ ಮಾಡೋದಕ್ಕೆ ಇದು ಅಪ್ಲಿಕೇಶನ್ಗೆ ಇದಾದ್ಮೇಲೆ ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ ನನ್ನ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್
ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಹೇಳ್ಬೇಕಾ?
ಕನ್ಸಿಡರ್ ಮಾಡೋದಕ್ಕೆ
ನಾನೇ ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ.
ಡಿಸ್ಪೋಸ್ ಮಾಡೋದು
ಕರೆಕ್ಟ್. ಅವ್ರು ಕೇಳೋ ಫ್ಲಾಟ್ಸ್ ಆಲ್ರೆಡಿ ಅಲರ್ಟ್ ಆಗಿದೆ ಅಂತ ಅವ್ರು ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅದು ಗೊತ್ತಾಯ್ತು, ಒಂದು ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅವ್ರು ಏನು ಕೊಡ್ತಾರೆ ಈಗ.
As per Annexure GH and J.
The petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner while arguing the matter would now give up the prayer with regard to the allotment that he has sought for, but would restrict his prayer to
prayer number 3, my lord.
To prayer number 3, which be consideration of the representation of the petitioner for suitable allotment as the application of the petitioner had been cleared by the single window agency, and what was waiting was an allotment at the hands of the board. The learned counsel P.V. Chandrasekhar, representing the board, submits that the allotment that the petitioner is seeking have already been allotted to other entrepreneurs. In that light, I deem it appropriate to dispose the subject petition, reserving liberty to the petitioner to submit a representation to the board. Or consider the representation prayer number 3 if the plots are still available today and not allotted to someone else. The board shall consider it in accordance with law and pass necessary orders. In the event the plots that the petitioner seeks in prayer number 3 is already allotted, the petitioner would be at liberty to submit a fresh representation seeking the appropriate allotment, which shall be considered in strict consonance with law. Therefore, said observation, the petition stands disposed.
One request, my lord. ಈಗ ಪ್ರೆಸೆಂಟ್ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಕೇಳ್ತಾರೆ, ಅದನ್ನ ನನ್ಗೇನ್ ಗೊತ್ತಾ, ನನ್ನ ಸೀನಿಯಾರಿಟಿ ಬಿಟ್ಟು ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ. ಆ ರಿಕ್ವೆಸ್ಟ್ ನ ಸ್ವಲ್ಪ ಕನ್ಸೆಷನ್ ಟು ಬಿ ಕನ್ಸಿಡರ್.
ಕನ್ಸೆಷನ್
ಅಂದ್ರೆ ಆ ರೇಟ್ ಅಲ್ಲಿ ಪ್ರಿವೇಲಿಂಗ್
ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ಲಾ ತಾನೆ.
ಪ್ರಿವೇಲಿಂಗ್ ರೇಟ್ ಅಂದ್ರೆ ಇವಾಗ
ನಾವು ಈಗ PM ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಏನ್ ಬರ್ದಿದ್ದೀವಿ,
200 ಕೋಟಿ ಆತರ ಎಲ್ಲ ಕೇಳ್ತಾರೆ. ಅಷ್ಟು ನಮಗ್ ಶಕ್ತಿ ಇಲ್ಲ ಸುಮ್ಮನೆ, ಯಾಕಂದ್ರೆ ನಮ್ದು ಎಕ್ಸ್ಚೇಂಜ್ ಎಕ್ಸ್ಪೆನ್ಷನ್ ಪ್ರಾಜೆಕ್ಟ್ ಅಲ್ಲ. ಆವಾಗಿಂದು ಯಾಕಂದ್ರೆ 2013 ಅಲ್ಲಿ ನಮ್ಗೆ ಅನ್ಯಾಯ ಆಗಿದೆ, ಅದಕ್ಕೋಸ್ಕರ
13 ಅನ್ಯಾಯ ಆಗಿದೆ.
ಅಲ್ಲ 13 ನಲ್ಲಿ ನಮ್ಗೆ ಕೊಡ್ಬೇಕಾದ್ರೆ ಸೀನಿಯರ್ ಮೋಸ್ಟ್ ಅಪ್ಲಿಕೆಂಟ್ ಮೇಲೆ ಬಿಟ್ಬಿಟ್ಟು ಬೇರೆಯವ್ರಿಗೆಲ್ಲ 10 ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಹಾಗಾಗಿ
ಅದು ಕೇಳಿದೀನಿ ನಿಮ್ಮ
ಅಲ್ಲ ಇಫ್ ಬೋರ್ಡ್ ಕನ್ಸಿಡರ್
ನೀವು ಮತ್ತೆ ಹೆಂಗೂ ಬರ್ತೀರಾ ಬನ್ನಿ.
ಅಲ್ಲ ಸಿಂಪಥೆಟಿಕಲಿ ಇಟ್ ಶುಡ್ ಕನ್ಸಿಡರ್.
ಯಾವ ನಿಮ್ ಪ್ರಕಾರ ಏನ್ ಸಿಂಪತಿ?
ಅಲ್ಲ ಅದೊಂದು ಡೇಟ್ ಆಫ್ ಅಲಾಟ್ಮೆಂಟ್ ವಿಚ್ ಮೇಡ್ ಟು ದ ರೆಸ್ಪಾಂಡೆಂಟ್.
ದಟ್ ವಿಲ್ ಬಿ ಅಲೋಯಿಂಗ್ ದಿ ಪೆಟಿಷನ್.
ಅಲ್ಲ ನಮ್ಗೆ ಅವ್ರು ಕೇಳ್ತಾ ಇಲ್ಲ ಸುಮ್ಮನೆ ಬೇರೆದು.
ಆಯ್ತು, ಒಂದು ಸೆಂಟೆನ್ಸ್ ಸಿಂಪತಿ ಹಾಕ್ತೀವಿ. In the event such a representation is made, the board shall sympathetically consider the application of the petitioner, owing to the fact that his application earlier had been cleared by the single window agency. ಅಷ್ಟೇ ಸರ್. ಇನ್ನ ಜಾಸ್ತಿ ಸಿಂಪತಿ ತೋರಿಸಿದ್ರೆ ವಜಾ ಮಾಡಿ.
48 urgent 49.
ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಾರೆ.
ಯಾಕೆ ಅಲ್ಲೇ ಬರ್ಲಿ? ಸ್ಟೇ ಇದೆ ಅಲ್ವಾ?
Stay is there, my lord. So it is till today.
The post the matter before the bench having roster, interim order subsisting will continue till the disposal of the petition.
50.
Circular matter, madam. Delay penalty, my lordship.
Oh, this is RERA.
RERA matter. Delay penalty, lordship has already passed orders, my lord.
Same order.
This is different, my lord. Little bit different, my lord.
Delay penalty ಏನಾಯ್ತು?
ಅದು ತಾವು
allow ಮಾಡಿದೆ.
You can allow it, my lord. But in this case, my lord, we only directed we have issued a circular, my lord, saying that they should follow 41D, 412D, my lord, of the RERA Act, uploading of their documents.
ಅದು follow ಮಾಡಲೇಬೇಕು. I have said so in that also.
Yes, my lord. So that is the only thing we have told in our circular, my lord.
If that is the only thing, they cannot.
Yes, my lord.
They cannot complain of that.
Yes, my lord. And based on that provision, we have imposed a penalty, my lord, that as per section 60.
4-1D documents ಕೊಟ್ಟಿಲ್ಲ ಅಂತ delay penalty.
Penalty by passing separate order, my lord, under section 60 only. That provision itself provides for that.
Let them come there. Yes. Heard the learned counsel Gautam Dev Ullal appearing for the petitioner, awaiting the appearance of the counsel for the petitioner. List the matter on 8th January.
Okay. 51.
For the petitioner. The petition where I sought reinvestigation, where is
CBI further
reinvestigation.
for reinvestigation. Choice is not yours. CID. ಇಲ್ಲ ಅಂದ್ರೆ ಕೇಳಿ ಏನ್ ಕೇಳಿದೀರಾ ಅಂತ ಕೇಳಿದೆ.
Reinvestigation wherein the very complainant was made an accused.
ಕೊಡಿ.
I filed a synopsis.
Yes, Jagdish sir. ಕೇಳಿದೀನಿ last time.
Well, correct, but there is nothing in this case.
This is that father and son ಇದ.
Mother and son.
Mother and son. Close ಆಗಿದೆಯಲ್ಲ ಅವಾಗಲೇ.
Close ಆಗಿದೆ. The accused who were initially in custody have been dropped and the complainant itself was made an accused. At the instance of one police officer who was none other than brother of the
we'll see.
accused
Him,
number 3.
he drunk and confesses how he committed the crime. That was recorded.
Drunk and confessed that police confess video record ಮಾಡಿದ್ರು ಅಂತಾನೂ ಇದೆ. A3 is brother and he is the one who gave the fresh complaint, arraying the complainant as accused.
Synopsis there.
Synopsis is
And
there.
I've heard you also. Inda ಇದೆ Jagdish.
Close case, my lord, unnecessary of.
No, not all cases will permit.
No, but this case, my lord, is clearly.
Yes. Are reserved. Yes.
52.
ಯಾಕಿದು ಅಲ್ಲೇ ಬರ್ಲಿ. ಅದೇ ಇದು dates 5 years, 7 years, 9 years ಅದೇ ತಾನೆ.
ಅದು ಸಿನಾಪ್ಸಿಸ್
ಅದೇ OS 10 ಅಲ್ವಾ?
OS ನಂಬರ್ ಹೌದು 10 ಕರೆಕ್ಟ್
10 of 2014. Yes.
ಸಿನಾಪ್ಸಿಸ್ ಕೊಟ್ಟು ಲಾಸ್ಟ್
Synopsis ಇದೆಯಾ?
My lordship, I request short accommodation.
ನೋಡಿ. Yes. Let it come before the regular court. Release the matter instead as being partnered. Post the matter before the bench having roster. Interim order subsisting would continue till the disposal of the petition. Yes.
53 urgent, 54.
ಏನ್ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಏನಾಯ್ತು?
ಅಲ್ಲ, insofar as
ಅದೇ ಅಲ್ವಾ
petitioners.
ಇದು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಸನ್.
Please, my lords, I pray for short accommodation, my lords.
ಅಲ್ಲ, ಮ್ಯಾಟರ್ ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಹೌದು ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಅವಾಗಿಂದ ಹೇಳ್ತಿರೋದೇ ಅದೇ ನೀವು.
ಅಲ್ಲ, ಇಲ್ಲಿ ಪಿಟಿಷನರ್ಸ್ ಯಾರಿದ್ದಾರೆ ಅವ್ರ ಮಧ್ಯೆ ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ರಿಮೈನಿಂಗ್ ಅಕ್ಯೂಸಸ್ ಇದ್ದಾರೆ, ಅವ್ರ ಮೇಲೆ ನಾನು ಎಫ್ಐಆರ್ ನ ಕ್ವಾಶ್ ಮಾಡೋದು ಬೇಡ ಅಂತ ನನ್ನ ರಿಕ್ವೆಸ್ಟ್.
ಆಯ್ತು, ಯಾರ ಮೇಲೆ ಯಾರು ಸೆಟ್ಲ್ ಆಗಿದೆ ಅವ್ರ ಮಿಕ್ಕದವ್ರು ನಡೀಲಿ.
My lords, I'll get instructions.
This instruction you should have got. Anyway, we'll take it in the first week.
Much
Yes.
obliged.
Same. Interim order subsisting will continue to the next date.
Great.
Yes, next. First week. 9 8 ಏನು 482 ಎಲ್ಲ ಯಾವತ್ತು ಬೇಕಾದ್ರೆ ಹಾಕಿ.
55 urgent, 56.
Plus the FIRs of the year 1980, my lords.
ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ.
Please, my lords, all the other co-accused have been acquitted, my lords. In the year, way back in the year 1993.
Yes, Jagdish sir. Dates ಹೇಳಿ ಮೇಡಮ್ ಸರ್.
Please, please. That's 1968, my lords, I have been joined in the petitioner's bank as a clerk. That's 1976, my lords, I was transferred from one branch to another branch as a junior officer. That's 1977, my lords, I was transferred from one branch to another branch of the same bank. That's 1977, my lords, one certificate was issued by the accused number 1. My lords, saying that, my lords, all the jewels pledged for the loan are intact as per the description of the agreement. Plus 1978, my lords, I left the petitioner bank, my lords, and moved to Bangalore. And later, my lords, I was moved to Gulf. It was not here. Plus 1980, my lords, respondent number 2 bank lodged a complaint before the respondent number 1 police. Plus 1980, my lords, on 15/4/1980, my lords,
Complainant ga 1980
ತಗೊಂಡಿದ್ದು.
ಹೋಗಿ ಬಂದಾಗಿದೆ.
ಆಗಿದೆ.
Await service.
ಅವೈಟ್ ಸರ್ವಿಸ್ ಬಂದ್ಬೇಡಿ.
Let's,
ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಮೇಡಮ್. ನೀವು ಎಲ್ಲಿದ್ದೀರಾ ಈಗ?
my instructions are that he's abroad.
ಅದೇ he is in Gulf.
He's
ಆಯ್ತು, ನೋ ಪ್ರಾಬ್ಲಮ್. The heard the learned counsel appearing for the petitioner post immediately after service of notice upon the respondent or 9th January, whichever is earlier. Interim order subsisting will continue till the next date of hearing.
hand someone to respond.
ತಗೊಂತೀರಾ? ಗಲ್ಫ್ ಅಲ್ಲಿ ಇದ್ದಾನೆ ಅಂದ್ರೆ
Mangalore,
Bank is in
responding about bank.
complainant. Apart from the without awaiting the service of notice, the petitioner is also at liberty to serve the complainant by way of hand summons. Same day.
Removal.
Same. Exactly. Continue. Cata. Black magic. Good.
Bank classes.
57.
Idರಲ್ಲಿ
Petitioner is the
party
complainant, my lords. Petitioner is the complainant, my lords.
ಅಲ್ಲ, ಇದು ನಿಮ್ದ್ರಲ್ಲಿ ಯಾವ್ದು ಕಂಪ್ಲೇನೆಂಟ್?
My lords, 498 my lords. ನಾನು ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ CC ಆಗಿದೆ my lords.
ಅದಾಯ್ತು, ಕಂಪ್ಲೇನೆಂಟ್ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ, ಅಕ್ಯೂಸ್ ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ my lords.
ಯು ಆರ್ ದಿ ಕಂಪ್ಲೇನೆಂಟ್?
Yes my lords. I am the wife my lords.
ಓ, ಕಾರಣ?
My lords, there are two lockers my lords in the charge sheet. During the investigation, the IO seizes two bank lockers my lord.
ಬ್ಲಾಕ್ ಮ್ಯಾಜಿಕ್ ಅಲ್ಲಿ ಓಪನ್ ಆಗ್ಲಿಲ್ವಾ?
ಇಲ್ಲ my lords, because I had not sought for prayer in that black magic.
Yes sir.
Thereafter, what happens is the IO files charge sheet, my lords. What he was supposed to be doing is the bank lockers was seized, 102 was complied. He should have asked the magistrate permission, see what is there in the locker, make an inventory. Rather, he does not do that thing and he directly files the charge sheet. And even magistrate takes cognizance, my lord. Without opening, there is an allegation that 3 and 4 of DP Act is there, my lords. My entire gold worth rupees 1.5 crore rupees jewelry is there, my lords. Black magic.
ಅಷ್ಟೇ.
And my lords, thereafter,
ಮಾಯಾ.
yes, my lord. Thereafter, annexure A45, page 45, my lords, I have made requisition to IO. I have made requisition to public APP, assistant public prosecutor. My lord, nobody is filing 173.
Nobody is ready to believe your back.
My lord, and because of that, I am before your lordships, my lord. For means.
So you want me to believe?
No, my lord, 100% is there, my lord, because accused has several times tried to break open. He has tried to file 451 application after your lordship has stayed the matter, my lord. Annexure A is page 45.
ಏನು ಈಗ ಲಾಕರ್ ಏನು ಇಲ್ವಲ್ಲ?
ಎಲ್ಲ ಇದೆ, ಅಲ್ಲೇ ಇದೆ,
ಅಲ್ಲೇ ಇದೆಯಾ?
ಎಲ್ಲ ಅಲ್ಲೇ. He has several times tried.
ಬ್ಲಾಕ್ ಮ್ಯಾಜಿಕ್ ಅಲ್ಲಿ ಗೊತ್ತಾಗಿದೆ ಅಲ್ಲಿ.
ಗೊತ್ತಾಗಿದೆ ಅದೇ.
Yes,
ಕರೆಕ್ಟ್ ಆಗಿ ಹಾಕಿ ನೋಡಿದ್ರ ಎಲ್ಲಿದೆ ಎಲ್ಲ ಅಂತ.
Yes,
ಅಲ್ಲೇ ಲಾಕರ್ಲೇ ಇದೆ ಎಲ್ಲ.
Yes, my lord. In so far as further investigation concerned, my lord, the charge sheet ಅವರೇ ಮಾಡಿದ್ದಾರೆ IO. 102 is complied. So they ಅವ್ರು ಓಪನ್ ಮಾಡಿ ಇನ್ವೆಂಟರಿ ಮಾಡಿ ಕೊಡ್ಬೇಕಿತ್ತು, my lord. Log books also they should have done.
ನಾಳೆ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ತೀನಿ.
Obligation.
ಮಧ್ಯಾಹ್ನ 2:30.
Yes, my lord, it is within charge ಆಗಿಲ್ಲ, my lord. Vinu by paragraph number 42.
ಆಯ್ತಾಯ್ತು.
Obligation.
ನಾಳೆ.
Obligation.
58.
ಬಂತಾ ಇದು? 2:30 ಮೂರು ತಗೊಂಡ್ಬಿಡಿ. ಅಲ್ಲ ಒಂದು ನಿಮಿಷ, ಇದು 58 ಮುಗಿದೋಗ್ಬಿಡ್ಲಿ. ಎಸ್ ಮೇಡಮ್, ಏನಾಗಿಲ್ವ ಇದಿನ್ನು? ಇನ್ನು ಫೈಲ್ ಹುಡುಕ್ತಾ ಇದ್ದೀರಾ? ಲಾಸ್ಟ್ ಟೈಮ್ ಏನು ಹುಡುಕ್ತಾ ಇದ್ದೀನಿ ಅಂತ VC ಹೇಳಿದ್ರಲ್ಲ.
ಆ ಫೈಲ್ ಇನ್ನ ಸಿಕ್ಕಿಲ್ಲ.
ಅವ್ರು ಕೇಳ್ತೀರಾ ಜಾಗ ಕೊಡಿ ಅಂತ, ಜಾಗ ಹುಡ್ಕೋ ಬದಲು ನೀವು ಫೈಲ್ ಹುಡುಕ್ತಾ ಇದ್ದೀರಲ್ಲ.
ಜಾಗನ ಹುಡುಕ್ಸಿದ್ರು my lord. My client was called, my lord, and survey was done.
ಸರ್ವೆ ವಾಸ್
ಆಗಿದೆಯಾ?
ಅದು ಮಾಡಿಸಿದಿರಿ. ಅದಕ್ಕೋಸ್ಕರ I want some
ಕೊಡೋದು ಒಂದೇ ಬಾಕಿ.
ಅದು we'll have to look into that, my lord. That's because we were not in
7 in the, my lord, they please my lord, put them on
I
terms,
do
my lord.
understand.
At least they will
There is some-
No, don't, madam, you are getting a windfall if you get it.
only
My lord, my
this one is, my
property-
lord. Kindly see the RDs. I don't know how these RDs have come into force. I mean,
RD?
it is relinquishment deed ಅಲ್ಲಿ 53,000 square foot of areas for road widening ಗೆ ಅಂತ RD
3,000 ಸ್ಕ್ವೇರ್ ಫೀಟ್.
53,000 square foot.
ಯಾಕೆ ತಗೊಂಡ್ರಿ?
ನನಗೆ ಅದನ್ನೇ ಫೈಂಡ್ ಔಟ್ ಮಾಡ್ತಾ ಇದೀವಿ. I don't know how it is.
ರೋಡ್ ವೈಡಿಂಗ್ 53,000 ಸ್ಕ್ವೇರ್ ಫೀಟ್
ಬೇಕಾಗಿಲ್ಲ. ನಾನು ಅದನ್ನೇ ಯೋಚನೆ ಮಾಡ್ತಾರೆ. ಅದಕ್ಕೆ ಆ ಫೈಲ್ ಹುಡುಕಿಸ್ತಾ ಇದೀವಿ. ಫೈಲ್ ಸಿಗ್ತಾ ಇಲ್ಲ. This is the problem now for me. My lord, 53,000 square foot of area, my lord. That is almost 1.5 acres of land.
ಫಾರ್ ರೋಡ್ ವೈಡ್ನಿಂಗ್ ಹೊಸಕೇರಳ್ಳಿಗೆ
ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸಿಗೆ ಹಂಗೆ ಬಂದ್ಬಿಡ್ತಾರೆ ಕಮಿಷನರ್ ಬಂದು ಅಲ್ಲಿ ತಗೊಂಡು
ಕಮಿಷನರ್ ಅದೇ ಬಂದಿರೋ ಪ್ರಾಬ್ಲಮ್. ಅದಕ್ಕೆ ನಾನು ಇವಾಗ ಹುಡುಕಿಸ್ತಾ ಇದ್ದೀನಿ ಫೈಲ್ ಸಿಗ್ತಾ ಇಲ್ಲ. ದಿಸ್ ಇಸ್ ದ ಪ್ರಾಬ್ಲಮ್ ಫಾರ್ ವಿಚ್ ಮಿಲಾಟ್. ಅದಕ್ಕೆ ಇವಾಗ ಸರ್ವೆ ಮಾಡಿಸಿದೀನಿ. ವಿ ಆರ್ ನಾಟ್ ಇನ್ ಎ ಪೊಸಿಷನ್ ಟು ಐಡೆಂಟಿಫೈ ದ ಲ್ಯಾಂಡ್ ಬಿಕಾಸ್ now milord what has happened is this land there are 3 to 4 owners insofar as this land is concerned. Where this lady's land is available we don't know. ಅದಕ್ಕೆ ನಾವು ಈಗ ಸರ್ವೆ ಮಾಡೋದಕ್ಕೆ ಅವರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟು ಕರ್ಸಿದೀವಿ.
ಸರ್ವೆ ಮಾಡಿಸಿದೀರಾ ಮತ್ತೆ ಯಾವ ಲ್ಯಾಂಡ್ ತಗೊಂಡ್ರಿ ನೀವು?
ಅಲ್ಲ ಅದೇ ನನಗೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. ಯಾವ ತಗೊಂಡ್ ಫೈಲ್ ಸಿಗ್ತಾ ಇಲ್ಲ, ಯಾವ ಲ್ಯಾಂಡ್ ಅಂತ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. This is the problem now what we are facing.
PWD department ಗೆ they wrote a letter milord.
ನಾನು ಅದೇ ಯೋಚನೆ ಪೆರಿಫೆರಲ್ ರೋಡ್ ಮಾಡ್ತಾ ಇದಾರ, ರಿಂಗ್ ರೋಡ್ ಮಾಡಿದ್ರ, ಇದು 53,000 ಚದರಡಿಗೆ ಅಂತ
ರೋಡ್ ಮಾಡಿದ್ರೆ
ಅದು ಅದಕ್ಕೂ ಬೇಕು. ನಾನು ಅದನ್ನ ಯೋಚನೆ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಫೈಲ್ ಸಿಕ್ಕಿದ್ರೆ ನಮಗೆ ಗೊತ್ತಾಗುತ್ತೆ. It is not attached to nice road. No. It is not. It is not attached to nice road, sir. Sorry. It is.
ನಿಮಗೆ ಆತರ ಡೌಟ್ ಇದ್ರೆ ಎಲ್ಲಿದೆ ಅಂತ ಅವ್ರಿಗೆ ಕೇಳಿ. ಬ್ಲಾಕ್ ಮ್ಯಾಜಿಕ್ ಅಲ್ಲಿ
ಬ್ಲಾಕ್ ಮ್ಯಾಜಿಕ್ ಗೆ ಅದೇ ತರ ಕೇಳಿಸ್ಕೊಳ್ತಾ ಇದ್ದೆ ಈಗ.
ಅದಕ್ಕೆ ಎಲ್ಲ ಐಡೆಂಟಿಫೈ ನಿಮ್ಗೆ ತೊಂದ್ರೆ ಇದ್ರೆ ಅವ್ರಿಗೆ ಕೇಳಿ. ಅವ್ರ ಕ್ಲೈಂಟ್ ಗೆ ಅವರೆಲ್ಲ ನಿಮಗೆ ಬ್ಲಾಕ್ ಮ್ಯಾಜಿಕ್ ಅಲ್ಲೆಲ್ಲ ಹೇಳ್ತಾರೆ. ಈ ರೋಡ್ ಈ ತರ ಇದೆ.
It has been escalated now, Lord. It has been brought to the notice of Chief Commissioner. ಅಲ್ಲ sketch ಅಲ್ಲೂ ಇಲ್ಲ ಅದಷ್ಟು.
ಸತ್ಯಾನಂದ್ ಅವರೇ,
I do concede, my lord.
Relinquishment deed ತಗೊಂಡು.
Yes.
And I relinquishment deed is not in thin air.
I know.
Relinquishment deed is a registered deed.
Yes.
Registered at the signature of the Commissioner of the Corporation or delegate.
Concerned official has signed.
Delegate of the Commissioner of the Corporation. Yes. How can you wriggle out of it saying that
Lord, I am not wriggling. Lord, I am not wriggling.
Compensation ಕೊಡಲ್ಲ.
ಇಲ್ಲ ನಾನು ಅದನ್ನ ಹೇಳ್ತಾ ಇಲ್ಲ ನಾನು. I am only, my lord, making my efforts, my lord, to find out my file first. What is that what they have acquired, to find out, my lord, that itself is becoming very difficult for me.
There must be something more than what meets the eye here.
I less said the better ಅಂತ ನಾನು ಅದನ್ನ ಏನು ಹೇಳಕ್ ಹೋಗಲ್ಲ. ನಾನು ಏನ್ ಹೇಳಿದ್ರು ಇಲ್ಲಿ ಸರಿ ಹೋಗಲ್ಲ ಇಲ್ಲಿ. ಅದಕ್ಕೋಸ್ಕರ now it has been escalated. We have brought to the notice of Chief Commissioner of GBA also. My lord, he has taken up the matter. My lord, we want some time, my lord. Once we are in a position, my lord, to find out the entire thing, I will place all the papers on record, my lord, before your lordships by filing my objection statement.
ಇನ್ನು ಹಾಕಿಲ್ವಾ? ಇನ್ನು ಫೈಲ್ ಹುಡುಕ್ತಾ ಇದ್ದೀರಾ?
ನಾನು ಅದನ್ನೇ ತಮಗೆ ಹೇಳ್ತಾ ಇರೋದು. ಇದೇ ಪ್ರಾಬ್ಲಮ್ ಬಂತಿರೋದು ನನ್ಗೀಗ. ನನಗೆ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಮಾಡ್ಲಿಲ್ಲ. ಈಗ ಅದಕ್ಕೆ ಸರ್ವೆ ಮಾಡಿಸಿದ್ದಾರೆ. ಸರ್ವೆ ಮಾಡಿಸಿದ್ದಾರೆ ಅಂತ
ಮಾಡಿಸಿದ್ದಾರೆ. ಅದೆಲ್ಲ ಡೆವಲಪ್ಮೆಂಟ್ ಎಲ್ಲ ಆಗಿ they were not able to, because this lady is a widow, my lord. Her husband, he was the owner.
She is also not in a position to identify her own land ಅಂತ I was given to understand.
ಅಲ್ಲಿ ಇರಬೇಕಲ್ಲ, ನಿಮಗೆ ಕೊಟ್ಟು 13 ವರ್ಷ ಆಯ್ತು.
ಇಲ್ಲ
ಈಗ ಲ್ಯಾಂಡ್ ಎಲ್ಲಿದೆ ಕೊಟ್ಟರೆ ಕೊಡಕ್ಕೆ?
ಅಲ್ಲ ಲ್ಯಾಂಡ್,
her own land ಅಂದ್ರೆ
my lord, instructions, my lord, is
you have taken relinquishment deed.
ಅದು ಕರೆಕ್ಟ್. Merely because, my lord, a relinquishment deed to
merely because ಅಲ್ಲ
53,000 square foot of area.
Only because.
ಅಲ್ಲ, I agree with that, my lord. That document is there on record. My lord, some action will be taken by us, my lord, in this regard. We have been doing it. We have been working on it.
Action ತಗೊಳ್ಳಿ. TDR ಕೊಟ್ಬಿಡಬೇಕು.
ನಾನು ಅದನ್ನೇ ವರ್ಕೌಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Kindly appreciate, my lord. This is the difficulty what we are facing now. Lord, this has been escalated also.
Simple. If you have taken relinquishment deed or whatever, why did you take that? It is different thing. Relinquishment deeds are there.
I do concede that.
You have to give it. 53,000 square feet ತಗೊಂಡಿದ್ದೀರಾ?
ನನಗೆ ಅದೇ that itself is a doubtful, my lord. For road widening purpose, 53,000 square foot of area. I don't know. That is one relinquishment deed. Another relinquishment deed talks of 5,000 and odd square meters. 2 relinquishment deeds are available.
ಅಲ್ಲಿಗೆ ಬಂತ ಅದನ್ನು.
ಅದು ಅಷ್ಟಕ್ಕೆ ಬರ್ತಾ ಇದೆ. ನಾನು ಅದನ್ನೇ ಯೋಚನೆ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. How is it that for road widening, my lord, adjacent lands are being acquired like this? There is something, my lord, which I can't now, my lord, say anything without records.
Why should they suffer? They have lost their land.
I do concede that. That is where, my lord, something, my lord, it is all, my lord, which the power of attorney holder of the
whoever it is, sir. Land is lost.
I only say this much.
Land is lost.
I don't know whether they have lost the land or not.
Why will they come here?
My lord, I don't know whether they have lost. Without records, my lord, I can't say anything.
To BBMP do submission alla idu.
My lord, there, one ನಿಮಿಷ madam. In the RD, possession is also handed over anta illa alli. RD ಯಲ್ಲೂ ಇಲ್ಲ ಅಲ್ಲಿ. That is in the relinquishment.
ಯಾಕೆ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಂಡ್ರಿ ಸರ್ ಹೋಗಿ ಅದಕ್ಕೆ?
Possession is handed over ಅಂತ ಇಲ್ಲ. That is what I find.
Relinquishment deed ಏನು ತಗೊಂಡ್ರಿ ಮತ್ತೆ?
I don't know the reason, my
You
lord.
don't know, you don't know.
Adikoskara we are.
ಅದಕ್ಕೆ you don't know, your officers will know it.
My lord, those officers who took it, my lord, on that date, they are not available now with us.
Get them.
That is where, my lord,
Get
now that is being done by
Nothing.
us. Kindly grant us some time.
These official delays and covering up things we will not accept.
No, I am at your lordship's mercy, my lord, but whatever happens, my lord, this is what is being done there. Now they are they have got it surveyed. My lord, we are precipitating the matters.
Precipitating.
We are precipitating the matters, my lord, to go ahead with the entire thing. Kindly grant us some time. It takes some time because even now, my lord, 13 years.
Wrong word use ಮಾಡಿ ಪರವಾಗಿಲ್ಲ.
ಅಂದ್ರೆ ಏನು ಅಂತ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ ಅದಕ್ಕೆ ಅವ್ರು
ಆಯ್ತು ರಾಂಗ್ ವರ್ಡ್ ಆಯ್ತು ಬಿಡಿ, ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಒಂದ್ಸತಿ ಬಂದ್ಬಿಡುತ್ತೆ, ಆ ಕಡೆ ಇರ್ತೀವಲ್ಲ, ಲೆಟ್ ದೆಮ್ ನಾಟ್ ಪ್ರೆಸಿಪಿಟೇಟ್ ಪ್ರೆಸಿಪಿಟೇಟ್ ಅಂತ ಆ ಕಡೆ ಹೇಳಿರ್ತೀವಿ, ಈ ಕಡೆ ಬಂದ್ಬಿಟ್ಟು ಅದು ಮರ್ತೋಗ್ಬಿಡ್ತೀವಿ ವರ್ಡ್ಸ್ ಅದು.
5 ಗಂಟೆ ಆಯ್ತಲ್ಲ
ಅಲ್ಲಿ, ಯಾಕಂದ್ರೆ ಅಲ್ಲೊಂದ್ 10 ಕಂಟೆಂಟ್ ಮ್ಯಾಟರ್ ಮುಗಿಸ್ಕೊಂಡ್ ಬಂದೆ, ಅಲ್ಲೂ ಹಂಗೆ ಆಯ್ತು. ಅದೆಲ್ಲ ಸ್ವಲ್ಪ ಇರುತ್ತೆ ತಲೆಯಲ್ಲಿ.
ಕಾರ್ನರ್ ಕೋರ್ಟ್ ಅಲ್ಲ. Yes.
Kindly grant us some time.
Heard the learned counsel Srimati H.R. Renuka appearing to the petitioner and counsel B.S. Satyanand. This court from time to time has passed slew of orders directing the respondent BBMP to file its statement of objections. Even then, the statement of objections have not come about. Learned counsel B.S. Satyanand projects a strange circumstance which prima facie is unacceptable. The circumstance projected is that the petitioner's property worth
ಅದು ಬೇಡ ಅಂತ ಹೇಳ್ತಾರೆ. It is only, my lord, I brought it to your lordship's notice that this is the difficulty what we are facing.
Learned counsel submits that there is some difficulty with the filing of statement of objections with the loss of files.
Please.
The files are being traced and objections would be filed positively by the next date of hearing. List the matter on 5th January finally.
Please.
In the event statement of objections are not filed by the said date, this court will be constrained to answer the prayer of the petitioner, leaving it with no choice.
Please.
Interim order subsisting will continue to.
interim order
ಏನಿಲ್ವಾ?
There is no interim.
ಅದೇ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
Please. Much obliged. Grateful to you.
Yes. ಹೌದಾ? ಕೊಡಿ. ಸ್ಟೇ ಆಗಿತ್ತಲ್ಲ?
No, my lord, stay agila, my lord. First day itself, that case was confirmed.
ಸ್ಟೇ ಆಗಿತ್ತು ಫಸ್ಟ್.
ಇಲ್ಲ my lords. First day itself ಇದಾಗಿದೆ.
This is ಬೇರೆಯವರದೆಲ್ಲ ಕ್ವಾಶ್ ಮಾಡಿ, ಹಸ್ಬೆಂಡ್ ಮಾತ್ರ ಕ್ವಾಶ್ ಮಾಡಿಲ್ಲ, ಅದೇ ತಾನೇ?
Yes, my lords. Supreme Court has
that.
My lords, yes, my lords.
Yes. Thank you.
59.
Lakshmi.
For the petition. The trial court, my lord, has insisted.
Oh, this matter. Tomorrow we'll pass orders tomorrow. ಇದು ಅಲೋ ಮಾಡಿದ್ದೆ ಅಲ್ವಾ?
ಅಲೋ ಮಾಡಕ ರಿಸರ್ವ್ ಫಾರ್ ಆರ್ಡರ್ಸ್ ಅಂತ ಇತ್ತು.
ಕೊಡಿ. ಅದೇನ್ ಕೊಡ್ಬೇಕು?
ಸೈಟೇಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
ವಿಲ್ ಪ್ರೊಬೇಷನ್ ತಾನೇ?
ಪ್ರೊಬೇಟ್ ಪಿಟಿಷನ್.
ಎರಡು ಅದೇ.
Tomorrow
2:30.
2:30 more. That come.
What extension, Angad?
Yes. In para 4 to 8, the reasons are stated, no? Also may extend it by 8 weeks. 4 to 8.
The subject petition was disposed by an order dated 24th September 2025, directing the concerned court to dispose the petition within an outer limit of
8 weeks.
8 weeks from the date of receipt of the copy of the order. 8 weeks are long gone. The petitioner has now preferred an application seeking extension of time. The reasons rendered in the application, para
4 to 8.
Para 4 to 8 are as follows. In that light, I deem it appropriate to, and that light and in the interest of justice, I deem it appropriate to extend the time for conclusion as was directed by another period of 8 weeks from today.
Lord, instead of 4 to 8, 4 to 9, your lordship.
4 to 9. Yes. Ordered accordingly.
Yes, so good.
Yes. ಯಾವ್ದು ಮೇಡಮ್? ಹೋಯ್ತಾ? ಪಾಸ್ವರ್ಡ್ ಯಾವುದಿಲ್ವಾ?
Submission, if my lords may permit.
Yes, sir.
Serial number 47, my lords, I could not appear.
40.
For 47, my lords.
1 minute.
The matter came to be disposed of.
Disposed.
I wanted to make my arguments.
Dispose
My lords, I was on my legs, my lords, I could not.
Nothing, you're for the KDB, is it?
Please, my lord. My lords,
Chandrasekhar appeared for
appear for
KDB?
the private company. my lords.
We have no harm. I only said the applications that are already processed need not be reopened or considered. Permitted him to give a representation, let them consider it. ಅಷ್ಟೇ. ನಿಮ್ಮ absence ತೋರಿಸಿದ್ದೀನಾ ಇಲ್ಲ? You want me to tell that you vehemently argue? We'll do that, not a problem. No, if there is any problem in the order, I'll release it tomorrow or day after.
Please.
You move the matter, if there's any prejudice caused to you, we'll revive it. Because it is his
My
petition,
lords
sir.
have the matter tomorrow, I'll my.
No, it is his petition. He has said only consider representation.
Submitted that is already, sir.
He said that it's already allotted, I will not disturb the allotments. He said, permit me to give a representation. ಅವ್ರು ಕೊಡ್ಲೇಬಾರ್ದು ಅವ್ರಿಗೆ ಮತ್ತೆ
My apologies.
No.